All right, we are now live streaming. So Mr. Brickman, hello, Mr. Brickman.
Good morning.
He's connected. So in the way he did, you should be able to, Mr. Sterling, whatever link we sent should empower you to get in.
Can you get in the link?
I'm trying right now.
Okay.
Okay. Looks like I'm in here.
Yep, you're in. So if you want to practice sharing screen, you can do that now since we have no jurors. We're sort of stuck at ease till we get all our jurors.
I think I got it, Your Honor. Thank you.
Okay. Just make sure you got to mute your machine. There you go. And who is CCCAM?
That's me.
That's you. Great.
They don't allow us in earlier than 8:30 if they're non-employee of the court. So I'm afraid that I'm not going to be rolling with the exhibits. Can I just ask your permission to talk to him about the exhibits? I don't know if we're supposed to screen share or is it supposed to be separate? I don't know how to do that via Zoom. I tried to get here early enough to ask, but you have to be an employee I was standing outside since 7:30.
No, that's all right. Hold on one second. We have everyone? Look at that. Okay. I'm not understanding your question. You can screen share from if you're CCCAM, you should be able to screen share. Just
Okay,
practice.
just screen share and just do it that way. I thought there was a way you want one at a time. So they don't see the whole screen at one time. That's kind of distracting.
So what I was describing is that, let's say you're the first witness. Mr. Sterling ought to have up at the witness stand there, all the exhibits you're going to use, the hard copies, because that's what gets admitted. Nothing should be shared until an exhibit is admitted.
Okay.
So when plaintiff's one is admitted, then Mr. Sterling would say, hey, can we put one up on the screen? And then he'll help you navigate because he'll say, go to page 6. We want to see paragraph 9.
Okay.
And your role will be getting us to page 6, paragraph 9, without making us seasick looking at the screen. But as long as you share screen, you put up whatever has been admitted into evidence. If exhibit 2 is not into evidence, no one should be looking at that on the screen. You might be, but you shouldn't be sharing that yet.
Got it.
Does that answer?
It does.
I want to make sure I'm being helpful.
Yeah, thank you so much.
You're welcome.
What we do is I have him. I have them.
I just don't know if this is what I'm talking about. Look, see, you can see, for example, this is a big release. When I screen share it, right, it doesn't give me the opportunity to no longer exist.
But you're saying you can't move it
I
on.
don't know. I tried to do it last night and it wasn't allowing me to, but maybe because the meeting wasn't. Perfect. So my only question is just your copy. Because it was so small, I had to blow it up.
Got
So it's not in order, it's just so big. I have. Then you have these. You might want me to put those in, right? No, I have it
you.
already.
Yeah, if you got one here, I just need to admit it.
All right, why don't we get started? Mr. Sterling, any reason I can't bring the jury in?
No, Your Honor.
Mr. Williams?
No, Your Honor.
All right, let's bring the jurors in, please. I've asked someone to come out and sign in, so they'll sneak out and You better see what's going on.
Your Honor, can he not have his PowerPoint up until you've given instructions?
Yeah. It's not.
Well, if,
Oh, okay. It's not now.
thank you, Your Honor.
Sure. Someone else granted your request.
Okay.
Yeah, I'll be talking for a little bit before.
Just started it till you go, so I'm in the right place.
Yeah. Are you related at all to Jeffrey Brickman?
I am,
In what unfortunate way?
son.
Don't tell him I say hi. We stand for you. Don't get used to it, but it's what happens in here. It's like, wait, I could have sworn we had. Should have one more. There we go. Excellent. Thank you, Deputy Gordon. You all can be seated. Happy Tuesday morning, ladies and gentlemen. Happy Tuesday morning, Judge. Yeah, good to see you. Welcome, our actual jurors. I appreciate most of you being on time. I think we had a couple folks who are still navigating how the shuttle works, et cetera. An important rule is that we can do nothing with the case unless we have all 13 of you. So I'm going to rely on you to police each other and encourage each other to be on time from breaks and lunch and in the morning, et cetera. First morning, everyone is understanding that you're learning the routine, and you really only have one other morning, tomorrow morning, if we stick to our schedule, that you'll need to be here. But by then you'll be a well-oiled machine. I want to give you some basic operating instructions. Then I need to administer to you all a different oath, the jury oath, that will make you officially jurors. Then I have to give you some instructions on the law, not too much up front, but just to give you a basic understanding of how civil trials work. Then I will verbally get out of the way, and we'll start with the lawyer's opening statements and the presentation of the evidence. What I need you to do at any time you cannot see or hear what's going on, or you just need a break because we've been going on too long, is to tell me that. There is no replay button here. You will not get transcripts of witness testimony during your deliberations. So if at any time it's hard to see something, hard to hear someone, I'll try to make it more visible, get people to speak up. But other than saying, I'm sorry, could you repeat that answer? There's not a, could that witness come back and say all the things she said before? That doesn't happen. It's a one-time situation. So we will break usually once in the mid-morning, definitely for lunch, once in the mid-afternoon. If you need more breaks than that, that's okay. But you need to let me know. I can't read your minds. Other than if I see you nodding off, then I get Deputy Gordon to hand you a mint or gently redirect your energies towards being awake. While we're in trial, it's not appropriate for you all to interact with the lawyers or any of the parties outside the courtroom. And so you may be moving through the hallway to go to lunch or whatnot, and wait, I can't remember where the bathroom is, and you want to ask Mr. Sterling or Mr. Williams, they're going to treat you like you've got the plague, not because you've got the plague, but it's just not appropriate. Even if it's a nicety of, hey, you know what, the better bathrooms are this way down the hallway. The other lawyer sees that, like, wait a minute, this lawyer was talking to the jurors and he doesn't know if the lawyer was saying, hey, I hope things are going well for my client. What do you think about that? It's not an appropriate interaction. So don't take it the wrong way. If anyone out here associated with the case gives you wide berth, I've instructed them to do that. They need to do that. Once the case is over, if you all want to have a conversation, that's okay. We will run from 9-ish, 9:20-ish to about 5 each day. I don't think we'll need to go that late tomorrow. We'll see what's going on with the case. But there's not a whistle that goes off at 5 and like Fred Flintstone, you slide down the back of the dinosaur and you're out of the courtroom. We'll see where we are with a witness as the 5 o'clock hour approaches. And if there's a way to finish with that witness a little before 5 or a little after 5, I'll ask your forbearance to go with us a little after 5. I won't say, hey, who can stay till 7 because there are 2 hours left with the witness. That witness will need to come back tomorrow morning to finish his or her testimony. So 5-ish is when we will break. And as I mentioned, we'll stop anytime any one of you I got to walk down the hallway a couple times before I hear anything more about this case. Before I give you some basic legal instructions, I'd like you to stand up and raise your right hand. Your last oath. Do you swear or affirm that you shall fairly try this case and provide a true verdict according to the law that I give you and the opinion you form concerning the evidence to the best of your skill and knowledge without favor or affection to either party? Please say yes if you so swear or affirm. Yes. Does anyone not so swear or affirm? Excellent. You're all officially jurors. I've had in my 10 years as a judge, only one person say no at that point. It was a guy who didn't want to be on the jury. He said, I got other things I need to do. And so he figured his way out was to say no. He said, okay, you go sit there. And he got to watch the trial. So he didn't get to go do the things he needed to do. And he didn't get to serve as a juror. So that was not a good choice on his part. And the seats are much less comfortable, as you experienced out in the gallery. All right, ladies and gentlemen, you are about to hear the case of, and I want to get the style of the case right, Thomas LaVone, LLC, John Wesley, and Thomas Woodard, those are the plaintiffs, versus FloShea at the Point, LLC, and Shea Embry. Before the lawyers begin their presentations, I need to talk to you a little bit about how trials work, your role, my role, and the lawyer's role. Many of you have seen trials on TV, as in made-for-TV trials. Very few have participated in trials. And so most of you have a misconception of what happens. It will not be the case that at the middle of the trial, Mr. Williams or Mr. Sterling will be asking a witness a question and the person breaks down and says, I did it, I killed the butler. First of all, it's not a murder trial. So hopefully we're not going to learn about any dead bodies, but that's not how it flows. Information is going to be pushed in your direction that you need to process and work through. You are going to hear from the lawyers during their openings, likely, what the specific causes of action are. In other words, what the harm was and why they think they should collect. But you don't learn until the end of the trial, when I talk to you again, what the elements of those things are. So it's an odd process you go through. You're receiving all the evidence. And then at the end, I give you the tools to say, all right, has either side met its burden? This is what they need to prove by a preponderance of the evidence to be entitled to damages. But that's how it works. And you're now a part of it. You all have notepads. You are invited to and encouraged to take notes, but you're not required to take notes. You're free to do that because, as I mentioned, there's no replay button. We're not recording the witness testimony. You don't get to watch it again during your deliberations. You will be relying on your collective recollection, what's up here and what's on your notes. So feel free to take notes. A couple ground rules about notes. Number one, they need to remain private until you begin your deliberations. So whatever you write down, even if it's a picture, look at the funny judge, don't share that until you begin your deliberations. Once you are deliberating, you're free to say, well, here's what I wrote down. And people can say, that's fascinating. That's not what I wrote down, or I remember it differently. But you can use your notes as a memory aid during your deliberations. What you need to avoid if you are a note taker, is letting note taking consume your focus while you're a juror. One of the things you do as a juror is determine the credibility or believability of witnesses. And one way you're going to do that is by noticing that when the witness was answering questions from one side, he was all bubbly and making eye contact. But when the other side started asking questions, he pulled back from the microphone. Maybe there's a little sweat on the brow, not looking at you anymore. That's a tell. You may decide from that there's something you want to conclude about the way he was answering those questions. But you'll miss it if you are trying to write down verbatim what the person said. The only person in the room who's got the skill set to write down verbatim what people are saying is the one who gets paid a lot of money to do that. And that's not you. So take notes, but don't let that distract you from seeing the exhibits or observing how these witnesses are interacting with the lawyers and with you. Your notes at the end of the trial will be shredded. You don't need to worry if you write down uncharitable things about how the trial is going or anything like that. I won't read them. They just literally get shredded. In fact, some of you may have partially used notepads because the last juror didn't use the whole notepad, and we're a local government, so we have to conserve resources. And so we reuse the pads, but your notes will be destroyed when you're done. In a civil case like this, the plaintiff has the burden of proving the claims that the plaintiff brought by what is known as a preponderance of the evidence. Preponderance in the course of a civil trial means superiority in weight. It means specifically the greater weight of the evidence upon the issues involved. To be a preponderance, the weight of the evidence before you must be sufficient to incline a reasonable and impartial mind to one side of the issue rather than the other. And I use the term weight intentionally because when you think about the scales of justice, that image of the lady with the blindfold, it's actually a helpful image. What you will be deciding at the end of the trial when you decide if the plaintiff has proven its claims, or because there are counterclaims in this case. In other words, the defendants have in response brought claims against the plaintiffs, and the defendants have the same burden. They have to prove their counterclaims by a preponderance if they're going to be awarded any damages for them. Think about it as scales, and you are deciding in which way do the scales tip. So if we just start with the plaintiff's claims, the plaintiff has the burden of proving their claims by a preponderance. In other words, you need to be able to perceive that the scales, when you load all the evidence onto them, tilt perceptibly in plaintiff's favor. If you find that the scale is even, you know what, it's 50-50, then the proponent loses. They have not met their burden. They have not convinced you that there's more weight of evidence on their side. Obviously, if on a plaintiff's claim, you feel the evidence preponderates towards the defense, plaintiffs have lost on that claim as well. But if you find for a claim that the plaintiff's evidence or the overall evidence in the case, the weight of that evidence causes those scales to tilt in favor of the plaintiffs, that's all they need to do. It doesn't need to be 70-30, 90-10. It's 50.0001. If you perceive that there's a little more evidence on the plaintiff's side for their claims, they've met their burden. And the same for the counterclaims. The defense has to meet that burden. If they fail to, or it's 50-50, then you are legally required to deny the counterclaims. The basic structure of a trial is that in a few minutes, the lawyers will both be given an opportunity to present an opening statement. An opening statement is sort of a forecast or a preview of what these lawyers think the evidence will be. It itself is not evidence. In fact, nothing, N-O-T-H-I-N-G, nothing the lawyers say in this case is evidence. Evidence is going to come to you in two forms. One, it'll be what witnesses say once they're under oath in response to questions. So it's not the questions of the lawyers, it's the answers of the witnesses. And number two, it will be the exhibits that are admitted. And those exhibits, one, you'll get to see on screens, but two, they'll go back with you during your deliberations. So when I mentioned you won't get a transcript of witness testimony, you will get all the exhibits that are admitted. So there may, for example, be a lease that is admitted into evidence, and parts of the lease may be flashed up on the screen and you're trying to write some of that stuff down. Feel free to write some things down, but know that you will also have that lease, if there's a lease admitted, to review during your deliberations. So evidence comes in two parts: what witnesses say under oath and the exhibits, not what the lawyers say. But they're going to share with you in this opening statement what they think the witnesses are going to say. And because you're going to hear this, ladies and gentlemen, because you're going to hear that, we believe you should decide this case in our favor. So you have a sense of what's coming in the trial. Neither side is required to give an opening, but both sides typically do. Once these openings are over, I will turn to Mr. Sterling as counsel for the plaintiffs and ask them to call his first witness. And he'll do that. He'll call Steve Smith. Steve Smith will come on up and begin answering questions. And when Steve Smith gives that first answer, that's when the evidence in this case has begun. At some point, I'll ask Mr. Sterling to call his next witness, and he'll say, Judge, at this time, plaintiffs rest. That means that the plaintiffs have completed their presentation of witness testimony and documents or whatever other physical evidence they're going to admit. We'll have to take a break at that point because there are a bunch of legal things that happen when one side rests. When the dust settles from that, you'll come back in, and I'll ask Mr. Williams to call his first witness. He has a burden of proof for his counterclaims. And he may start meeting that through his examination of witnesses that Mr. Sterling calls, but he gets an equal opportunity to call witnesses. And he may call some of the same witnesses because there were certain things he chose not to explore with them during the presentation of the plaintiff's case. Although usually the lawyers, when a witness is on the stand, try to take care of everything. They're not required to. So some of the same witnesses may get called by Mr. Williams, but it would be to cover something different from what they discussed before. At some point, Mr. Williams will say, Judge, the defense rests. And assuming there's no rebuttal from the plaintiff, then the evidence will be closed. The lawyers will be given a chance to provide their summations or closing arguments where they advocate to you, here's what you ought to do. You heard all the evidence. Here's the right outcome, a verdict for the plaintiff or a verdict for the defendants. And their goal is to persuade you, but remember, what they say to you is not evidence. When they tell you, by golly, witness X said that the sky was blue that day, and you've got a very clear recollection that witness X said it was pouring rain, you can be persuaded by the lawyers, but what they say is not evidence. It's what the witnesses said. When the closings are done, I will give you a more formal legal charge about the law that you must apply to the facts as you find them to be. You are the fact finders. You're going to decide what the facts are in the case. Was there a lease? How long was the lease? Was the lease violated? You decide that. But there's certain law that I give you that you have to apply to those facts to decide, has either side met its burden? During the trial, you may hear some of what you see on TV with trials, which are objections when lawyers, sometimes they stand, sometimes they don't. Objection, hearsay. I need to rule on those objections. Nothing I say in ruling on those objections should be viewed by you as a comment on the evidence or a comment on which side is doing a better job or not. That's not a perspective I take on this. I'll simply be ruling based on the rules of evidence. And so if someone objects and claims that it's hearsay, and I think that based on the rules of evidence, what the person was about to say is not hearsay, I'll say overruled, and we'll keep going. If I say sustained, then the lawyer who asked the question needs to ask a different question. Every once in a while, an objection comes only after the witness has said something objectionable. The lawyers are good, but they don't have perfect crystal balls. And so sometimes the question seems innocuous, but the answer goes into an area that is problematic evidentiarily. And the lawyer who objects will say objection and move to strike, something along those lines. If I tell you to disregard the testimony that you heard, you need to do that. So if you wrote it down, cross it out. If you're back there in the jury room deliberating and someone in your group says, hey, remember when that witness said that the car that ran the red light was a green car, but that's what I told you to disregard? You need to police that and say, hey, the judge said to disregard that testimony about what color the car is. Now, before you start thinking like, what kind of joke is this? We're not going to forget it. If it came out, we can't forget it. If the testimony that came out was so central to this case that it's the kind of thing you'd be struggling with during your deliberations, you're not going to hear a motion to strike. You're going to hear a motion for a mistrial. We would not put you in a situation where you've heard testimony that I ask you to unhear that is central to your deliberations. These are good lawyers. I hope we don't run into a mistrial, but a mistrial means thanks for your time. We have to do this all over again. Those are infrequent. In fact, the main reason we have mistrials, I'm going to talk about a little bit later, which involves you conducting outside research, which you're not allowed to do. But I need to rule on the objections. Nothing I say about those rulings is meant to be a comment on the evidence or which side is doing a better job. I also use that term motion. Every once in a while, the lawyers will have something more substantive than just objection hearsay. Motions usually mean break for you all, because the lawyers need to talk about something more openly and fully that you ought not to hear until I rule on it, because I may rule in such a way that you're not going to hear about it at all because it's something that's not relevant or shouldn't be shared with you for some important legal reason. So when the lawyers have a motion, I'll usually say, could we talk about that during their next break? And sometimes we can, but sometimes we need to deal with it right away, in which case you'll get a bonus break and we'll work through it as quickly as we can. Your job, we talked about mine, ruling on motions and ruling on objections. The lawyer's job, they're the advocates. Your job is to determine the facts of the case based on the evidence you see and hear. I've already told you evidence comes in two forms, testimony and exhibits. The things that are not evidence, again, nothing the lawyers say, nothing I say, questions aren't evidence. One of the ways you will be deciding what the evidence is in this case is by determining the credibility or believability of the witnesses. You decide which witnesses you believe and which you don't believe, if there are any that you don't believe. It may be in this case, you can believe every word that is spoken and still reach a verdict. Usually we don't have trials if, in fact, you could believe everything everyone says. But we'll see how this case plays out. In determining the credibility of a witness, you are free to consider all of the facts and circumstances of the case, as well as the manner in which the witness testified. That's, again, you watching the witness and see how she handles questions from one side versus the other. Your sense of this witness's knowledge of the facts about which she's testifying, her apparent intelligence, her potential bias, in other words, her interest in the outcome of the case because of a connection to one side or the other, and this witness's means and opportunity for knowing the things about which she's testifying. You may believe or disbelieve all or any part of the testimony of any witness. You decide, and no one else does, what testimony is worthy of belief and what testimony is not. While you are determining the facts of this case, you may from time to time perceive that there are conflicts in the evidence. If you do find conflicts in the evidence, you should try to reconcile them as if each witness had testified truthfully. As you know, very often one person will perceive a situation very differently from another because he was on one side of the room or was outside the room and was only listening and not watching. This doesn't mean that one person is being untruthful. It simply means that people's recollections differ. If, however, you find that some parts of the evidence are in such conflict as to make it impossible to reconcile them, then you must believe the evidence that seems most reasonable, probable, and truthful to you. During trial, you will be permitted to submit your own questions to the witnesses. The way this works is that the end of a witness's testimony, so after Mr. Sterling and Mr. Williams have had a chance to examine or question the witness, you all can write questions down on those note cards, and you should spread a few around before we get started. You write them down. Don't put your name on the note card, just whatever your question is or questions. You can ask more than one. Please write on only one side of the note card and do your best to write legibly because I'm the one who has to read them. But you'll submit your questions. I'll meet with the lawyers outside because they need a chance to be able to object. Your questions can be just as objectionable as another lawyer's question. Those questions that are proper, I will then pose to the witness, and then the lawyers will have a chance to follow up. So the way you scratch that itch of, wait a minute, what does the store at this shopping center we're talking about, what does the store look like? If you're curious about that, you write it down. You don't go online to find the store and look at a Google Maps picture. You don't, on your way home, drive by the store to look at it. You would ask a question, are there pictures of the store or anything like that, if that's germane? I don't know that the appearance of the store is something that matters. And if it is, likely these lawyers have pictures of it. But the way you get a question answered is by writing it down. There is no outside research. You will be deciding this case based on the evidence presented here in court, evidence that both lawyers, both sides have a chance to object to, respond to, rebut, and that I mediate, that I admit in if it's permissible and I exclude if it's not. If you go home and Google landlord-tenant law and spend 2 hours reading on that, you are having an uncurated experience that may be accurate, it may not. Just because it's online, as we all know, doesn't mean that it's true. And so I need you to not engage in that outside research. And if you've got questions, write them on those cards. And if they are relevant to the case and appropriate to be asked, they will be asked. And you will see that the lawyers suddenly become interested in those topics as well. So last thing, when you are on break, it's important that you not pre-deliberate. The time for you to discuss, hey, did the plaintiffs meet their burden? Did defendants meet their burden? Is after you've heard all the evidence, closing arguments, and the law that you must apply. So when you go back for your first break, when you have your first lunch, it's fine to be together, but don't talk about the case. Don't share your impression of that witness or this or that. You can complain about the temperature or that the bottled water isn't the brand that you like. That's fine, but talk about anything else. There are a whole lot of subjects out there. Talk about Silicon Valley Bank. Or whatever you want, but not about the case. I promise you, once it's deliberation time, you'll get as much time as you want to work through the issues in the case and decide, has either side met its burden of proof? But until you've heard the law that you must apply, you're kind of shadow boxing. Because you go, oh my gosh, Sterling's doing an amazing job. He has totally convinced me of the what? I mean, he's going to tell you what the allegations are, but you don't know what the elements of those allegations are. So process things while you're in here, process things in your head on your notepad, no group processing until I tell you it's time to start deliberations. You've got the evidence back there with you and you've got the charge of the court. A corollary of this is that when you go home tonight, you need to be pretty circumspect about how your day went. I mean, you can use wonderful glowing adjectives about it, but don't engage in, hey, this is what the case is about, because well-meaning people will say, oh my gosh, I was a tenant in a commercial lease once, and let me tell you how that went. Or I was a juror in a murder trial, and let me tell you, those are different circumstances. They're not this case. So be vague with other people and say, hey, it's a process. When the trial is done, if you want to write a book about it, you want to sing a song about it, you can do that. You can tell everyone everything about the case. But between now and the entry of your verdict, you need to be really boring with other people about it. I've got jury duty. Obviously, you can tell people you've got jury duty. Don't even civil, criminal, doesn't matter. I've got jury duty because folks, they love to talk about their experiences. Their experiences are not yours. It's not this case. It's not this courtroom. It's not these lawyers. And you just run risk of getting some of that outside information that's prohibited. And no one wants to try this case a second time. So please live in that bubble during the course of the trial, and we will get you through it as efficiently as we can. That concludes my instructions. I'm going to turn to Mr. Sterling for his opening statement.
Space button. How do you go back? This one.
Good morning, ladies and gentlemen. My name is Attorney Michael Sterling, and I represent the plaintiffs in this matter. Mr. John Wesley, Mr. Thomas Woodard, and Thomas LaVone, LLC. I'll tell you something that it doesn't matter how many times I do this, you will see it visibly on me. My hands get sweaty, I get butterflies, I shake a little bit because I know how important this is to my clients. And the fact that out of all the great lawyers they could have chose in the state of Georgia and the Atlanta area, they've trusted me to prosecute their claims regarding how they lost their business. See, this case is very simple. It is about broken promises, a stolen dream, and a small startup business that was completely and utterly destroyed. That's what this case is about. And it really starts with my clients moving their business from New Jersey to Atlanta to pursue their dreams. What you will learn is that John Wesley and Thomas Woodard, small business owners with big dreams, a fashion label, fashion design. They designed dresses and fashion, clothes, and they knew that Atlanta was the place where they could pursue those dreams in earnest. And so they moved their business from New Jersey to Atlanta, and in doing so needed a location in which to operate their business. They've been working on this for 10, 15, 20 years, coming up with designs, drawings, working tirelessly to get their business off the ground. Years and years and years of effort, of sweat equity, of work that they put into this business. And they knew Atlanta was the place for them. And so in 2019, they entered into a lease. You will learn, go to the next slide, you will learn that a lease is basically a contract. It's a contract. It's a promise, you do this and I'll do that. It's a promise on what you do and how you will perform. As my grandfather used to say, it's your word. Your word, you've got to be as good as your word. It's simply an agreement. So a lot of times we see contracts with all this language and they're written down, but sometimes it's just a handshake. Sometimes it's just someone giving their word on what will happen. But in this particular instance, there was a lease that was signed in 2019. They relocated their business to a place called The Point in Atlanta, Georgia on Cascade Road. They entered into that lease with the defendant, FloShea at The Point, which is co-owned or business partners is Shay Embry and Mr. Flournoy. And I hope I'm saying this name correctly, but it's Flournoy, Mr. Flournoy. And so they entered into a 74-month lease in 2019, a place in which to operate and grow their business. And what you will hear is that in that lease were certain promises that were made. You can go to the next slide. What was promised? My clients promised, we'll pay you rent. We'll accept the building as it is in its current condition in 2019. We'll follow the rules and covenants that you put in the lease, and you have to do the following. And I want to draw your attention to certain things you will hear about what was required of the landlord. Landlord could change the number, dimensions, location, or improvements of the building. They could change the manner of the building. They could alter and make improvements comprising the building. However, if that materially or negatively impacted access or hurt my client's ability to use the building, then they would have to get the prior written consent of my clients. That's the promise. I take the building as is. I pay you rent. I follow the lease and covenants. If you make changes or improvements, or if you do anything different to the dimensions of the building, you have to get my prior written consent. That's a promise in the lease, in the contract. That's your word. You go to the next slide. What was promised? Again, we'll take the building as it is. We'll pay you rent. We'll follow the covenants and rules you put in the lease, but you have to do the following. You're the landlord, and after a reasonable period of time, after receipt of written notice from the tenant, you should make necessary structural repairs to the exterior walls of the premises, necessary repairs to plumbing, pipes, and conduits located outside the premise or in the common areas, and necessary repairs to the common areas. That was what was promised. Pay you rent, we take the building as is, we follow the rules, and if we ask you to make repairs that are necessary to the integrity of the building, to the necessity of us being able to operate our business, you will make those repairs. Seems pretty reasonable. Go to the next slide. Then, take the premises as it is. We'll pay you rent, we'll follow the rules. Now, you have a right, landlord, right? Anytime you can make alterations or additions to the building. You can construct other buildings that adjoin my building. You can make improvements on the land, but there's an exception to that. If you do that and your construction interferes with my ability to operate my business, you cannot make those changes in a way that unreasonably interferes with my ability to operate my business. We've got a lease, we've got an agreement, right? We're not trying to stop you from making other improvements or changes on your own land or your own property. But if you do it in a way that unreasonably interferes with my ability to continue to grow my business, to operate my business, that is prohibited under the lease. Go to the next slide. What was promised? You're not responsible for any of the personal effects within my building. The landlord's not responsible for any of the personal effects within the building, except under a few circumstances. If you intentionally or willfully or in an act of gross negligence impact the personal property that I have located in this building, then you are indeed responsible. Makes sense, perfectly reasonable, simple terms of the lease. You're not responsible if something happens to my property, somebody breaks in and take my stuff. You're not responsible unless it's you. Unless you intentionally go in and unreasonably take things out of it. Unless you go in and willfully or wantonly destroy or hurt my personal effects. In that case, you are indeed liable for what happened. Go to the next. What was promised? You will learn in this trial that on April 29th of 2022, that the locks were changed on the building following a discussion back and forth regarding what should be happening with improvements, changes to the building. You will learn that sua sponte, the landlord, said, I'm terminating the lease. And they changed the locks on April the 29th of 2022. My clients went to the building that day. And even though they had had some dispute about the termination of the lease, about the issues involved, you'll learn about those issues. You'll learn about those details. There'll be some debate about what was proper, what was improper. There was a dispute about the landlord not doing this, not doing that. Dispute about the tenant not doing this or not doing that. You'll hear about those things. But what I really want you to pay attention to that you will hear is that on April 29th, when the locks were changed, our clients went to the building. They sat there, couldn't get access to the building, couldn't get in, couldn't get their personal things out of the building. They talked to Mr. Flournoy. There was a police officer present. They had this conversation. And they understood at this point, regardless of what the law was, regardless of what the rules were, regardless of the back and forth they had, that they were locked out of a building with all of their designs, their 20 years of work, their 20 years of equity, sweat equity, all of the things that they had paid money for to make their dreams come true was in a building that they had no access to. And so they asked Mr. Flournoy, we want to get in that building. And he promised them, you can get in this building on Monday, just get in touch with us before 4 p.m. I won't let anything happen. I've got the key right here in front of witnesses. I've got the key right here. I won't let anything happen to your stuff. You can get in on Monday at 4 p.m. That was the promise that was made. But what actually happened, go to the next slide, was that before 4 p.m. on Monday, approximately 10 a.m., all of their business items, and there will be no dispute about this. There will be no dispute. All of their business items, all of their intellectual property, all of the tangible things, everything related to the business began to be taken out at 10 a.m. on Monday. My clients show up because they get an alert from their alarm. The alarm that they had installed in the building, even though they didn't have the key, alerted them that somebody was in the building. They show up. And in their presence, as they're outside pleading to get their stuff is taken out piece by piece. Their fashion designs, the dresses, the tangible items, their intellectual property, their years of hard work is taken out of that business. It's not given back to them. It's not put on a corner. It's not put in a place where they can get it back. It's destroyed, discarded, as if it was nothing. Now, it's one thing to lose the building. It's another thing, completely entirely different, to lose all of your years of hard work, 20 years of building a business. And there will be no dispute. There's no doubt that the defendants took their stuff out and destroyed it. They admit that. They took their stuff out, didn't give it back to them, and completely and utterly destroyed it. And in essence, destroyed their business. They had items, you learn my clients had items on back order. They had things they needed to fulfill, invoices that were going to be paid. They had people asking them to do things. They had gigs that were booked. They had all sorts of things in the works that helped their business. And in one fell swoop, all of the items were taken, destroyed, and they lost their business. You can go to the next slide. You will learn that what was promised was that you can make improvements to the building, but if you do so, it can't interfere. What was promised was that if there are repairs that are needed, we can let you know, give you written notice, and you have to make certain repairs. What was promised was that you can build a structure next door, and that's fine, there's no problem with that. Anything adjoining the building, but if you do so, it can't unreasonably interfere with what we did, with what we have going on in our business. And what you will hear is that in each of those scenarios, rather than reading the entire lease and looking at the contract in its entirety and understanding everything that was promised, you will learn that the landlord simply responded in each instance, you agreed to accept the property as is. That she relied on an as-is clause, as is, as is, as is, as is. And what you will learn is that my clients willingly accepted the property as it was. No mistake about that. In fact, you will learn that they put nearly $5,000 worth of improvements to increase the property, to make it look nice, to make their space comfortable for their customers in order to keep their business going and accomplish the things they wanted to accomplish. And the landlord, every time they brought one of these issues up related to the other part of the contract, you will learn that this building, it was flooding with water because there was construction next door that interfered with my client's ability to operate their business. You will learn that there was an electrical box that was put in there that created a hazard that my clients brought to the attention of the landlord. And all she responded with was as is. Well, that wasn't there in 2019 when they got the property. It wasn't there in 2021, in 2020, I'm sorry. Wasn't there until late 2021. And when my clients noticed it in early 2022, they brought it to the attention, per the lease, per the agreement, in writing. This is what you've done. This is what needs to be fixed. This is a problem. You will learn that the landlord simply responded, you agreed to accept the property as is, without reading that there are other parts of this contract that require you to do other things. They were simply trying to keep their word and hold the landlord responsible for their word. They went to try to meet with her in person. They sent emails. They did a number of different things to try to get these issues corrected. You can go to the next one. So what my clients did was, at first did what was completely appropriate. Let's try to reach out to our landlord, get her to fix it, get them to fix these issues. When they couldn't get a response, they then sought legal advice and counsel. Let's go find a lawyer. Let's see what our remedies are. What are the possibilities for us? What can we do? What are our options? If she won't remedy the things that she's required to remedy under the contract, what can we do? They made some of the improvements themselves. You'll see video of the water coming in and my clients taking it upon themselves to clean that water out, getting somebody to come and fix those issues. They took the repairs on themselves when they couldn't get the landlord to fix it. And you'll see the video and the pictures of what exactly was happening in that building and why it was hurting my client's ability to operate. You'll see that they also sought help from local leaders. They call their local neighborhood planning unit. In Atlanta, there are these things called NPUs, or neighborhood planning units, where in each neighborhood, there's a sort of a neighborhood organization or association where you can get help or seek recourse if there's something not up to code or not being done in a particular area. So they sought help from the local neighborhood planning unit. They sought help from city council, from their Fulton County commissioner. They took a number of different steps to try to redress what they thought genuinely believed was an issue with the building, was a violation, and was interfering with their building, the flooding, the electrical issues, things that they thought should be remedied by the landlord per the agreement, per the contract. They sought help to do these things. You can go to the next one. So that's one. Is that the last one?
Traditionally,
And ultimately, what happened, and the reason why you all are here, the reason we're in court, is that the last thing they could do, so they were kicked out of the building after everything was destroyed, after they had nowhere to turn, so they came to my office. They said, what can we do? Well, it's only one level of recourse. We have to try to see if we can get some justice in a court system. And that's why we're all here today. That's why you're here today. That my clients lost 20 years worth of work, destroyed right in front of their eyes, taken out of the building and discarded right in front of them. All of the designs they had worked on for 10, 15, 20 years, all of the tangible assets that were in the building, all of the equipment that was in the building, all of the fashion, nearly 2 decades of sweat equity was taken away from them. And they lost their ability to operate. They couldn't fulfill orders. They didn't have their designs anymore. They didn't have their products. They didn't have their sewing machines. They didn't have any of the things they could have needed. The building in and of itself was important in the instance that it provided a location for my clients to operate. But surely they had all of their stuff. They could have just gone somewhere else and operated. But once they took their stuff, stole it essentially, destroyed it, discarded it, my clients lost their ability to operate their business anywhere else, and essentially lost 20 years worth of work. And so at the end of this, I will come to you after you hear all the facts, all of the evidence, all of the testimony. I will come back to you and ask you to find the defendants liable. Liable for the wrongful, liable for failing to fulfill their obligations under the lease, liable for the wrongful termination of the lease for evicting my clients out, and liable for the fact that they converted the property of my clients to their own use when they took it, destroyed it, and in essence, destroyed their business. Thank you.
Thank you, Mr. Sterling. Before you go, Mr. Williams, we're just getting the court reporter visual access to the Zoom feed. Thank you, Ms. Hansberry, for doing this. Sorry, I don't have a chair for you. So we're just logging in. I think you have to do CO. If you go back, do yes, CO, and then the slash above the inner sign. CO, and then that slash above the inner, and then Michelle.Hansberry. Yeah, who knows? Are you using a PowerPoint or not?
Your Honor.
Well, then why don't we get rolling and we'll let Ms. Hansberry work her magic.
I'm sure the court reporter would love to see me on the screen. Thank you, Your Honor. Good morning. Good to see you all again. I'm not going to ask if it's good for y'all to see me. I know the answer to that question. We met yesterday. I'm Kyle Williams. Joseph Brickman with my firm is here with me. Amani Brad was here with us yesterday. She's in another court. We represent the defendants. First, thank you for your service. I said it yesterday, I mean it. What Mr. Sterling and I do for a living depends on you. Depends on jury stepping up, because we need you. We need you to weigh the facts. We need you to look at the documents. We need you to hear from the witnesses. We need you to decide what obligations and rights the plaintiffs had as the business and commercial tenant, and decide what obligations and rights that FloShea at the point had as the business and commercial landlord. We need you to map out the timeline. We need you to map out that timeline against the lease. And we need you to judge the evidence, hear the law from the court, and make a decision. We've not been able to do that. So we need you. You've just met the plaintiffs today, John Wesley, and Thomas Woodward, and their company, their business, Thomas LaVone, LLC, the commercial tenant. You met my clients yesterday, and they're back with us today, Bobby Flournoy and Shay Embry, and their company, their business, FloShea at the Point, LLC, the commercial landlord and the owner of this building. And I've got to be frank, I'm somewhat embarrassed. In preparing for this trial, it dawned on me for the first time, FloShea, Bobby Flournoy, Flo, Shay Embry. I'm embarrassed to admit that in front of my counsel, but that's where it comes from, FloShea, Bobby and Shay. And you're here about the Point at Cascade, the property that we're going to talk about that you got introduced to yesterday, the adaptive reuse and the redevelopment of a collections of 1950s commercial buildings in the heart of Cascade Heights Commercial District. It's Shay and Bobby's work. Since they purchased it in 2016, they've invested in it, they've renovated it because that's the neighborhood that they live in. They've grown local businesses there. They've fostered local businesses there. It includes a coffee shop, a wine shop, retail, office, and restaurants. And one of those businesses that we've already heard was the plaintiff's business. You will see that lease. This is not a handshake deal. This is a written commercial lease. Signed in November 2019, signed by the plaintiffs as the tenant, signed by FloShea as the commercial landlord. The evidence will show you that Miss Embry, Shay, was not a party to that lease. Yes, it was her company, but individually, she was not a party to that lease, even though the plaintiffs have sued her. The evidence will also show that the lease, the written lease, the black and white words are not in dispute. The evidence will show what promises each made to the other. Mr. Sterling and I agree with that. What the tenants were supposed to do, what the tenants could do, what the tenants could not do, what the landlord could do, was supposed to do, was responsible to do, or not responsible to do. The evidence will show, and you'll hear from the law, that this is a commercial lease. And a commercial lease is different. It's different than what we think of every day as a residential lease. The evidence will show that that's the difference, that difference, that's what's at the heart of this case before you. The difference between a residential lease and a commercial lease. The evidence will show that plaintiffs, as the tenant, inspected the property. We're talking about a relatively small store, 693 square feet. They accepted that property as is, where is. That means tenant was not supposed to put in HVAC. Tenant was not supposed to move walls. Tenant was not supposed to landlord, excuse me. I get nervous just Mr. Sterling. Landlord wasn't supposed to do that stuff. Tenant took the space as it was, where it was. The evidence is going to show that they negotiated the terms of that lease, 74 months, 6 years, 2 months, and they negotiated the rent. That the tenants took possession of the space November 1, 2019. Mr. Sterling has, and he will continue to try to paint my clients as predators, as shady commercial landlords taking advantage of his clients. You will hear from his clients. You will hear from my clients. You will see Shay on the witness stand, and you'll be able to ask her the questions. What I will continue to ask you is to look to the written lease. Under the terms of the written lease, first 2 months were free. Free rent as a concession. The third month, when tenants were supposed to start paying rent, $1,000. Second year, that increased to just over $1,400. And in the third year, when all of the stuff that we're going to hear about happens, the rent was $1,487. What the evidence will also show is that from the beginning, there was issues about pay. The check, and you will see this in the evidence, check for the security deposit balance. The evidence will show that once plaintiffs as the tenants were required to start paying rent after the free rent period, they repeatedly paid late or partially paid and didn't pay everything that they were supposed to. The evidence will also show that the plaintiffs made changes to their space. To the exterior side facades, the brick exterior wall, that they cut open a sealed door that had been sealed for a very reason that you'll hear about. That they cut open a window in a window unit that you'll hear about. And Mr. Sterling's right. 2022 had some bad rain. You're probably going to see a video that shows flooding. We don't dispute that. But what the evidence will show is that it was the work that tenants had done, not that the landlord was responsible for, not that the landlord did or didn't do, that caused this. And the evidence will show around that time that this relationship fully broke down. The evidence will show at that time that plaintiffs were still slow paying, late paying, partially paying rent. Mr. Sterling mentioned this in his PowerPoint that at that time plaintiffs hired an attorney. Not Mr. Sterling here, but attorney Terrence Burrows from the law firm of Deming, Parker, Hoffman, Campbell, and Daly. And as my mom said when I got a job at a law firm, just a bunch of names. But a law firm here in Atlanta. And there's no dispute, and the plaintiffs admit that Mr. Burrows was their attorney at this time. And in addition to the lease, the evidence will show emails and letters. And you'll see March 22nd, 2022 email, one email from Mr. Burrows, representing the plaintiffs as their attorney, as the tenant. The evidence will show that Mr. Burrows, as their attorney, sent that email directly to my clients, complaining of issues with the space. We don't dispute that. Complaining about plumbing, complaining about electrical, complaining that the space was not up to code, and about this rain and the flooding. And you will see my clients' communications or attempted communications to Mr. Burrows. The evidence will show in black and white, emails and letters, that my clients as landlords responded. The evidence will show that they also said they needed an attorney and they hired me. And you will see the emails and you will hear the evidence from the witnesses that they responded. And the first thing they said was, hey, this is the first time we're hearing about electrical problems, first time we're hearing about code issues, first time we're hearing about plumbing issues. What's going on? We need to know more. We need to understand it. There's no code citations. We're in compliance with the city. We don't know what you're talking about. You've been in this space for 2 years. Let's figure this out. The other important thing that you're going to see in the letters and the emails and from the direct testimony is they say, we understand our obligations under the lease. Let's figure out who's responsible for what and who's obligated to do what. The evidence will show Mr. Burrows didn't respond, didn't elaborate, received those communications and didn't respond. Instead, what the evidence will show is that they ignored that. Despite multiple attempted communications to Mr. Burrows, landlord will be responsible for what it's responsible for. Here's the other key. Tenant still has to be responsible for, tenant is responsible for paying rent. Because what the evidence will show is that they were behind, they were still slow paying, and they were still only partially paying. And you're going to see a series of letters. You're going to see a notice of breach. Plaintiffs, you're behind on rent and you need to pay. Fair warning. Remember, there's a difference between a commercial lease and a residential lease. And we're going to see the lease. And you're going to see the language in the lease. And you're going to see that exact same language repeated in the emails and the notices of breach and the notices of terminations in the letters. If you don't pay, landlord may exercise its rights under the lease. That landlord may exercise what the law calls self-help. That means exactly that, self-help. That the landlord may terminate the lease, that the landlord may retake possession of the space, that the landlord may change the locks, and that the landlord doesn't have to keep accepting partial payments or late payments. It's time to get right. What the lease is going to show, the lease negotiated, the lease agreed to, and the lease assigned, is that the lease says the landlord could exercise those rights without notice. If the tenants were in the breach, they didn't have to give them a fair warning. They didn't have to give them notice. They didn't have to give them time to move out. But we did. And the evidence is going to show that in all of the communications, fair warnings were given, opportunities were given, notice was given, and deadlines were given. You'll see a notice of termination where the evidence will say you've ignored all the previous stuff. Did not come current, not accepting late rent, not accepting partial rent, we're terminating the lease. And you'll see in that notice, we're terminating the lease, fair warning, opportunity, please come get your stuff. Please come get your stuff. And the evidence will show, again, that Mr. Burrows, as the attorney, did nothing. You will even see direct emails from my clients to the plaintiffs, where my clients say, and the evidence will show, here's the letters we've been sending your attorney. We've terminated the lease. Please come get your stuff. You will hear, and the evidence will show, and it was already previewed in Mr. Sterling's PowerPoint, that the plaintiffs did not heed these warnings. They did not go get their stuff. Instead, they took the attitude that the landlord could not and would not do anything unless it filed an eviction action against them, a lawsuit against them. We're going to look at the lease. Plaintiffs did not look at the lease. The evidence is going to show that plaintiffs ignored the lease and instead started threatening and pointing fingers at my clients. You saw it in the PowerPoint. They went to city council members, they went to county commissioners, they went to Facebook. To their own peril, plaintiffs took the position that the landlord wouldn't do what it said it was going to do and couldn't do what the lease said it could do. The evidence will show, and there is no dispute, that the landlord, my clients, did exercise its rights to self-help under the lease. Did we retake possession of the space? Absolutely. Did we change the locks? Absolutely. Did we clean out the space? Absolutely. But what the evidence is going to show is that was only after repeated notices, repeated fair warnings, and multiple opportunities were given to the plaintiffs. You will even see a last-ditch email from Mr. Flournoy, the Flo, to plaintiffs. I will be in the store today from 9 to 2. Please come get your stuff. We're going to have a disagreement about dates. The evidence is going to give you a clear timeline. The documents and the emails and the written notices are going to give you a clear timeline, and that timeline matters. Because that timeline shows it was 3 weeks of notices and opportunities and warnings, more than 21 days. And you will see, and the evidence will show, that plaintiff's response was, quote, "There will be no removal of anything." They started attacking, threatening, took to Facebook, posting videos, emails to city council members, media. They blamed everybody but themselves, and the evidence will show that's not the case. They're going to continue to try to paint us as corrupt, as predators, that we burglarized the space, that we vandalized the space, that we stole, that we're commercial grifters, commercial culprits with grievous commercial contracts, and worse. But throughout this, I'm going to ask you, and the evidence is going to show what the lease says, what the lease permits, and the difference between a commercial and a residential lease. I realize, and I get it, saying changing the locks or retaking the space sounds harsh. I get that. Because that's not how it is in residential. But the evidence will show that those self-help remedies were in the negotiated lease and were allowed. Plaintiffs would blame everybody but themselves. Let's look at the lease because the lease is clear. Landlord gave notice after notice. And the evidence will show landlord gave fair warning after fair warning. The evidence will show landlord gave opportunity after opportunity, and that the lease allowed self-help. And the evidence will show that plaintiffs ignored all of this, refused to remove their stuff from the space, did not protect themselves, and sued. You're going to see the complaint. You're going to hear testimony, and the evidence will show you how much plaintiffs are asking for in this case. The evidence will show a 2-page listing of damages that the plaintiffs prepared. Property they claim was in the 693 square foot space. And we're going to total that up because that's what they're asking you for and what they'll come back and ask you for at the end. Pay attention to what that number is. This is their fault. What does the lease say? What does the timeline show happen? What does the law allow? And who is to blame? At the end of this, and there will be an end, I promise. You will hear charges from the jury, jury charges from the court as to what the law is, what the standards are, what the elements are. And we'll come back to you. And I'll ask you to set aside your sympathies. And I'll ask you for a verdict that's fair, that's just, it's based on the documents, facts, and the law. I appreciate your time. Appreciate your service. And I appreciate you bearing with me. Thank you. Thank you, Your Honor.
Thank you, Mr. Williams. So what we're going to do is have our morning break. I know you've only been out here for about an hour and a few, but I'm trying to get this screen right here to show what we can see. And I think, is anything on the screen up high? I think what's on the screen down low comes from the screen on high. And we're going to get that screen to have the same Zoom feed during your break. So During the break, don't talk about the case. You actually haven't heard any evidence. You've just heard compelling presentations from both sides as to what the evidence may show. And when we come back, Mr. Sterling will call his first witness. We're going to try to keep the break to 10 minutes, but you're the boss of break time. So Deputy Gordon's going to try to corral you on that clock around 10:35, a little bit later. You're free to fan out down that hallway. If you don't want to all be in the same room, there should be snacks in the room. The restrooms are for you. The water you can bring out here. And as I said, you can spread out down the hallway. Don't play the drums down the hallway because then my colleagues will fuss and then we lose hallway privileges. But otherwise, feel free if you need to walk around a little bit. Any logistical questions? Seeing none, you're welcome to take your notepads with you, leave them on your chair. Oh, one last thing that I meant to mention. There are no assigned seats. I encourage you, unless you need to be on the end because you have to stand up and stretch every once in a while, shuffle around a little bit. You literally get a different perspective. You are very far from the witness and you may want that, keep those seats. But the more you sit in a different spot, the more you'll have a well-rounded view of the lawyers, the parties, the witnesses, even the judge. So don't always take the same seat. Go with Deputy Gordon, please. Do you want me to, I can give you the meeting number. Oh, so we're off the record now. I'll find out from you guys if there's anything you want to talk about before I bring them back in, but let's be at ease right now so we can get signed in. Give me 1 second. All right. The meeting number is 928-8914-6670.
Just messed up.
He said my name.
164.
Said he said my name right.
655.
I love
Look at that.
FloShea reality.
Oh, yeah.
But-
Those people are.
Just good.
I honestly didn't think
Comedic
about it
thing.
either. I knew shit,
Good.
obviously.
Yeah.
It moves around. Yeah, we want her camera off because that's picking up. I don't even know what camera that is. Yeah, you can push that down. Good. And I can turn the video off. We just need. Oh, it's off now. Good. So join without audio. It can be with audio. You just need to mute it when you do that. In a second. Yeah, and if you can just maximize it. So that, there you go. Excellent. Perfect. Thank you so much. Oh, yeah, I heard that. Crack, crack. And let me turn. So what we'll want to do, thank you so much.
You're welcome. Yeah, I didn't have any credentials on that.
Yeah, and so it was needed to do. I saw you having to type in like, whoa. All right. Whoops, she's asking, can you, well,
One more?
Chi-Chi's, but I don't know. She's
Oh,
used
Chi-Chi's
the notepad, so you may need to type. We're all set. Thank you so much.
That was the weirdest thing ever. It was like having a weird
Yeah, she's
watching. I see her just started typing. Just Attorney Burroughs.
okay. She's there you go.
BURROUGH.
I can't imagine I was mispronouncing things.
All right. Oh, he left. I'll get the exhibit stuff later. About 5 minutes.
Thank you, Robin. Yes, please.
Oh, and I can ask about some water, sure. I'll ask them about some water.
I kept messing up.
I didn't notice.
You always mess up.
One thing that I'm picking up on is I just looked through the complaint.
Woodard,
The OODARD,
well, it's spelled Woodward, it's pronounced Woodard,
the OODARD.
W-A-R.
John Wesley, just like his name.
Yes,
It is Woodard with no W.
it's no W on
Yeah,
it.
it's Woodard.
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 I've been pronouncing it right, but I think it's spelled the same. Yeah.
Woodard, got it. That's much better. I can now see all the names.
You wouldn't happen to have any hand lotion, would you?
I don't honestly don't use it.
It's too dry for me. That's true.
Also,
I saw it.
it's okay.
Did they say we could have her?
She hasn't come back out yet.
Okay.
That's what she does. I was the only one that came prepared. I was the only one that came prepared.
Yeah, I know. I think they left. I guess they do.
Yeah, I think so.
Yeah. Joseph is one of the happiest people I've ever met. That's nice. Sure can make the day better.
He said remain seated.
Oh, it's hard.
All right, let's get back on the record. We now have a video feed for the court reporter, and I think both large screens have the feed, which is great. You had wanted to hand me something, Mr. Sterling, or the?
The exhibits, I've got a copy. That's for the witness. I've got a copy.
Okay, I'm fascinated by the color-coded zip drives. What's that?
Those are videos and pictures.
Okay, great. I'm ready for my stuff. I don't need to have color-coded zip drives. Thank you.
And Your Honor, it seemed like a number of witnesses here. We will invoke the rule.
Okay, I see no witnesses now. I know I saw our Commissioner Abdur Rahman here again.
Correct.
Hopefully she can return to county duties soon. It's 2 mornings in a row she's been here. So you're invoking the rule. So other than the parties, we'll need to make sure folks who you expect to call wait outside until they're called.
Yes, Your Honor. I think, if I remember correctly, they charged me for a room for witnesses to sit in.
I don't know who would be charging you.
That was enough.
I'd love to know a new revenue stream that we have. Yeah.
I didn't even know.
There was a room. No, just claim it. There's an open space out there. Put a bench out. $10 a seat. The last name is Abdur space Rahman. Abdur Rahman. Yeah, first name is Khadijah, but she can spell it when she testifies. All right, Mr. Sterling, are you ready for the jury?
Yes, Your Honor.
All right, and Mr. Williams,
Yes, Your Honor.
let's bring him in, please. You lost your technical support. Okay. And seated with you is Mr. Woodward or Mr. Wesley?
Mr. Woodard, Mr. Wesley's.
Okay, great. I know they're both there. I just want to make sure I get them right.
Play the video with the sound, without sound, no sound. Because it's him talking.
Yeah.
I might say, yeah, it's okay. I don't even know if it's possible.
Yeah.
All right, adjourned.
Thank you, Deputy. You all can be seated. A plus for change in seats. That's great. We are now at the point where I'm going to ask Mr. Sterling to call his first witness.
Claims will call Mr. Thomas Woodard at this time, Your Honor.
All right, Mr. Woodard, if you'd come on up, please. Deputy Gordon will swear you in.
Raise your right hand. You swear affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth, so help you. Go ahead and have a seat. State and spell your name for the record.
My name is Thomas LaVone Woodard, that's WOODARD.
Mr. Woodard, I need you to do two things for me. One, it's going to be three things, and one of them the deputy just did. Two, if you put your finger in that, nope, on the microphone, see there's a red light microphone, nope, the actual microphone. See there's a red light down there? Tap your finger, hold it there for a second until it turns green, and then let go. Or just let go, maybe it'll turn green. Yep, perfect. Now that's on. Now, the one I forgot about on the screen, what are the two options?
Stay mute or unmute.
Stay mute. Tap that, please. Excellent. Thank you so much.
You want to
Mr. Sterling.
Yeah. Mr. Woodard, how old are you?
I am 58.
And what do you currently do for a living, Mr. Woodard?
Currently, what I do now, I'm actually working for Claire's Jewelry, going to different Walmarts and setting up the jewelry. That's what I'm doing now.
And what did you do before that?
Fashion designer.
Are you familiar with Thomas LaVone LLC?
Yes, I am.
Can you tell the jury how you're familiar with Thomas LaVone LLC?
I actually started the business in 2009, after the big layoff in New York City. I started my own fashion line. I figured it was the perfect timing to do it because it was such a large layoff. And when I tried to go back to work, they wouldn't pay me what I knew I was worth. So I started the own business myself.
Mr. Woodard, I'm going to ask you to slide forward a little bit. The chair has no wheels, so that literally, not you, but others have actually, they've rolled off. So no wheels on the chair. I just need you to be a little closer to the microphone so that we can hear you better.
How's that?
That is much better. Thank you.
Thank you.
And can you tell us a little bit about what you did, about how Thomas LaVone LLC worked and what you did for Thomas LaVone LLC?
Basically, I was the designer and the technical designer. I designed, I sketched, and I did the technical aspect, which is make sure the measurements and the grading of different sizes of the garments are executed properly.
And when did you get started in designing and doing garments? Did you go to school for that?
Yes, I graduated from Mesa College in San Diego. And in 1999, Jones, New York offered me a job. That's how I wound up back on the East Coast.
And I'm sorry, you mentioned, where did you start Thomas LaVone LLC at?
I started it in New Jersey.
And how long did you operate in New Jersey?
I operated in New Jersey from 2009 all the way up to, we moved to Atlanta, it was 3 years ago. So we're talking about, what was 2019,
So
20, 21, 22.
I'm sorry, so you would have been in New Jersey from 2009 to about 2019,
That's true.
and then you moved to Atlanta.
Then I moved to Atlanta.
Can you tell us a little bit about the trajectory of the business, how you started it and where it was when you moved to Atlanta in 2019?
By the time we moved to Atlanta, we had already been in Vogue. We've been in Elle. A lot of UK magazines were actually contacting us saying that they love what we're doing. We're the next designers to look out for. Vogue even did a spread on us. Elle magazine calling us the upcoming new designers to look out for.
And what kind of things did you design?
I did evening gowns, red carpets. I did ready to wear as well, and also did a lot of custom work for different clients.
And did there come a time, I think you said you moved to Atlanta in 2019?
Mm-hmm.
Can you tell a little bit about how you decided to move to Atlanta and what that process was like?
Well, basically, we owned a house in New Jersey, so we sold our house. First, we had to find a place. We wanted to move down here because originally we was in Macy's at first. And we did so well in Macy's, we outsold Michael Kors for the month we was in Macy's. So we decided to move on our own. Let's find a place outside of Macy's and move on our own. So we found the place over and off of Cascade Road. I liked the area. We was familiar with the area because we come back and forth to visit John's family down here. So we was familiar with it. It was close by that we could literally walk to the shop. So that's what made it so amazing. So we just seized the opportunity and we decided to go ahead and go with the place on Cascade Road.
And who owned the place on Cascade Road?
Shay, at the time when we pulled up there, we was looking in the store and she happened to just walk up right behind us.
And is that Shay Embry?
Yes, sir.
And what's her business name, FloShea at the Point LLC?
Yes, sir.
And did there come a time where you decided to lease there and enter a lease agreement?
Yes, sir.
Would you take a look? It's in front of you. I'll just pull up the first sheet of paper and look at the second sheet. It's marked on the bottom as Plaintiff's Exhibit A. Would you take a look at that? I'll pull it up there.
Yes.
Is that a fair and accurate copy of the lease you entered into for the space at Cascade?
Yes.
Has it been altered or changed in any material way from what you entered into in 2019?
No.
Your Honor, at this time, we would move for Exhibit A to be moved into evidence as the executed lease agreement.
Mr. Williams, any objection to plaintiff's Exhibit A?
No objection, Your Honor.
It's admitted.
And let's go through that lease a little bit. Mr. Wood, can you give us the address of where the exact address of where this was?
2291 Cascade Road.
And who's listed as the landlord?
It's listed as Shay at the Point, FloShea at the Point.
And what was the base rent?
The base rent at the time we first moved in, I think it was $1,000.
And was there a required security deposit?
Yes, there was.
And what was the date in which the lease was to commence?
It was in November of 2019.
What's the date on the lease?
Oh, it was December the 1st, I'm sorry, 2019.
And let's go to the next page. Well, actually, let's go to the last page, if you will. The very last page of the signing.
Mm-hmm.
Do you see where it says landlord? On the very last page, page 22, I believe.
Page 22. Okay, one
It'll be
second.
the very last one.
Yes. Okay, I see it. Okay. Mm-hmm.
It says, you see where it says landlord?
Mm-hmm.
And who signed under FloShea at the Point LLC?
Shay Embry,
And what was her title?
managing member.
And you see where it says tenant?
Yes.
Okay, and who signed for tenant?
John Wesley and Thomas Woodard.
Now let's go back to page 3.
Okay.
When you look at where it says demised premises, you can pull it up now, I'm sorry. So maybe we published to the jury, Your Honor.
Sure.
Mm-hmm.
You see where it offers a definition for demised premises?
Mm-hmm.
So hold on one sec. Mr. Woodard, when you are answering questions, if you could say yes or no, or maybe, whatever the answer is,
Okay.
but the mm-hms are real hard for a
Okay.
court reporter to translate, because that could be mm-mm or
Gotcha.
mm-hmm,
Okay.
or something in between. So pick your words, but make sure you're using words to answer the questions.
Yes, sir.
Thank you.
I'm sharing it, but there's a lag. It's saying you're sharing, but it's not showing. It's a lag.
Well, it's a really long lag if it's not up yet. Video sometimes lags a little bit, but
Oh, yeah, this is on.
It's on. It showed originally, but
but what's shared is you're not sharing the right thing. What you're sharing right now is your Windows Explorer. In other words, the list of files as opposed to the actual file. You don't want to share that screen with us. You want to open up the exhibit and then pick that from the, when you do share screen, there'll be a tile that represents Exhibit A. That's what you want to share.
Can you just pull up the lease by itself?
Won't let me do it.
Stop share. Try it again. Share screen. Click on it now. Now click on the lease. There you go.
Excellent.
Teamwork, Your Honor.
Mhm.
All right, let's go down where it says, let's look at a couple of definitions that are defined in the lease. Where it says building, what does that refer to as defined in the lease?
Means collectively all of the buildings and related improvements located on the land in which the demised premises are located.
And what does demised premises mean under the definition of the lease?
Meaning that a certain space located in the building containing approximately 693 square feet of floor area. I say which floor area footage shall be the basis for the calculation of the base rent as set for herein, as shown on the site plan, and it says attached here to Exhibit A, and by this with reference incorporate here some.
And is it your understanding that that demised premises, the site plan, was the area in which you were to occupy?
Yes, sir.
In which Thomas LaVone LLC would use as its business?
Yes, sir.
Let's go a few pages over. Now, were you required to provide a security deposit in advance of moving into the space?
But when we've agreed to the space, we gave a deposit, but it wasn't in advance. Deposit wasn't in advance. We eventually paid the deposit when we came down because we were still living in New Jersey at the time we signed the lease.
And was there an issue with the payment of the security deposit?
No.
Was the security deposit paid in full?
Yes.
And it was after you came to Atlanta to move into the space?
Yes.
Now, you moved into the space in December 1st of 2019?
Yes.
Correct? Now, can you tell me, did anything happen in February of 2020 that you remember?
Yes, we started having issues. Basically in February, if I recalled, there was she had replaced the electrical box.
Well, we're in 2020
Okay.
right now. So you move into the space in 2019.
Mhm.
Did anything happen in February or March of 2020?
No, it was fine then during that time.
What about globally with your business? Did anything happen in February or March of 2020?
No.
Were you and your business at all impacted by the COVID pandemic?
We was impacted, but we still was able to pay our rent. So we paid our rent ourselves with no grant money or nothing. We still paid the rent. It was, we was impacted, but we still was able to thrive and take care of business.
So during the pandemic, when things were shut down, did you get a reduction in rent of any kind?
No.
And were there any issues with paying rent while the COVID pandemic?
No, not at all.
I want to take you to page 7 of the lease, under Article 3, where it says condition of demised premises.
Okay.
Can you explain, or can you read that to the jury so you can understand exactly what it was you were accepting in terms of the use of that particular location?
Tenants agrees to accept the demised premises in the present as is, where is condition. Landlord should not be obligated to make any improvement to the demised premises or building, notwithstanding anything to the contrary contained in the implied in this lease. Tenants agreed that except as specifically and expressly provided therein, tenants will accept possession of the denied premises and as is, whereas conditions during the terms and that no representation, warranties, or inducements which with respect to any condition of the demised premises have been made by the landlord or its designated representative to tenants or its designated representative. Tenants agreed to and acknowledge that the tenant has an opportunity to inspect the demise premises.
And prior to moving in, did you inspect the demise premises?
Yes, we did.
And did you accept the conditions of it as it was?
We accepted as it was. We did accept it as it was.
Now I want to take you to Article 6 on page 11. It says repairs and maintenance. And let me go back, Mr. Porter, just to ask a question. And you were in this building in November of 19. Were there any issues in 2020 or 2021?
Well, the issue that we found that she did replace the Jesus Lord, give me the right word, the venting system, because when we was in there working, it had flooded while we was literally in there working. So she replaced the venting system, the whole HVAC system in there.
And when was that? Do you remember when that occurred?
Oh God. That was probably like a year after we got it. It was during the time we moved in. The HVAC system went crazy and it flooded out before we moved our stuff and we was actually doing a build out. And that procedure happened. And she replaced the whole HVAC system.
And that was replaced. And then subsequent to that, were there any issues prior to 2022?
No.
So you were in there for a little over 2 years and there were no issues.
Right.
Can we go to Article 11, repairs and maintenance?
Mm-hmm.
And just read section 6.1 for the jurors' consideration.
Within a reasonable period after receipt of a written notice from the tenant of the need thereof, the landlord shall make necessary and structural repairs to the exterior walls, excluding the exterior of any frames surrounding all windows, door, glass, door fronts, and signs. Of the demise premises, necessary repairs to plumbing, pipes, and conduits located outside the demise premises or in the common area, and needed and necessary repairs to the common areas. Landlord should not be required to make any repairs where such repairs are made necessary by any act or omission or neglect of the tenant. Any substance or concessionary of tenants or their representative employees, agents, invitees, licensed or contractors, or by fire or other casual or condemnation, except as provided in Article 8.
And so what's your understanding of what this particular section required of the landlord?
But when I read this, is for me, my perception is that the landlord she would make the necessary structural repairs to the exterior walls. Plumbing, the piping, conduits located outside of the demise building or in the common area.
And did there come a time, I don't want to go into it right now, but did there come a time where you provided the landlord written notice of issues in the building that needed to be repaired?
Yes, we did.
And do you remember when that was first brought to her attention?
That was the beginning of 2000 and I think it was 2022. We were texting back and forth about the electrical box having a wet line going across it. And I know that's from my experience working with OSHA, that's a violation.
So let's talk a little bit about this. Where did this electrical box come from? When did this happen?
Shay installed the electrical box because we found out the city had pretty much told her she had to update the boxes because they were old boxes with the round screws in them. Yeah, so she had to update the boxes. And when she did update the boxes, according to OSHA law, a wet line has to be separate from the electrical line. And she just ran it across the electrical box.
And was there a point where you brought that to her attention?
Yes, we was going back and forth for about a year. And she said she would take care of it. A couple of times she came in and tried to take care of it. She took the line and put it underneath the electrical box. And I told her that's still not acceptable. It had to be on a separate wall, as OSHA says that you have to comply with.
And what happened subsequent to that?
It was never fixed. It was her going back and forth, kept saying that she's gonna send the guy. He never came. Every time I would take the alarm off the door for her to come in, he would never show up. She would never show up.
And did there come a time where there were any other issues that you brought to her attention that needed repairs?
The plumbing situation because of the backup from the rain, and the water was coming from the weep holes in the building.
And how did you bring that to her attention?
Well, the day it happened, we were so shocked to see so much water flooding in, because the day before we came in, we noticed that it was like a little wet spot. We was like, okay. Then it rained really heavy the next day. And then we noticed that it was just a flood of water. It was so much water in there, it covered my whole shoe into the place, and it covered the whole floor. So we saw her outside, we brought it to her attention, and she just waved us off and just kept going.
And what did you do following trying to bring the water flooding issue to her attention? What was your next step?
My next step was to try to reach out to get help from somebody, because we knew at that point that she waved us off. It was not important to us. This is 20 years of work that just getting wet, and the gowns are getting wet, everything is getting wet. So we thought the best thing to do is to seek help.
And who did you seek help from?
Originally, we went to was prepaid legal, and they referred that counselor to us.
And who was the counselor? Do you remember the name?
I don't remember.
There's a name, Terrence Burrows.
Yes.
And I'm saying that you were assigned Terrence Burrows through prepaid legal.
That is correct.
And so did there come a time where he tried to reach out on your behalf to Ms. Embry to try to get the matters of the electrical box, the flooding issues resolved?
Yes.
And did you also look at other alternatives under Georgia law and to see what your options might be?
Yes, I did. We did look under other attorneys. We tried to reach out to the counselor and all the proper people in the proper places. We started out with her, of course, but then we was not getting anywhere with that results. And meanwhile, in fashion, every day that I'm not doing, I'm losing money every day. So fashion is not like a regular business 9 to 5 where you can make up once your business is damaged. So we was trying to reach out to her to get her to respond, even to clean up the water. Nothing. We had to clean up the water ourselves.
And okay, I was going to ask that question. It's just what did you do? I mean, while you're trying to run a business and it's flooding and there's an electrical box issue, what was your next step?
My next step was to try to get legal aid, but we cleaned up all the water. We cleaned up everything that we could clean up and that we can do legally. We did on our behalf, and it came out of our pockets.
Now, did there come a time where you deducted a portion of your rent due to the issues that you were having to clean up and deal with?
Well, basically, that's one of the things we had spoke to her about, saying, how do you want to handle this? Do you want us to, go ahead and take it from the rent, or do you prefer you go ahead and do the repairs yourself and we continue paying the rent? Nothing.
So was it your understanding under Georgia law that you could make the repairs yourself?
Correct.
And deduct it from the rent?
That is correct, sir.
And had Ms. Embry brought, prior to 2022, had she brought or complained of any issues regarding payment of rent, partial payment of rent, or late payment of rent?
Never. She never spoke to us about any late payments. We was not even given no late payments. We addressed her because we had moved and sold our home. She knew that we was in the process of selling our home. She understood that what we was going through, and we explained to her from the beginning, hey, we may be a little late because we're moving and we're trying to relocate. And she was like, fine, that's no problem. I'm not going to charge you no late. I understand you guys moved from New Jersey. There was no issue. And my partner, he worked while I make the clothes as well. So when it was time to pay rent, John would pay the rent. He would handle that portion of it. And we had spoke to her, say, hey, it may be a little late here or there, but it was never late to the point. And she never had a problem with it. She's like, you guys are good. You always pay your bills, your rent, you're good. She never had an issue with it.
Was there a time where you deducted the amount of the repairs from rent? And if so, when did that happen?
Well, once that flood took place and everything took place, we just held on to the rent. We was like, let's just hold on to the rent, see if we can get a response from her. We still didn't get a response. So eventually what we did, we just sent them the rent anyway, regardless, knowing that we were still out, can't even use the building. We still sent them the rent regardless. So the rent was paid up the part.
What date would this have been? What time would this have been in the March and April?
March and April, yes. We had sent them all the rent.
And when you paid rent normally, I think you said Mr. Weston paid it. Were there receipts or invoices provided? Were there receipts for payment of rent so you could keep track of everything?
Well, basically, they had a system where they would take it, John informed me, they would take it to the house and just put it underneath the flower pot, to Bobby's house and put it underneath the flower pot. That was remedy. We talked about trying to do a payment, through some type of transaction so you can see, whether it be through credit card, through whatever. But at that time, she was not taking it that way. She wanted money orders.
So did you all pay in money orders?
Yes, we paid by money orders. So we have receipts from the money orders as well.
And what about checks? Did you use any checks to issue payment?
I don't remember no checks. It was always been money orders. We always did money orders, never checks. No.
What? And it would be left under the flower pot, but you wouldn't receive a receipt demonstrating that you had made payment.
No.
So as long as you weren't getting kicked out, you assume payment was good.
Everything was fine.
And did you receive emails or related issues prior to 2022 when you brought these concerns to her? Did you receive any emails or text messages from Ms. Embry complaining about the way in which you all were paying rent?
No, not at all.
Now let's talk about 2022. I want you to take a look at Exhibit B.
Okay.
Do you recognize this document?
I don't recall it. I don't recall. Like I said, basically John handles the rent, so I don't recall.
You don't recall this particular document?
No.
So you had never seen this document before?
No.
And I don't mean before today, but prior to being removed from the premises, you had never seen this document?
I have never seen it.
Now, can you tell us a little bit about what was in the location, like what was actually in the location of your store, Thomas LaVone LLC on Cascade? What was actually in there?
Basically, what was in there was everything that we brought down from New Jersey: fabrics, industrial sewing machines, tables to work on, your drafting table, garments was in there, cameras, light rings. I mean, the whole shop was TV monitor, speakers. Even we had crystals that was sitting on the desk, that's Baccarat classic crystals that we have set on the table. So it was a numerous of things that was in there.
And what about your designs?
There was every design I ever done was in that location.
And how many years worth of designs did you have in that location?
20 years.
And were there copies of those designs anywhere?
Those are original designs, one of a kind. You will not have a copy of them. No, those are original.
And did you have orders being fulfilled for those designs?
Yes.
I want you to take a look at plaintiff's exhibit C. Do you recognize that document?
Yes.
What is it?
This is our online inventory that we keep. And it lists everything that we have in the shop and the price points.
And was this kept in a normal course of business?
Yes.
Have there been any changes or alterations to it that you can tell with respect to when it was provided and today?
There's no changes.
How do we know what point in time this is a snapshot of, Mr. Woodard? I don't see any dates on here, but I'm not familiar with.
This, I haven't been back on my website except for when it initially happened. We had to shut it down. I'm
sorry, I didn't mean to interrupt you.
Well,
Did you-
but I have a question that needs to be answered before you go on another one. I'm looking at Exhibit C. You're looking at Exhibit C. And it's not in evidence yet, so I won't discuss its contents. I'm trying to understand how you would know by looking at this, whether this represents a snapshot from 2020, 2021, 2022.
If you can, to bring you up to date, how you can really tell, basically, if you look at the pictures which I'm pretty sure will be shown later, of the product that was in the place, you will see some of the same items that's on here that was currently in the place when things was taken out. So you will see that these items are in the location.
Okay.
So that's letting you know these items are current. And the only thing we do, we put out current items for our clients to purchase. It wouldn't make no sense for me to have this on the website and then a client try to purchase it and it's not there.
Understood.
So that's how we was able to keep track of everything.
Okay. But this specific listing, do you have a way of knowing that was current as of the time you were removed from the premises, or whether this happened to be a snapshot from 2021 when you may have had a slightly different mix of merchandise?
This is current because I see the pleated high waist, this skirt. I can see some of the items that I know I've done currently that's from this current season. That's another thing. I'm glad that you did say something. It's about this different seasons with designers. So I'm looking at this and you can see everything is the current with season. This is the current stuff that we had listed in that place.
Current as of the time you were removed from the premises,
Right,
not current today.
Not current
Got it.
today, the time
Okay.
was moved from the premises.
All right, thank you.
Mhm.
Back to you, Mr. Sterling.
And was this printed out at or around the time when you were removed from the premises?
Yes.
So you printed this out to track what may have been in there or what was in there at the time you were removed.
That is correct.
And has there been any changes to this document that you can tell?
None.
We would move for admission of Exhibit C into evidence, Your Honor.
Any objection to Exhibit C?
Your Honor, we have similar concerns that just because inventory is listed on the website, that doesn't mean that it was in the actual premises on the date in question or any of those dates in questions. With that as a caveat, we're happy to cover that on cross.
Okay, yeah, so I'll admit this as what it's purported to be, which is an online list of inventory, and then the jury will give it the weight it sees fit to give based on other evidence that's presented. So Exhibit C is admitted.
Thank you, Your Honor.
You're welcome.
Publish, Your Honor.
You may.
While Ms. Camacho is publishing that, can you just talk a little bit about exactly what these items are and what it is? So I think the jury will get a better understanding of exactly what it is you do.
Okay, basically, these items are all the garments I made myself. I do the grading and I do the sewing myself. So all these items you see listed on here are items I made myself. Like I said, I made the patterns, I grade them up to different sizes as well, and I execute the sewing. I do have sometimes outside help that will actually assist me, but majority of everything you've seen on here, matter of fact, everything you've seen on here, I made myself directly.
So when we look at, for example, let's look at one of the items so we can just understand. So you make these items and then you provide an inventory list online for individuals to order?
That is correct. They can go online and purchase them once I complete the order.
And these are all your handmade original designs.
This is true, yes.
And so if I wanted to buy something for my wife at the time, I could go on here, press a button, order it, and then you would deliver it to me from your shop.
That is true, yes.
So let's look at page 4, for example. The very last item, the open neck gown.
Mm-hmm.
So at the time, this would represent that you had 18 of these garments you had created that you were selling for $3,500 a piece.
That is, yes.
And that was in the building at the time that you were removed.
Yes.
Now, did there come a time where after your removal from the building that you tried to continue operating your business and requesting a business license from the city of Atlanta?
Yes, we did, but we couldn't receive it because we're not in the physical location anymore.
Now, tell me exactly how that process worked.
Well, basically, you have to, the business license, you have to get business license from the state of Georgia. And you have to provide them with certain information. And one of the information you needed is actually a brick and mortar or your business and the location. And we could not provide them with that because we was no longer at that location. So we couldn't get the license.
And did you receive an official communication from the city of Atlanta explaining why you couldn't get a license?
Yes.
Do you remember who sent you that?
I don't recall.
Was it someone in the city of Atlanta's Department of Finance or your business permitting department?
I really don't recall.
Well, would you take a look at Plaintiff's Exhibit D?
I'm sorry, repeat that again.
Would you look at Plaintiff's Exhibit D and see if that refreshes your recollection?
Yes.
Do you recall who you received that from?
Now I recall it when I see it, yes.
Who did you receive that communication that because you were no longer in a building, you couldn't get a permit to continue operating your business?
Felicia Winfield.
And what
Felicia Winfield,
and what department was that from?
the Senior Financial Analyst, Office of Revenue.
Now let's talk a little bit about the physical location that you were in and the renovations that were made at the physical location.
Okay.
You talked earlier about accepting the property as is that right?
Yes.
And did there come a time where you accepted the property as is and made renovations to improve it for your business?
Yes.
Tell us when that happened.
That happened when we first moved in. The first 3 months, we were not open. We was literally actually renovating the whole inside of the place. The place was not renovated. The bathroom, everything was out of code spec. It was not up to par that you could not even open the business. So we had to literally just tear down nearly everything cosmetic and do the repairs. And we had to open the bathroom, make it wider because it was not big enough for handicap.
Did you take a video of the shop prior to the renovation?
Yes, we have.
And did you provide that video? And did you personally take it with your cell phone?
Yes.
Did you label it as shop prior to renovations?
Yes.
Would you look at Exhibit E? It's the thumb drive. It's actually the thumb drive. It should be right there.
This one here. Where I need to put it.
Did you bring the video to my office so that we could put it on a jump drive?
Yes.
And would you look at how that jump drive is labeled and see, and does it properly label it as shop prior to renovations?
Yes.
And has that been altered or changed in any way to your knowledge?
No.
Your Honor, at this time, we would like to introduce into evidence a video of what the shop looked like prior to renovations.
So that's E, Exhibit E?
Yes, Your Honor.
Okay, and which of the color coded?
I believe it's the pink one, Your Honor.
Okay, great. Any objection to Exhibit E?
Subject to actually seeing the video? No.
You've not seen it before?
Have we seen this one before? Then no objection.
Okay, I hope it's what you've seen before. Okay,
I don't have repeat.
It is.
okay.
I wouldn't do that.
Well, we'll find out. He is admitted.
Thank you, Judge.
Before you press play, is it audio or just video?
It's just video.
It's
this
just
particular-
Okay, great.
And just tell us what we're seeing and explain to
This
the
is
jury
the
what we're seeing.
corner of the place when we first located the place, we first saw it. That's the condition it was in. You can see that that's the office on to the side. The electrical, you can see all the wires hanging everywhere. I mean, you can see the pole that was sitting in the middle of the place where you first walked in at, and that's the bathroom looking straight back. That was not up to code. You see the walls, the ceilings. This is what the place looked like when we got it.
And you understood, based on the lease agreement, that you had to accept it as it was.
As is, yes. So, yeah, this was, we took it as is.
Now, did the lease agreement give you the opportunity to make improvements and renovations?
Yes, yes.
And did you speak to Ms. Embry or her representatives about what improvements and renovations you wanted to make?
Yes, we did.
And were they approved prior to you all making those renovations?
Yes, they were. She even offered to actually to do the build out for us, but we got someone else.
And this is the entire space as it looked before you moved in.
Mhm.
And did you also take video of the process of the renovations you did
Yes,
to document it?
yes, sir.
And when did you all start to make renovations to the building?
We started probably a couple weeks after we was given the keys. We started just by taking out stuff that was in there, little stuff that we can take out, you know, the cabinets and things like that, that we know we could just knock down ourselves. It was cosmetic things. You know what I'm saying? Anything else outside of that, we got professional help to do.
And again, that was pre-approved by Ms. Embry.
Yes, yes. She want to explain to us that we had to do our own build out.
And would you look at, and taking that video, did you take that with your cell phone?
Yes, sir.
And you documented it of what those process of those renovations looked like at the time?
Yes, sir.
Would you look at exhibit I? And Your Honor, just for the court's, I know I'm going a little out of order in terms of the exhibits, but
As long as they're labeled, you go in any order you want. Before we ask questions about I, was E a video you had seen before?
Yes, Your Honor. No objection.
Great, so we're all in the same universe. All right, back to I.
This big one.
do you recognize exhibit I?
Yes, I do.
And tell us, what is exhibit I?
Exhibit I is what the place looked like after we started doing the cosmetic build out.
And has there been any changes or alterations made to the video or rather the pictures you took? I said video earlier, I misspoke, to the pictures that you took on the process of renovations.
No.
You know, it's just,
So the exhibit list says Exhibit I, process of renovations, parentheses, video.
it was a mistake on my part. Your Honor.
Okay.
It's just the picture.
It's the pictures. There's not also a thumb drive that corresponds with it.
No, Your Honor.
Great.
At this time, we will move for admission of claims exhibit I into evidence.
Mr. Williams?
And it's 4 pages? Is that
Yeah,
correct?
That's correct. That's correct.
No objection, Your Honor.
Admitted.
Walk us through, let me pull it up. Well, may we publish, Your Honor?
You may.
Walk us through what we see here on each page of exhibit I.
The first page you're seeing is where you first walk in the door. That was the greeting area. The wall where we had pretty much decided we're going to put the garments on one side of the wall, and there was another side of the wall. But exhibit I is where you first walk into the door where the big columns is at. We had to knock down, and that's what we did. And we also redid the wall. That wall took us forever. We chiseled by hand that wall to get all that I don't know what you want to call it, on top of it off, because it was actually platted onto the wall. So we did this literally hand by hand, day by day, towing with a chisel and a hammer to get this wall to look like this and do the German smear on it.
And take us to the next page.
The next page is the bathroom, which you guys saw earlier. That bathroom was definitely out of it. It's not up to code. So we made sure the bathroom was up to code with the proper sink, the proper toiletry that's working properly, and made sure that it had enough room for handicaps to get in there if it needed to be.
And then what about take us to the next page?
Next page is the, actually, that's just what we, when we was doing the floors, we wanted to put the couch somewhere. So we set the couch on top of the room where was actually built out just to put stuff on top of there. But pretty much we was doing the floors and cleaning up and getting the lights up. As you can see on the corner, there's white lights in the corner. That's because we was installing the lights as well, new lights.
And then take us to the last page.
The last page, again, that's the wall that we did the chisel out on. As far as that glass there, that was already open. Only thing we did was did a new glass. That was already there. That was already open like that. Only thing my guy did came in and put in a new glass. So, in response to this is the glass we put in, and that's the wall that we continue chiseling by hand to give it that aesthetic that we wanted.
Did you cut through the wall? Or?
We didn't cut through no walls. We did not do any of that. So there was a back door on the premises that was so unsafe that you couldn't even get it unlocked. And we told her about that. You know what I'm saying? So we didn't cut through no walls or anything. There was a back door already on the premises. This what you're seeing on this last page with the glass up here, it was already glass there that was old. We just installed and made up-to-date ones. And also, if I may say, if you look at the bottom of the page, there's the weep holes where the water was coming from at the very bottom above the boards. Those are weep holes. Those little square things. Those are weep holes.
And this was when you were in the process of doing the renovations.
Right. We noticed the weep holes was behind the walls.
Now, in 2019, 2020, 2021, did you ever experience any flooding in the building?
No.
When was the first time that you experienced flooding in the building?
I don't know the exact date, but it was raining so heavy. It was last year. It was, I think it was sometime in March. It was just raining so heavy. That time it was raining so heavy. And like I said before, we came in this shop to work and we noticed that there was a wet spot. And we was like, okay, that's weird. Where did that come from? But then the following day, when it poured down rain, we didn't have to wonder no more. The water was running through the weep holes. It was running in so much that we couldn't even stop it. We was trying to stop it by every means. We couldn't even stop it. It was running so fiercely.
And was there any construction or any issues happening to the adjoining property that impacted what was happening to your property?
Yes, Shay partnered with another young lady by the name of Deborah, and they opened a restaurant. And they had to do some type of plumbing, which was supposed to have been done to the building prior, and it never was done. And so once she did that, that's when all the flood just kept coming. It just kept coming. It got to the point it was coming up off the sidewalk, coming down the sidewalk into our shop as well.
And did there come a point where you spoke to Ms. Embry about this?
Yes, we have.
And what was her response?
No response.
Did she ever email you back regarding the issues that you brought to her attention, saying you have to accept it as is?
When all this stuff was going on, I texted her personally. We were going back and forth, like I said, for a minute, back and forth. In the email, she kept promising that she would get it taken care, and it never got taken care. Then we went to the point after a while, it's as is. But at first you promised that you will get it taken care.
Did you try to document what you were experiencing, the water?
Yeah, that's why we filmed everything, tried to film everything to keep everything on record. Basically, even down from her Texas, just kept everything together and filed on record.
And did you personally video the flooding and the issues that you were experiencing?
Yes, I did. Yes, sir.
Did you do it at the time you were experiencing it?
Yes.
Did you keep a true and correct copy of that?
Yes, I did.
And did you bring it to me so we could put it on a jump drive?
Yes, I did.
Would you look at exhibit F and exhibit G? Did we label those jump drives?
You said exhibit F?
Yeah, exhibit F, I'm sorry, not exhibit F, sorry, exhibit G and exhibit H.
G. Yes,
And then we properly label those jump drives.
yes.
And what was the label assigned to them?
Store, wall, and door, and store.
Has that been changed or altered in any way since
No.
we put that video on those jump drives?
No, sir.
Can you see any material changes to the video, to the jump drives? Are they in the same condition as when we reduced them to the jump drives?
Yes, sir.
Your Honor, at this time, we will move to enter in exhibit G and H into evidence.
Any objection to G or H?
Subject to showing the videos now.
Okay, assuming they're what we think they are, they're admitted?
These do have sound on it, Judge. I don't know if you want me to take the sound off.
No, I only was asking because you have to click a special box when you're sharing video to also share sound. I just wanted to make sure Ms. Camacho had checked that. They're in for what they are, and unless there's hearsay in there that ought to be excluded. And Mr. Williams, any reason we shouldn't just press play?
We would want to hear what it says. Press play.
Okay, great. So do you see that little box when you're sharing the video down in the corner? I don't remember if it's left or right. It says something like share audio with video.
No, I don't see it. Let me see. Audio. Oh, yeah, I do. Share
Great,
sound.
make sure that's checked. And G and H are admitted.
Tell us, why don't we watch the video?
Right, don't talk over the narration if you want.
Outside of the walls. The water is pouring in from outside of the cracks in the wall. It's coming in from the outside of the walls. So I don't know where this is coming from. I don't understand. But this is terrible. This is really terrible. I mean, it's pouring in here. This has never done this before, never ever done this before until recently. So I don't know where this is coming from. I can't even control how much mopping up of this water that's coming in here. It's coming in from the front window as well. It's just pouring in here. I don't know what's going on with this. This is not good. It did it the other day. This is the second time it's done this. It's just pouring in here nonstop. So it's got to be coming from the roof down the side of the walls inside. Because it's coming from inside of the walls, just pouring in here. I have to use all my stuff. Thank God everything is up off the floor. I'm trying to make sure everything is off the floor. The other day, down with our paper, dot paper, we have to throw all that out. You understand? Now this, you understand? Thank God we do everything. I mean, it's just pouring in here from the roof. It's got to be coming from the roof because it's literally pouring in here.
So if there's another one with audio, you want to mute your machine.
I don't think the other one.
Okay, you want to mute your machine anyway because we're having that great reverb.
There you go.
There you go. All right, thank you.
So whose voice is that?
That's my voice.
Were you upset at the time?
Yes, I was very upset.
And just tell us, when was this video made, or around the time? You remember approximately when this video was made?
This was, again, I don't know the exact date. It was in March during the floods when we was having a lot of rain in March.
This March of 2022?
Yes.
And in the video, you say you had never experienced this before.
Right.
Did you start to first experience this after the construction?
After the construction, that's when it started just flooding in. It just started flooding in because on the outside, where she was working at, she left it undone. So it was muddy and everything else just running in from the outside. And as you can see, those are weep holes. Those are coming from another direction than, you know.
So the renovations you made, you and your business partner made, were in 2019 and 2020?
Correct.
And then the construction next door, when did that begin?
That was in March, April, I believe April, March.
Of 2022?
February, March, and April, somewhere they were doing repairs, probably even before then. But far as the repair for us, the water line, she had some water company come out and dig up the whole ground right in front of us and everything else, because we told the issue we was having with the water. We had a professional plumber come out and said, no, the water lines need to be fixed, which was never fixed. So it kept backing up into the place. So we found out, okay, it was the water lines. And then she began, before it started back up in the place, it was the water lines. We was having little issues, the little water coming in. Before it to flood like it did, that was after she did the repairs. It started flooding in like it did. It would be, like I said, little spots, like I said, that would dry up, but nothing like that ever happened to us.
And you brought this to her attention in writing per your lease agreement?
Yes, I brought that to her attention.
And then let's play the next video, Exhibit H.
Sorry.
I think we have to play the sound on this one as well, y'all. We might have to go back, make sure you add the sound.
I did, I clicked it. It's probably edited out. He said to mute it. There's no sound on this one.
And tell us what we're looking at, Mr. Wood.
What we're looking at is another day of flooding. I just came in and I started sweeping it out. You can see this time it just kept getting worse and worse. This is the next day of flooding. I had to sweep it out this time. It was so much water that came in. And then it was another day after that of flooding. But this, what we're looking at here, is actual flooding that took place from the weep holes again.
And that's you sweeping it out?
Yes.
And this is inside your shop?
This is inside the shop.
And you're trying to sweep the water out into the front, out of the front door?
That is correct, as it still was coming in.
And this happened, this was the second time this had happened?
That is correct.
And what did you do the second time it happened? What steps did you take to try to?
I was very upset at this point in time because we couldn't get a response back from Shay at all, or Bobby. We couldn't get a response back from neither one. So at this point, I was really upset at this point in time. And I told them we just have to probably seek legal counsel because they're not responding back to us. So what more can we do? They have our rent money. We gave them the rent money. So I didn't know what more to do at this present time.
Now, did there come a time where you will put on notice that we're going to terminate your lease?
Well, during this time when this is happening, no, she didn't send us anything at all. You know what I'm saying? Pretty much. I didn't receive anything from her. She didn't say nothing. We're still going back and forth trying to talk and get things done. I've heard we didn't get nothing back from her.
When was the first time you were put on notice that your lease was going to be terminated, or they were going to lock you out of the business?
The day they came in the shop.
And what day was that?
That was that Friday, April the 29th or the 28th. That I think it's the 29th. It was the Friday.
And whatever, April 29th, 2022?
Yes.
And who was at the shop that day?
That day was myself. I was in there working. I had a client that had an event that day, so I was in there finishing up her dress that she had ordered. And there was another young lady named Deborah. She was in the shop. She went out to go get us lunch, and she just said, "I just saw your quote unquote." She said, "I saw your girl Shay sitting talking to a police officer." I was like, "She can talk to one, so it's okay." And then she came back in, and then after she came back in, we was in the back eating, taking lunch. And we heard the doors unlocked, and that's when we saw her walk in.
And was anyone else with her that day?
She had another gentleman work with her that's from Ben Hill Electrical, sketchy looking guy that was with her. You know what I'm saying? That was with her at the time. And then she had already called the locksmith.
And what happened?
And she had the police officer with her, a Atlanta police officer. And he proceeded to tell me, you got to leave. You got to leave. He never introduced himself as a police officer, never said anything. He just said you have to leave with his hand on the gun. So I'm not going to argue with nobody got their hand on the gun. I'm going to leave.
And then what happened next?
Then afterwards, I left. I went back in there. I grabbed a few things You know what I'm saying? That was important that I can grab, that she allowed me to grab, and that was it. I left. And then I wanted to call his sergeant, the police sergeant back, and he was like, no, you can't do this. You can't. So Shay agreed to give us to Monday, and Bobby agreed to give us to Monday to go down to the court system and see if any paperwork was filed. They agreed with the police officer. They said they won't do anything till Monday after 4.
Let's get this timeline correct. All right.
Mhm.
You're at the shop on Friday, April 29th. That's when the locks are changed.
That is correct.
Prior to that, you had not personally received any communication about the termination.
No, not at all.
You're having lunch with a client in the shop.
That is correct.
The locks are changed.
First, she unlocked the door, and then they were locked. The door was locked originally, and she came.
Make sure it's yes or no rather than mhm.
Okay. Yes. I'm sorry. I'm so sorry.
And
I'll work
so,
on that.
the police officer tells you, you've got to get out of the building because
Yes.
she's exercising her rights to terminate your lease and you've got to get out.
Right. Exactly.
So you called his sergeant or a person who's above him
Correct.
and you talked to Shay and Mr. Flournoy. And this was on a Friday, April 29th.
That is correct with the police officer.
When did they say you could come to the shop to get your things at that point?
We all had came to the agreement that we'll wait till 4 o'clock on Monday, which is the 2nd. That gave us enough time.
4 a.m. or 4 p.m.?
4 p.m. in the evening, in the afternoon. They gave us enough time to go downtown because the police officer told Shay, if you did not file the paperwork in their sheriff department, you cannot just put them out the way you're doing. So she agreed, her and Bobby both. Bobby explained, I'm just an innocent bystander. I'm just going to be the one to have the key. Make sure I hold your things. Nobody will bother your things. Bobby promised us this in front of this police officer. And of course, that didn't happen.
And did you take a video of the police officer?
Yes, I did.
Did you take it at the time on that Friday?
Yes, I did.
Do you remember the officer's name?
His name was Officer Vanillery or something to that nature. He was his sergeant that came back and chastised him, saying that you were wrong in what you did.
And when you took that video, did you bring it to my office so we could reduce it to a jump trial?
Yes, I did.
When you look at Exhibit F, the jump trial Exhibit F?
Yes.
Is that the jump drive that we put and that we labeled and put the off-duty officer video on?
Yes, sir.
As far as you can see from the outside of it, has there been any alterations or changes to it?
No, not at all.
Your Honor, we would move to admit Exhibit F, off-duty police officer video into evidence.
Any objection to Exhibit F, Mr. Williams?
Subject to showing it, no, Your Honor.
It's admitted.
Can we publish it on?
You may.
I don't have to play the sound, it's gonna double.
We can play
I think there's sound for this one.
Oh, yeah.
Yeah,
we have
it's
to-
gonna double, yeah.
Well, it won't double. You can keep yours muted. You
Okay.
just don't have your audio on. Make sure you check the magic box and then it should play over the court sound system. Should,
Share sound, yeah, it's muted.
or it just might shock you.
You hear nothing.
It does have sound, Your Honor. It's not.
I would have to press my sound for it to work. It's just
Okay,
gonna-
well, the other one you played, the sound was coming through our system. Yours wasn't muted, so we got that fun echo. It's real short, so if you want to have it pushed through both, that's fine.
I apologize for anything that's not done.
And his last name is M. Muhammad. And what's your first name? Or you just need the last name? Okay, Muhammad with the ED.
And just confirming, so he was off duty?
He just said it,
All right,
yes.
correct.
And he was
All right.
hired by her.
All right,
Thank you,
thanks.
Mr. Muhammad.
And this is this is the police officer who escorted you out of the building that day while you were with your client.
That is correct.
And he was off duty, is that right?
That is correct.
Hired by Ms. Embry to escort you off.
That is correct.
And he confirmed all of those things to you.
He confirmed.
Now, who told you, Who told you that you had until Monday at 4 o'clock to come and remove your thing?
His sergeant, who actually we all sat with, agreed, and Bobby, Shay, and I, John, we agreed. But the sergeant said,
Before you go
okay.
further, just give us a description of who was actually in the meeting, what witnesses were there in the meeting when that happened.
It was a few witnesses that's outside. It was myself, Shay, Bobby, both police officer, Dana, Donovan. They were all there. When the police officer explained to them, they need to go downtown and look for see if you filed the proper paperwork to have them evicted. Shay agreed. Bobby agreed. Bobby said, quote unquote, I will have the keys. I won't let no one in to take your things, but you have to 4 p.m. on Monday to get back here with that paperwork or whatever the case may be, or we're going to have to put your stuff outside. So we agreed.
So tell us what happened on Monday.
Monday, I'm sitting at home. John is getting dressed to go to do the research on the paperwork. I'm going to head down to the shop just because we got to move the stuff. And before we can leave our house, my alarm system go off. I get a call from a police officer and says someone has invaded your space and your alarm system is going off. So I told police, no, you need to go there because there should be no one in there at this present time at all. No one. Well, I ran from my place because it's not far from where I live at. He was already in the midst of going downtown. So in the process, I called him. He called the commissioner, you know what I'm saying, to get her over here as well. So by the time I get there, I run down there, all the way from my house, run down there. It didn't take me long. I used to run track. So I ran down there. And then when I got there, they were inside the building, taking things out of the building, stripping things off the wall, taking the recording system, because they knew the last time they entered, that's how we had a recording. So they took it this time. So they took everything out of it. And then they was driving off in cars with it. But it was nothing I was able to do besides watch 20 years of work just walk up from right in front of my face.
Did you ask them, can I get my property?
I begged them and they just kept going. She just acted like she didn't hear us. Bobby was in there, which he gave his word that he would not do. And you can see in the video that he was already inside the place with them, helping them taking the stuff out.
Now I want to talk about a little bit about what was taken. Take a look at, did you take pictures of things that were sold and clients you serviced within the shop?
Yes.
Items within your shop, the storefront, did you take pictures of those items?
Yes.
So we can have an idea of what it looked like and what you sold?
Yes.
And look at Exhibit K.
You said exhibit who? K?
Exhibit K. Can you tell us at or around the time that you took these pictures?
This was during the time we was doing our grand opening. We had did a fashion show on the green spot. There was, we invited some of my celebrity clients. I invited some of them down to come out to support the event. We wanted to do something out for the public so the public could be aware that we're here in the community. So we did a big event outside, free to the public, free everything, just to get the public aware of who we are and basically what we're doing in the community.
And are these accurate descriptions and pictures of that opening and that process and your storefront?
Yes, there's, yeah, these pictures are accurate.
Has there been any alterations or changes made to these pictures that you took?
No.
During at this time, we would ask for admission of Exhibit K into evidence.
Mr. Woodward, tell me as best you recall when the grand opening was. You may have already said it and I missed it, but it doesn't need to be a specific date, but month and year?
It was about what, 4 months after we got the place. I think 4 or 5 months after we moved in.
So it would have been in the spring of 2020.
Somewhere around there.
If you moved in December 1 or
right,
you
it was
took
about the spring because
possession
it was still,
December.
it was spring. I want to say, that's a good question. That was it was actually warm outside because we was outside. So we know that it was warm. So it had to be sometime during spring. I think it was sometime during, I think it was during the summer, more of June, maybe probably about May or June. I can't remember the exact date of it.
But it would be 2020 that we're talking about.
I said 2020. No, this was done actually I can't remember exactly. I can't remember the date.
Well, you took possession of the shop on December 1, 2019.
Right.
How many months roughly were you doing all the work you described? Was it for a year and some months or just some months? Because
No, we did the work. So it was for some months that we worked on the shop because the shop did not open right away. It did not open to probably about, I think, I want to say about 5 or 6 months after, because him and I, we did the portion that we did. Then we hired the rest of the people to do the build out.
so the grand opening would have been in 2020.
I think it was 20. I can't remember.
Okay.
And maybe I can help, Your Honor. Would it have been post-COVID, as you recall it?
I don't know what post-COVID means. Are we post-COVID now?
Well, I think it was, if you go back to when we were in the middle of the pandemic, Mr. Woodard.
No, this was after the pandemic because during the pandemic, we were still doing the build out.
Right.
So this right here was after the pandemic. I believe that this right here, we did a grand opening fashion show because no one never knew it was in the community, even though it was after we moved in. I think this was like last year we did this. The year before, I think it was last year. We had did this because we had did a grand opening because we never did a grand opening during the time we opened. So we wanted to make sure the public was aware that we was there. So I think we did it last year, even though we know prior year we were still putting it together, fixing it, getting the garments in there, doing everything else. It wasn't just the construction we had to get together with to make sure all the garments was in there and everything else. So it wasn't just that. So I believe that this was last year. It was last year that this took place.
Any objection to the admission of Exhibit K, Mr. Williams?
No, Your Honor.
It's admitted.
Commissioner Published Judge.
Granted.
So why don't you just kind of walk us through the pictures and what we're seeing and maybe give us a better explanation of what your shop was.
Okay, basically that's one of my celebrity clients. Her name is actress Terry Vaughn. I dressed her for several red carpets. She was one of the individuals that inspired us to move to Georgia because she lives in Georgia. The other one is a really famous DJ. I dressed her as well. Like I said, we're an inclusive size brand. We are an inclusive brand. We service every size. We don't discriminate in size. In other words, we make sure we cover every individual, no matter age, size, whatever it is. That's what we found our business on. That's what we stand on.
What's this next picture?
That's Shay at the fashion event with us, enjoying herself with us. And she was telling us how much of a great job we did. And she was so happy to have us in the community.
What's the next one?
That there are bags that we had underneath our cabinet at the front desk when you walk in. And you can see them itemized cups. We had a lot of those cups there that was detailed cups that were itemized. So that's some of the product that we had as well. As far as outside of clothes, we also had cups as well with our names on them. This is a chair. The history behind this chair, it was given to us. And we actually redid it. We reposted, we reposted, we cleaned it up, we redid the whole chair. Because the chair, it wasn't looking like this when we was done. So that's the chair that was in the place at the time. That's one of the displays that we did on the windows, outside the windows when you drive by on the streets. To do something like this in a private residential area is rarely heard of. So we was making sure we put the best effort and give the community the best that we can give them as designers. That's the other side of the window because you had two big windows. So we had two windows to do displays. And so we'll constantly change the display, doing stuff during Christmas, holidays, Thanksgiving, Mother's Day. Every time a holiday come up, we did a display to attract people to come into the business. As you see a different display there.
And that's this last picture, sort of a change of display of what your business looked like from the outside. Is that right?
That is correct.
Now, as a result of sort of your being terminated, locked out, having your stuff taken, can you tell us a little bit about what were the consequences? What were the things that you suffered as a result of that?
Well, let me just say this first. We had just got a huge gig. A movie came out on the Hallmark channel called Single Black Female. They recorded that in my shop. So they paid us for the time. So we were getting movie deals coming into our shop, want to use our space and actually hiring us to be in movies and assist on movies and even help put some of our garments in movies. So we had to miss out on all of that. We had to miss out on prom season, bridal season. My celebrity clients, I had to turn all of them down, saying, no, I have nothing that I could provide for you for this year's Emmys and Oscars. We addressed people from Kelly Carter to Jamil Hill to Melinda Williams on the red carpet, and we had to turn all of them down, saying, no, we can't dress none of you guys because we have nothing. And we had to turn down 2 movie deals with Tony here in Atlanta, based at the Hallmark movies. We had to turn them down. We couldn't do it because we had nothing to provide for them. So we had to turn them down.
And did there come a time where you created or made a list of the things that you had suffered as a result of losing? Well, let me ask you a different question.
Mm-hmm.
Were you able or are you able to recreate your business?
Honestly, right now, like I said, I'm working at Walmart. So it's hard trying to redo this business because, one, I'm working at a job that's paying me way below what I'm worth. And so now I got to take that money and buy the product. I'm not making money to buy the product. I have make enough money to survive and pay my mortgage with, period. So everything else I have to do, I have to just put it aside.
And what about losing your designs? How did that impact you? How did you?
So I had to shut everything down. I had to literally cancel orders. I had to literally just cancel everything. I mean, from orders I had to cancel. I had to tell my celebrity clients I don't have nothing to give to them. So it did impact the whole business as a whole. We had nothing to provide to any of our clients, nothing. After we made so much, we made these garments and put them into the shop. So we had the garments there. That's why they came to us. But now we have nothing to give them, so we can't do no business with them whatsoever.
And did there come a time where you were able to put together a list of things that you lost, money, financial damages you lost as a result of losing your business?
Yes.
When did you put that list together?
We put that list together as I began to notice that it's gonna probably when we had to wind up going to court. I began to start looking and just saying, okay, this was taken. This I started itemizing everything I know from pictures that I have, plus from my memory, plus also from my my website, because that's how I was able to get everything. Other than that, because she took everything, if I didn't have pictures or video, I would have nothing.
Look at Exhibit M for me.
Exhibit M. Okay.
Was this a list that you created?
This is the list I created.
How do you know this is the list you created?
I can look and tell from my original artwork, the sketches, the pattern, I can just the names of different things that in the terminology that we use in fashion. I know that's me.
Have there been any alterations or changes made to this list that you can tell on the pages 1 through 4?
No.
And is this a true and accurate description of the damages you believe you suffered as a result of having your business taken from you?
Yes.
Your Honor, at this time, plaintiff would introduce Exhibit M into evidence.
No objection, Your Honor.
Exhibit M is admitted. What's a notcher?
A notcher is what you use to, like, if you're gonna put your sewing something in the garment together, you have to put a notch on both sides so you know where to line it up to make sure it's sewed perfectly. It notches the fabric. Put a little notch in the fabric so you know where to connect to the two together.
Okay.
I'm not going to go through each thing, but there are some things that stick out to me that I think the jury needs an explanation. Let's start with the first one, which is your original artwork sketches, which you say 500 and value at 10,000 each. Can you tell me where that valuation comes from and how did you get the number 500?
Well, basically every pattern I do sketches with. I got to do the sketches before I even make the patterns. So over 20 years of me working and me grading, and I do the sketch. I'm a great drawer, but besides that. And then what I do with the sketch, I put it into the pattern. So we know what this pattern is. If you don't put the sketch in the pattern, you're not going to know what it is. So you have to make sure everything is itemized. So I'll do a very detailed sketch of what it is. I would actually do it by hand because we didn't use the computer system because it took too long. So I would sketch it by hand. So each one is done by hand and I place inside the bag. So that's the reason why I came with that price point, because that's my work. That's me doing the work. And I know over time what those actually sketches, what they become to designers, they become worth way more as time go on.
How did you get the number 500?
That I know exactly how many patterns I had and how much sketches I have. I number everything.
And what about, so that's for sketches and custom patterns. You had both of those at 500. So that's approximately the amount you had at the time it was taken from you?
There was about 500 patterns and 500 custom sketches in those patterns.
Why is the sketches valued at more than the patterns?
Because the sketches, without the sketches, you can't make the patterns. The sketches is the graveyard to the patterns. The sketches it's just like, for example, you see this skirt. If I don't show you the skirt, you know what I'm saying? You won't know exactly what's being produced. And the reason why the sketches are more because, first of all, they're done by me, they're signed by me, and they're original. That's no different than asking an artist why is, their work this amount, if that make,
Okay.
How did you get exactly 500?
That's how many I had. I knew exactly how many I had. It was about to go over that because I numbered each one. If you notice, if you go back to the first page with all the sketches on, each one of them have a style number on there. So each one of those style numbers there represent how many patterns. So you know what I'm saying? Those patterns, some of those style numbers, like you was asking, how do you know that's current? There's 500 patterns, but they're not 500 sketches. So that means that the current sketches are in there that was currently in there. The other patterns are those that's past seasons. So that's how you know what's current. If you look at how many patterns it was versus how many, when you show that paperwork with all the garments on them, and you ask me that question. So that's how you can tell what's accurate, because what we do every season, every season is every 6 months. It's got to come off new product. But what we do, we work on it a year in advance. So it's not like we just sitting here doing it tomorrow if we make our mind. We've been working on this a year in advance, and we're finishing up before we jump into the next project.
And what about the slopers, the 144 valued at 3,000? Tell me how you come up with that evaluation. I think you've explained to us how the numbers work.
Right.
Tell us how you come up with the evaluation.
There was 144 slopers. Basically, slopers are like that's just like the blueprint to anything that you're building. So that's like, that would be like a basic sloper, say for a top, a pants, or, so I'll take that top, say is a client that's wears size 12. I'll pull a sloper that's a size 12, and I'll start doing my design element to it, what I want to change, what I want to do, what I want to invoke, what I want to take from it. So those are my building blocks. Without those building blocks, you don't have a business. You got to keep rebuilding those building blocks. You need those building blocks in the fashion industry. You have to have them, or you'll find yourself doing them day after day, time after time, and you'll never get anything done you need to have. The building blocks is like a shortcut that I've designed for myself that I find that works well. So I take the building blocks and I begin to execute the design from the building blocks, if that make any sense.
And what about the original barrier cover, original pattern?
Okay.
It's just patent pending, original barrier cover, original pattern. Tell us what that is, what that's about, and how you valued that.
Well, basically, how this even came about, Shay was really not happy with the orange barriers you see outside. They put outside around the city for you to sit outside if you're dining out. She wasn't happy with that color orange, so she was complaining when her and the city was going back and forth. And I said, let me see if I could come up with some type of design and fix this. She saw it, she agreed, she thought it was wonderful. So we got the city involved. The city agreed and found it was wonderful. But the thing, reason why it says pending patent, because we had put in the paperwork to get it, get it patent, but we didn't have the rest of the information to give to her because she took everything. So we couldn't finish doing the patent on that. So just stuck in limbo right now, because she had the original artwork, she had the, the blueprint, she has all that. It was in the shop. So I cannot complete the patent or anything else because she had all the other details to it.
And what about the original barrier cover sample with measurements?
She has that as well. That's a cover that you probably saw around the city that says something about the city of Atlanta on it and says all these little details on it. But the blue cover that I designed to cover the orange, ugly barriers that Shay didn't like. So I designed a cover to go over them, and it just slides right over and it snaps right onto it. So I had said, I'm gonna go ahead and get this patent because I had Birmingham interested in it. I had New Jersey interested in it. I was presenting it to different cities that does the same thing, Philly that does the same thing. So we wound up getting a contract with the city. The city did give us our first contract, City of Atlanta, and we did the covers.
And then I think you list a number of tangible items that were in the shop.
Mhm.
And you told us how you kept that inventory earlier.
Mhm.
And then you list a number of retail inventory, which is that compared to the list we saw?
The list that you saw earlier, that is correct.
And you counted how many were in there and then multiplied that basis the price that was in there.
That is correct.
And then I think some lost work that you had, you calculated that.
That is correct.
Well, to provide some guidance on what damages you believe you suffered as a result of losing your business.
That is correct.
And the total you had at the end was $6,884,280.78.
That is correct.
I tender the witness at this time.
All right, Mr. Williams, we're going to go until about 12:30. I have sadly a work call for your lunch. You may not finish, but I'd like you to start cross. It would be otherwise a natural break point, but we've got about 20 minutes we can use before we'll take our hour lunch break.
Okay.
All right,
Thank you, Your Honor.
you're welcome.
Good afternoon,
Good afternoon.
Andy Young. Maybe you're warming up to me. I'm going to try to cover a topic that we can cover hopefully in 20 minutes so that we can have a nice clean break. Mr. Sterling asked you about the lease. And we tendered that as Plaintiff's Exhibit A. This is the lease that you negotiated?
Yes.
Did you review this lease before you signed it?
Actually, my business partner reviewed the lease.
So somebody reviewed this lease on your behalf?
That is
before you signed
correct.
it? And after your business partner reviewed this lease, is that the other plaintiff or who is your business partner?
John Wesley is my business.
You all decided to sign this lease.
Yes.
You'd had an opportunity to review it, negotiate it, push back on it if you didn't agree with it.
Yes.
You weren't forced to accept this lease.
No.
Shay didn't force you to sign this lease.
No.
Page 7 of this, Article 3, Mr. Sterling walked you through this. And your testimony was that you inspected the space. And as written in the lease, you acknowledged in writing in the lease that you had the opportunity to inspect it and that you accepted it in the condition that we saw in those videos, correct?
That is correct.
And you knew that you were going to have to do all the work.
Not
We're
no
going to have
flooding
to,
work.
you knew that the condition was as what you represented in that video.
As
correct?
is.
As is.
Yes.
So landlord wasn't making any improvements. She wasn't going to renovate that bathroom for you, change the wallpaper or any of that. Correct?
Correct.
Article 1, which is page 3, subsection K. Base rent. This is a commercial lease. You were responsible for paying base rent, correct?
Page 3.
What page?
Page 3,
Mm-hmm.
the
Yes.
bottom of the chart, base
Mhm.
rent.
Mm-hmm.
Yes,
Yes.
yes, or you need to say yes, Mr. Woodward, or no.
Yes.
And on the top of page 4, we have a handy dandy chart that itemizes what the base rent was to be. First 2 months free, 0 rent. Months 3 to 12, $17.31 per square foot at $1,000 a month for base rent, correct?
That's correct.
And beneath that subsection L, you're also responsible for operating expenses. taxes, insurance, your utilities,
That's correct.
in addition to the base rent.
Yes,
Subsection M, you're responsible for real estate taxes, anything such as that.
yes,
And rent, and those CAM charges and those operating expenses, those were due on the first day of the month. Isn't that what the lease says?
yes.
Did you always pay them on the first of the month?
No,
You were late several times in your payments, correct?
I would say that's fine. Yes,
And under the terms of the lease, if you're late, there's a late fee, correct?
yes,
That you were obligated to pay if you made late payments of rent or operating expenses or CAM, common area maintenance.
yes,
And that if you didn't pay rent, let's look at section 10.1.
Section 10.1.
That's a default. Section 1, page 15, article 10.
Section, you said page 15.
Yes, sir. In the middle of the page, each of the following acts or omissions of tenants or occurrences shall constitute an event of default. Subsection A, failure or refusal by tenant to pay base rent, additional rent, which is the CAM, operating expenses, taxes, or other payments when due. You see that?
Yeah.
That was in your lease.
Yes.
Yes, I'm sorry. Yes, 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 yes.
I do the same thing, so you'll probably have to correct me because I'm just a redneck from Tennessee. Subsection 10.2, landlord's rights on default. Upon the occurrence of a default, which we've already established, is if you don't pay your rent when it's due, not late, when it's due on the first. And if you don't pay the additional sums when they're due, that's an event of occurrence. You see that first section, that first sentence?
Yes.
Can you read that? Landlord may.
Point 2.
Yes.
Upon the occurrence of an event of default, landlord may, at landlord option without any notice or demand whatsoever, any such notice and demand being expressly waived by tenant, in addition to any other remedy or right given under here by law or equity, do not, I say do any one or more of the following. Then it goes to A, termination of this lease is written, with a written notice to the tenant in which the tenant shall immediately surrender possession of the demise premises to landlord. Enter upon the take possession of the demise premises and expel or removal tenant and any other occurrent therefore to the extent permitted by law, after the law, with or without having terminated this lease, and C, after locks and other security devices at the demise premises.
So under the strict terms of the lease that you negotiated, read before you signed it and signed it, if there was an event of default, which is failure to pay timely, landlord could, without notice to you, terminate the lease, enter into the premises, and change the locks. Did you know that was in your lease when you signed it?
No,
Why not?
because I didn't see it.
You didn't see it.
No, I didn't see it. A 30-page lease is going to miss something. A 30-page lease on a commercial building, you're going to miss something.
But you had an opportunity not to miss that.
Yes, I did.
That next page, page 16. goes on to talk about what happens if the landlord takes the space back and if the landlord changes the locks. That first paragraph on the top of page 16. No alteration of security devices and no removal or exercise of dominion by the landlord, landlord's taking of the space back, over the property of tenant, which we've talked about, at the demised premises, which is the 697 square foot store, shall be deemed unauthorized or constitute a conversion. You're suing my client for conversion, right?
Repeat your question?
You're suing my clients for conversion.
Yes.
And the lease says, even if they did that, you agreed, you waived that right to sue them for conversion, correct?
I'm gonna object, Your Honor, that's argumentative.
Your Honor, I'm just going through the terms of the lease.
Right. No, I overruled. So I need you to answer the question if you understand the question. If not, then Mr. Williams needs to ask it in a different way.
Can you ask that question in a different way?
I think we'll move on. You already testified that, yes, you were suing them for conversion. And the
Okay.
lease says what the lease says. Going on down in that paragraph, all claims for damages by reason of such reentry and repossession and or alteration of locks or security devices are hereby waived, as are all claims for damages by reason of any distress warrant, forcible detainer proceedings, sequestration, don't punish me because I can't pronounce anything, or other legal process for damages or no legal process. Do you see that in this lease?
Yes.
That last sentence in that top paragraph, page 16, tenant agrees that any reentry by landlord may be pursuant to a judgment obtained in forcible detainer proceedings or other legal proceedings. And you testified that you didn't think that there was legal proceedings. You went down to the courthouse. But that last phrase, or without the necessity for any legal proceedings, but only to the extent permitted by applicable law, as landlord may neglect, and landlord shall not be liable for trespass or otherwise. Do you see that in your lease?
I see that in the lease. Yes, sir.
You've also sued Shay, Miss Embry, individually and personally, in addition to your landlord, FloShea, correct?
Yes.
But Shay's not a member, not a party to this lease in her individual personal capacity, correct? You testified when we looked at, I believe, the last page, which is the photocopy of the signature pages, that the two of you all signed as tenant Thomas LaVone LLC and as landlord FloShea at the Point LLC
Shay.
by Shay Embry as the managing member of the LLC, correct?
That is correct.
Let's look at page 17 of your lease. Article 11, section 11.3. Landlord liability. Do you see that section in the lease that you signed?
Yes, I do. Yes, sir.
The last phrase in that last sentence, and in no event shall tenant bring any action or make any claim against, recover any money judgment from, or seek to impose any personal liability upon any principal, officer, shareholder, member, manager, director, general or limited partner of landlord, or any principal for whom landlord may be acting or against any other property in which landlord possesses an interest. You see that?
Yes, sir.
But you're suing Ms. Embry as a member and as the manager of your landlord, correct?
Yes, sir.
Honor, do you want me to break now? I'm trying to come up with a clean break.
I want you to keep going.
Okay.
You got a few more minutes.
Okay, I just know that you said 12:30, you needed to go.
Well, I need to go 15 steps that way.
To Zoom, I'm sure.
Yep.
You testified that sometime in March, you hired an attorney through prepaid legal services, and that attorney was Terrence Burrows, correct?
Yes.
And when you hired him, what was your instruction to him?
John was the one who spoke to him. So you may have to ask him that question.
You don't know why you were hiring an attorney?
I'm not saying I don't know why, but I was on the phone present what he told that person. I was at work during the time at the shop.
So you don't know why y'all hired an attorney?
No, I'm not saying I don't know why, but you asked me exactly what he said, so I don't know exactly what he said to him.
In your words,
Okay.
why did you hire an attorney?
To see we can come to some conclusion to what happened.
And what was this attorney, Mr. Burrows, what did you ask him to do? What was
To
he-
contact you guys so we can come up with a conclusion to what happened. So we can come to some type of level of agreement.
When you're referring to what happened, what is it in your mind? What is the what happened?
When I'm totally confused with what you're saying. I don't understand.
Well, you just said, we hired Mr. Burrows to see if you could come to a conclusion on what happened. And I'm
Okay.
asking you
sorry.
to explain what happened.
I got it now. I'm sorry.
Because there was water, there
I
was
some
your
coffee.
stuff was taken.
Right. The conclusion, when we first hired him, originally it was about the water flood that had damaged the gowns that we couldn't get a response back from Shea from. Originally, that's what we had hired him for. Because during the time we hired him, the other place didn't even have taken place yet. The other situation did not take place at that time. It was the flood that took place that had damaged the gowns the first time
that we saw the video?
that we saw the video of.
Your Honor, I have exhibit notebooks. May I
Okay.
approach?
You may. Great. You can just leave it right there on that desk. Thank you.
Thank you, Your Honor. And I've shared this with Mr. Sterling. These are the exhibits that we've previously exchanged. Will you look at tab number 2, defendant's exhibit number 2? You see an email in the middle of the page. You see that email?
Yes.
The date of that email is Tuesday, March 22nd, 2022.
Yes.
And who is that email from and who is it to?
It's from legal correspondence.
And who is legal correspondence?
It says at the bottom, Terrence T. Burrows.
So this is the attorney that you all hired.
Right.
And who is this email to?
It's to Shay and Bobby.
So your attorney is emailing March 22nd, 2022 to your landlords, Shane Bobby.
Mm-hmm. Yes.
And based on this email, is this consistent with your recollection as to why you hired him to complain about the flooding?
She's about to come and the damages to the gown. So yes.
So we see in here, Your Honor, we tender this exhibit into evidence so that we can publish it.
Okay. Any objection to defense 2, Mr. Sterling?
No objection, Judge.
It's admitted.
Mr. Brickman, let's see how your skills are.
Oh, pressure's on. Paycheck is on the line. There it is. Solid.
Good job.
Good job.
Thank you.
You see that email?
Yes.
And this is the email that we're talking about. This is the email, defendant's exhibit number 2 in the notebook.
Yes.
I'm writing on behalf of Thomas LaVone LLC. He's operating as your attorney, correct?
Yes.
My understanding that you have a lease.
Yes.
Your plumbing issues, plumbing for the entire building is not up to code. Flooding issues, no hot water, electrical issues not up to code. That you're concerned about the property being condemned.
I'm sorry.
Thomas LaVone, and I will admit that in the copies that we received, some of the letters are missing, so it's like a word game. Main concern that Thomas LaVone has is that the building can be condemned as a result of the building not being up to code.
No.
You're saying that's not what it says, or that wasn't
no,
the
I'm
worry
saying-
you had?
No, that's what it says in front of me, but I don't remember even discussing anything of that nature with this attorney.
Because your testimony had been earlier that, and I saw the video.
Mhm.
Look, you had your yeoman's working cleaning up that water.
Okay.
Prior to that,
Mhm.
it hadn't flooded to that extent. You hadn't had those issues.
No, it did flood in March.
In March.
In March, right. And then prior, it
But
didn't.
The 2 years prior to that,
It
you
didn't
weren't
flood.
experiencing
Right.
those issues.
Right. It did not flood.
So you're saying you didn't have concerns in March 2022 about the property being condemned?
I'm reading what's written here. What he wrote here, I don't know exactly what the attorney wrote here because half of the words are missing, half of them are misspelled. So I don't even know what this is, to be honest with you. I never even saw this, to be honest with you.
Have you seen this email?
No. It's written to you guys, not blind CC to us, so we never even saw this. I haven't seen it.
But this was your attorney acting on your behalf at that time in March per your instructions.
Yes.
And that's the time where we're going to stop.
Thank you, Your Honor.
All right, ladies and gentlemen, your first lunch break. We're going to try to keep it to an hour. So try to be back in the jury room by 1:30. You're welcome to get food on the outside and bring it in as long as it's not in a glass container or sharp metal objects connected with it. But you don't need to eat in here. If you brought your lunch, you're welcome to eat in here, but go forth and just do your best to be back at 1:30. It's fine to eat as a large group, as subgroups. Just don't talk about the case during your during your lunch because you're not deliberating. During deliberations, I hope you talk about the case. No outside research. You haven't had a chance to ask any witnesses questions yet because we haven't gotten through our first witness in a trial that's going to end tomorrow, which is what the lawyers told me. So enjoy your lunch. We will pick up as close to 1:30 as we can. Recall, we need all 13 of you here. So if you see one of your number walking further and further away and it's 125, holler at them. Exactly. Grab them and bring them back. Yes, ma'am.
We give the cards to you now or later?
Nope, you're gonna hold on to them, and when we're done, when both sides, and we're already on side two, there are only two sides, are done asking questions of Mr. Woodward, then I will turn to you all and say, if you've got any questions, and then Deputy Gordon will come up to you, you'll hand them to him, and you'll get in, but this is the first time, so hold on to them. You can take your notepads with you or leave them in your chair. Have a wonderful lunch break. I'll see you in an hour. All right, I just got an email from another judge that I'm late, so I'm gonna go get on that. We'll talk about issues we need to discuss before the jurors come back in please be in here a little before 1:30. You're welcome to stay in the courtroom the whole time. You don't need to. Mr. Woodward, need to be sure if you do have lunch with Mr. Sterling, you don't talk about your testimony. Talk about anything else, but not about what you've been asked or how you're doing. No discussion like that. Okay? Thanks, everyone.
Thank you.
No, it's not. We usually Uber Eats. I got some protein.
Uber Eats is fun. Or is it, what's in the building? Oh, not even a cafeteria. I guess I'll be eating my snack, my trail mix, and send me to Atkins kind of day.
You got something on your
Yeah, fuzz on
pants.
your knee. It was all I could do.
That one
Not-
I threw that.
It was all I could do to not reach over and take it off from the iron side. My OCD was going
Did you bring your lunch?
bonkers.
Of course you did.
Smart woman.
Oh, no. Fail. Epic fail.
I get up here,
Yeah, getting out of this
after I
building.
got locked in, I told you that.
I usually make arrangements with the office, but I didn't today, so I don't know if there's anything.
I have two vanilla snacks. Anybody unhappy to
Well,
share?
if you all know something, you want me to order it through, I can do it, but it'll take
I'll
a
be
while.
fine.
Bars
I got
good.
some protein bars.
How long
Listen,
you
you
go?
did a really good job.
I confiscated my fork. So I apologize.
And I'm gonna get you
They
off.
confiscated.
I know. Yeah, what's up with you?
Typically, his
Yeah.
space, my house is gonna be out there, but she wasn't. So
Uh,
I don't want to have the judge.
Maybe that she typically likes.
She's not, she wasn't here. I didn't.
Oh, right.
I ended up finding somebody to ask for her.
Yeah, that's okay.
There's probably a vending machine.
yeah.
There's definitely,
Yeah.
I can do that. I can handle it.
No, we
There's
can
only a
go.
couple of places like right outside. that you can
And
walk
none
to.
of them are good.
It's one on the corner. It's
American
got
Deli?
chicken
Oh.
fingers and fries, but
This-
that's about it.
Not sure you'd make it through the rest
But
of
he
the
warned
trial.
us about
I
yesterday.
know.
Yeah. Whitney, he made, yesterday,
Can I sell one person, but I don't get it?
Oh, wait, that's too funny. Yeah.
after the jury came back from lunch, he asked if anybody had eaten anywhere. And he was like, I hope no one has eaten at the American Deli.
Yeah.
He's
And
like,
somebody,
oops.
somebody.
He's like, did anybody eat American Deli? 2 people raised their hand. He's like, good luck.
Yeah, it was good luck.
You know, I carry all the tablets in my bag all the time because I have had that much.
Yeah,
And it was not.
Yeah.
I was literally mouthing to the paralegal walking by through the glass window.
Help me.
Right, so we don't have copies of those checks that Bobby sent
I
earlier?
emailed them.
I know you emailed them, but I don't have them on this.
Oh, I had the physical checks.
You do?
Yeah, I do.
Better.
that's why he does that.
There were a couple that were scanned. So that's where he did have a bank account because they used the original one. Only,
There's probably a place where we could get something
Photocopies?
printed.
that's everything. That's every check they've ever written. There was one deposit slip because,
But it seemed like some of the later ones were just like $400 here, $150 here.
they were separating out, they weren't paying triple net at all in January, February. They had a late fee that they paid separate, so they were for funky amounts. But they started being for $444 because you can only write a cashier's check for $1,000 at a time.
And we didn't require cashier's checks.
No, they could have mailed the check. It was not possible at the time. I don't know if it is or isn't now. A bank, you can only have one Venmo account per person.
Yeah.
Per phone number. So we couldn't, if I gave mine to FloShea, I couldn't have one personally.
Yeah.
And my accountant said, you can't run it personally through your name because then it looks like you're the one
Yeah.
receiving the money. So that was a banking issue. So they could either mail the check or they could drop it off, or they could have used bill pay. They chose to use cashier's checks. The one where there's only a deposit slip is because the ink on the cashier's check was so light, the phone wouldn't accept it. So I had to go to the bank and deposit in person.
These match up to what the ledger is.
Yeah.
I could try to go to maybe like the clerk's office.
The only thing that's missing, I think, on that ledger is the late fee for January. Because they paid it on the 15th,
18.
18th.
And you can testify, I mean, you can read that.
Yeah. Because I'm a nerd, I'm on the accounts at least twice a day.
And the other thing too is when they were talking about what there was no relief during COVID. During 2020, we did not make any of our tenants pay triple net. And in 2021, they only paid partial triple net. They only had to pay for September on. So they were gifted 2 months. But in 2020, as an entity, FloShea paid for all the triple net for all tenants. So that was a gift. He may not know it because that's typically what tenants feel is if they would have to pay it. They don't acknowledge that it was a benefit, but none of them paid triple net in 2020. Even though it is in the lease.
Thank you for making sure that they all go to the lease agreement. That was like the perfect thing to do.
No, I can't publish their exhibits. Like when you were going through that lease, I wanted to put it up.
I would just publish the one that we have. It's the same lease.
Yeah, okay. I'll ask, just to, or should I just do it and
Just
wait
do
for
it.
them?
Let them judge.
Okay.
I mean, part of this is also to get them to write down section numbers.
Yeah.
So that when they get a copy of the lease,
They know where to look.
hopefully they'll go look for it and see that what we told them was true.
Yeah.
What else did I have to ask you?
So, like one of the things I used to do with sellers and negotiating as a broker is they say this, so-and-so said this, and I'm like, is it in your contract? If it's not in your contract, it's not a part of the agreement, period. It's in black and white, or it's not part of it.
We can talk about it since we weren't on the stand, right?
Yeah.
Okay. The other thing that he said, I said, which was not true, was about what occurred on the 2nd. So my conversation with him was, you can call me at any point over the weekend and I will come I'll come unlock the doors. This is the day the keys were changed. I'll unlock the doors for you to get your stuff out. It was not there was never a conversation about them trying to find out if there was something filed with the county. I never heard that.
We have a copy of the email where you said, but someone wrote, not it's me or yeah, there's him, that till noon.
Yeah, and then they
On the
said
2nd.
nothing will be removed.
And that's on the 28th. Well, that's on the 28th
And what day was 28th is the
or
day.
the 29th, but maybe you're.
Monday was
29th is Friday.
Monday was the 2nd, which is when we went in.
Right.
So their dates, they just got wrong on the dates. It's manipulative. The other thing is in his comments about how he talked to me about the lease amount and the payments and the whatever. All of the tenants know, if they come to me to talk to me about rental payments, I go, that's Bobby's job. I don't talk to them about any of it. I don't say, yes, it's okay. I don't say anything. I leave it completely up to Bobby. And anyone that is late, the only comment that Bobby and I would have is, for example, on April rent in 2020, they didn't pay until the 17th of the month. What I would have done is called Bobby and said, are you comfortable still dealing with this tenant? If not, we have the right to kick them out right now. What are you going to do? He's like, and every time he's like, no, I can do it. So his only job really is to take the check, deposit it, and create a monthly ledger. He said, but with this guy and with one other guy that was in here, we just dealt with, it was like a full-time job. They're trying to get paid. So.
I want you to say that.
I will.
Yeah, we did work with them for a very long time.
I'm going through those right now.
And when they wrote the hot check for the initial deposit, against the advice of our leasing agent and against Bobby's gut reaction, because I like entrepreneurs, I've said, let's just do it. That's why he handles the lease, the money part.
And the check that was bounced,
Yeah,
I still think it was February.
no, they paid it like,
No, they paid it over 3.
oh, they did.
They
split
paid
it
their
up.
deposit over 3 because but when the first one checked, if
Well,
you're-
just look at the email on the date that we got the email. I sent it to you.
yeah, this one. But I haven't seen it all.
No, but what does the contract say?
But
It would have been whatever the lease agreement said.
here, it's your email. Show you right. Well, okay.
You're afraid of.
I agree.
It's not turning off, so.
Where's that email from you this morning?
Yeah, that's it.
I know. I saw
I'll
it.
find it.
Yeah, I got all these, so, you know.
Yes.
Checked about there.
Okay, it was on December 17th. It's the date that we got the email from John Wesley stating that their check is bouncing.
But the only check that I didn't have. What is the February, which would have been first month's rent?
We gave him 2 months.
December, January.
I also want
Right, but what does
to
the
look at
contract say?
their inventory exhibit and match it up with these damages.
Because they did pay
Even though
the
the,
deposit
because it doesn't
for
look like
3 months.
anything on that inventory is on the damages sheet.
Right.
And but that's
They
why I
talked
think
about
I'm thinking that
sketches.
It was the
of the
January,
That's what I was trying to whisper was
or
that.
yeah,
There's no
February with
addresses
the
on
bounce.
their inventory list.
There are, okay, I
Or you
didn't,
didn't reference.
I haven't matched them up with each other yet.
It's in the
We're not
contract.
trying to prove, I think there's 6 dresses and there's 2 things we're trying to prove. A, you asked.
Yeah,
for
I-
close to
that was good.
$7 million.
And there's-
Yeah.
and then that
B,
one-
you're claiming there's hundreds and hundreds and hundreds.
Oh my gosh, I saw that too.
500 specifically.
Of things and dresses in this space.
Yeah.
We saw the video. It didn't look like that many dresses.
No. There weren't that many dresses when we went in there. I'm surprised they didn't show the video.
Oh, no, so it was fairly sparse. There was a single pole, 2 of them on one wall and 1 on the 3rd wall. And then there was a single pole that may be 7 feet long in the back room. And that's where the clothes were. That was it.
Mhm.
So I would guess based on that, there were maybe 40 pieces of clothing made. So that whole thing where he says they were all made and in the unit is a flat out lie.
Yeah.
And then if they showed the video of the
You
day.
disagree? You don't think that there was $7 million worth of dresses in there?
Well, I wear them.
Patterns.
I still wear them.
But
You know, I
the-
am
if they-
dress, dress, dress.
If they show the video of when Shay was in there, you can see what the inventory was. That may be why they didn't show it. I don't understand why they didn't show that. The Facebook video.
Oh, because they don't want for the jurors to hear everything. Because he says stuff that he shouldn't have said. That shows him how extreme he is with his behavior.
And you guys want trail mix? It's
Okay.
delicious. It's
Thank
better
you.
than American Deli.
I'm sure it
It's
is.
like eating like a bird over here. Have some seeds.
I actually got worried about you.
No, I did good this morning. Yesterday I was not prepared. I'm very worried about it. When we got here, and they're like, oh, it's only gonna be update. And then today, I had two things of oatmeal this morning. I'm filling up.
Have peanut butter and crackers.
Oh, and Kyle, they never hung up withholding of rent. We never received any of them why they were withholding it. They just stopped paying.
Yeah.
It wasn't like, hey, we're gonna pretend this is a residential lease.
Oh, and you told me that, Eli. But you know what?
It's better
What
to
you
follow
went
the
through
lease.
with them, by pointing out what was said in the lease agreement, it closes the case. I mean, every one of the jurors hear the truth now. Hopefully.
I think because. Yeah, he's waiting. Okay. I love you. Give me an hour. I'll talk to you later.
Child or husband or spouse.
Telling me all the things, you know.
Okay, they paid, advanced rent was $1,000. Security deposit was $1,673.84.
So the advanced rent was what is what that
Was, right, no, the whole thing. They wrote a check for that much.
20, oh, and it all
advanced.
bounced.
Mhm.
Oh, and then they paid it back.
Yeah.
In pieces.
That's why they split it up.
Got it.
Kyle, did you print out that case law?
Mhm.
Where is it?
How many people do you think they're really gonna call?
What?
How many people do you think they're really gonna call?
I don't know.
It's unbelievable how long this is.
Jury trial. They quickly fall apart.
The longer you talk.
Self-help.
So when would that come up during
Directed
directed?
verdict.
Okay. Do you need me to?
What is it for you? Less typing?
And did you need me
I'm so
to?
sore from that workout yesterday.
I haven't been to the gym and
What's
I
that?
thought about going this morning. I was like, there's no way I'm gonna have enough time. Considering how late I was.
I carried in the boxes.
And the binders.
Or the box, yeah.
Oh, your means the arms.
I was literally just doing this all the way up the elevator.
Well, you're
People were
still-
really worried.
You're still young, Joseph.
I don't,
How
I
old
feel
are
like
you?
it. I'm 20.
Oh, that's sad. You're 27. You still already don't know. You've already forgotten.
Forget a lot of
Would
things.
you like one of these?
I'll go RX, please.
I don't care, but it's all magically smashed up weird homemade stuff that I.
Yeah.
Some comments and some whatever you're not eating.
That doesn't matter to me.
I feel like I tweaked my knees skiing.
No, I thought you were gonna say lifting boxes.
Seriously, I'm like a little.
Is that how
worried.
you want us to ask you about skiing?
Yeah.
Where'd you go?
Utah.
Oh, nice.
That's really fun.
Blueberry,
And all the
peanut butter,
craziness, the
dark
snow and stuff
chocolate,
that's on
milk,
It literally
chocolate.
snowed the entire time. I was there.
I did Breckenridge in college. And
Okay.
it snowed the entire time and I didn't realize
Split it with
how
the two.
cold
Yeah.
Yeah.
It is when
It's
it
got
snows
two.
that hour. It was freezing. We suffered it out. But that,
I was in Deer Valley.
Yeah, we did your relative years ago.
It was so nice.
I was hoping we'd be done today.
Yeah, yeah. I have never been.
I
I've
feel like
only been,
tomorrow's
I've
gonna
been
be full.
snowboarding twice, and I went skiing this year.
I've got to cancel everything I had in my calendar for tomorrow.
all right. When did you go this past weekend?
2 weeks ago. Yeah. It snowed like 19 inches over Sunday there, which I've been told is awesome.
Oh, the powder.
Yeah,
I did
So what
steamboat
is-
one time. It was
Uh,
awesome.
yeah.
Yeah.
When it snows a lot, it's smoother.
Where are you headed?
I already went to Utah.
Oh, I love you, Tom.
It was beautiful.
It's a great
I
state.
Never been there.
Yeah, I would have liked to stay. I don't know.
How long were you there?
I was there for 5 days.
Oh,
Yeah,
that's good.
or 3 kind of full days, couple travel days.
How far is it from the airport?
Park City is like 30 minutes away.
From Salt Lake?
Mhm.
Oh, wow, that's great.
It's amazing. There's like another 15 where we were staying.
It's easy.
Life of luxury.
How much was the pass?
We got so my girlfriend's brother lives in Denver and he's got all these like annual ski pass discount stuff. So we got like 25% off each day and it was still like $200.
Very expensive, so expensive.
Yeah.
God. Back in the day, I remember when they were $100 and we were complaining about them.
One of my friends said his brother just went skiing in France because it was cheaper. Said it was like $30 a day. I opened up the ski conversation, pal.
What's the lift do you cost these things?
It was like 200 a day. It was scary.
A day.
So I had to get in all the runs every day.
Per person.
The
You
knee.
have a family, imagine.
Yeah, it's frightening.
Huh. And you can't get to those little restaurants unless you don't have a
Mhm.
That's where all the good, mid-ski drinks are. Yes.
I took my spouse years ago. We went to Winter Park, Colorado, and John's never skied. So he's from Colombia.
Mhm.
So for Christmas, I gave him skiing lessons. And I've skied. And then halfway through the day, I got really bored. So I dragged him out of skiing class, which he should not have been dragged out of class. And he made one green run, like kind of blue, and then it went to green. And then he's like, I'm done. That was miserable. I
going to the high
didn't
altitude
enjoy it.
bar.
No, he's like, I'm going home. So he,
I don't enjoy skiing either. I can do it. I grew up doing it. I don't like putting my feet in big concrete boots.
The boots
They
suck.
are.
but it's so fun when if you're not falling. It's
No, the
fun.
boots are really.
If you're not getting concussed, it's great.
Right.
So when my first time I ever went, we were in New
It happened to
Mexico
me once.
and
Yes,
they wanted me to take these, they had 3 slopes, but they wanted me to take this class. And I'm like, looking at it, I'm like, I don't need to do this class. And I just took off down the hill,
Mhm.
but I didn't know how to stop.
Oh,
Sit down.
I've been there.
pizza. You make a pizza.
But how do you do the pizza?
When you do the pizza, you're either gonna tear your knees up
Yeah.
if
I
you're
don't know what
older.
you're talking about.
You put your
Oh,
skis
yeah.
together, but you can't let them cross because then you topple
My
over.
left one
And
would
break
work and then
legs.
my right ankle was just like dangling behind.
You can tell, what's your weak leg? Well, I don't know.
I don't know. Thought I was ready.
Well, fortunately, me, I learned to just do both things and stop like that
Mhm.
because I had to.
I tried snowboarding once and it was okay, but they spend so much time on their butts.
You don't want to stay here for
They want some.
2 more days.
I like snowboarding more, I think.
Do you?
I'm okay. I got my bar.
Nice, smart.
I've had a couple of them.
Do we need to be prepared for any of this?
She's gonna make a decision.
Hearing it.
Y'all too?
Yeah.
They want to hear it all and then
I think it seems like they're looking for some good for that. But they might not call everybody. We don't know.
He was
Well,
really
it's such a
quick with his own
waste.
client.
Yeah.
You think?
Yeah.
I felt like it took forever.
Agreed.
I think it's forever too.
We're off reading it. It's not what you say.
We'll go find a vending machine for some.
I want to do that as well.
Need some cash.
I hope they take our card.
Always take it.
Oh, yeah, I'll take some cash. No,
So you want to order?
I would love at least one.
Will there be a break this afternoon?
It should be.
Pretty quick. Once copies is directed for it.
Mike has like 8 witnesses.
We have to hear all of this.
All these people who want to come say how bad it is.
Perfect. Never talks.
No, no, it's just let's see.
Hi, Ben. Jesse. From one of the, you know, the Highlands house.
Mhm.
We're not gonna be far from them, I think. We're reached about land between Young Harris and Blairsville, for about 14 miles from Hazel. Yeah.
We got some really good friends that have a house in the work.
Yeah, we went there last weekend, because we cleared the land last weekend. I was there for like 3 days.
We just never go up there. For me.
Yeah, we got it cleared, they mulched it. Some
We're
great.
gonna start building or?
Yeah. I'm not in a hurry, because I don't wanna, you know, alone, I don't have to. I was trying to do it all the time.
Listen, I'm sorry, I said those two things. Like under my breath, I said, that's a lie. This, and they're both looking at me like, shut up.
I didn't hear it happen.
I think it's my own Tourette's.
Oh, it's hard. It's hard for you to sit there and just say exactly what you're saying about you. And you know that's not true. You know that you would never just wait at all.
But after I was clicking my clicking my pin, the bottom of my pin, he smiles and looks. I'm like, I need to, I'm like a kid that can't sit still.
There's a lot of emotion going on right now. You're doing good back to it very. Yeah.
How you want to address this?
No, thank you.
You know, the builders you trust up there?
Yeah, but it's hard up there.
That's why I'm here. Because I'm building a steel building like that.
It's hard to get on schedules and get,
Fun times.
because what little work we've had, it's been.
You know, from my perspective, I wish no one harm in any of the situation. And we never meant anything other than to have him have a great experience where he was. And so it's hard to see him realizing that they're wrong. And that's what it is.
So if not anybody move for a collective verdict for the jury. So that's outside the jury's, and then if you win, he just releases them. 65. Mix the peanut butter up all the way to the bottom of the jar. It's hard to break. Cool. 20 minutes. Yay.
Time for another lunch.
I know. Cheers to the cab, it's crazy, like the restaurant, you could walk anywhere.
Yeah, the cab is a much better place to try, Jerry. Try 'em.
Bryce got a call today, she had called yesterday to see if they needed her. She just came by, and they shut down. Just call, I'm telling her, get your number and just call.
Yeah.
Gotta know. So she called, she was like, see, attention. No jurors are needed. No more jurors are needed this week. She goes, and I'm free for 2 years. See, that.
So if I'm gonna speak to these things, I have to have, because I don't understand what he does here. Because I thought we were over $5,000 in arrears from things, and none of it, like, did they pay this? And it just didn't, you see what I mean? Thanks so much.
I got an extra one for somebody.
Thanks.
How you doing? Multiple extras and crackers. Should we need them?
Bobby,
Well, in April, oh, not in April. When we did the notice of default, it was $5,089.
but if I'm going from here, I don't understand it.
Add $150. See what that does.
$51,13. So I don't understand the accounting here. So if I'm gonna speak to this, I need to understand. Are you saying that they did pay? Are you saying that what did we not deposit? What did we deposit?
We didn't deposit either one of those.
What about that one?
February did go in.
Because this is only, okay, so 1488, right? 150 from here that they didn't give us, right? 1488, we didn't deposit. And then no triple net and no late fees. So there would have been late fees here, right?
Correct.
And a late fee here. And their triple net is how much? 333?
No, it was more. It was 500.
500, okay. So that means no triple net here is 500. None here, 500, right? And none here is 500.
Trying to find the email that we sent Kyle initially, if I can find that so long ago.
And add it up too while we're doing it.
Because that had the breakdown. Sorry that my Excel not what it needs to be.
So that's what I'm coming up with these numbers, which doesn't match what we had.
On the, let's not trying to find his.
Okay. Would it be because we'd have another late fee that wasn't paid here?
There was,
That would have made 507.76.
What was the
if
amount
there was
of it?
another late fee here.
so there was no late fee there because they paid in January 18th.
Yeah.
Right.
What's the, there's-
Here's what we said in April.
50, 80, 24. You're at 50, 76.
So we said, we haven't received base rent, additional rent and operating expenses for March and April. Deficient and short rent for January and February. I mean, don't get too stressed out. about
No
the-
problem. I'm not
the
stressed.
Numbers, because
Yeah.
they're not.
Yeah.
Our overarching thing is, he was consistently late.
Right. No, I'm completely calm about it. I just want to make sure I don't get up there and fumble. So I'm just going to go to that number.
And I'll show you this document
Yeah. Okay.
and we'll talk about how, yes, you had accepted late payments before, but you said basically never again.
Yeah. But I mean, it's easier for me to address when they made payments. Because right here. Thank God for water, y'all. Thank you.
Took long enough. I'm sorry. And you weren't up there talking.
It's not a problem.
COVID, they used to give you a,
It was here during jury selection, I think. No? Oh, that was where I was. That was Forsyth County.
it was never COVID.
I was like, I saw cups yesterday.
Forsyth County never stopped doing it in person. No. And enough encouragement.
Discouraged. So Shay, you're from New Orleans?
That I'm from New Orleans?
Mhm.
I'm from Oklahoma originally,
Okay.
but I was in New Orleans for about 10 years.
Okay.
But before that, in 1982, I left my heart there. I love the city.
It's awesome.
Yeah.
It's amazing.
Yeah, it is. What do you like about it?
Food,
Yeah,
honestly, more than
Uh-huh.
anything. It's just,
Yeah.
and real architecture.
yeah. Amazing, isn't it?
I was gonna say my favorite coffee has become French Truck. They have such good stuff. It's literally my phone background. Like I went there last time I was there. Just
Wait, what is it?
it's called French Truck. I'll show you.
I don't, when did that come out?
It's truly my favorite. My dad and I are such snobs about it now that we order it from them in New Orleans. It's pitiful. I'll show you if I can figure out how to delete things.
Have you ever had Mellow Joy?
No.
It was like the original. Never seen it.
Okay. They've got a few places there.
Cool. And not when I was there.
Okay.
Yeah, but I've been gone for a number of years.
I'm going for
I
Jazz
moved from there
Fest
in
in May.
13. Oh, I love
Never been.
You're gonna love it.
I'm just talking about skiing trips and Jazz Fest.
Well,
see where
just
my head's at.
remember crawfish Monica
Mhm.
and Natchitoches meat pies.
Okay.
I like French Quarter Fest.
I love.
Never been to
that.
either.
It
French
is
Quarter
better.
Fest is better.
It is better.
Because it's in the quarter.
Yeah.
It's more local.
Yeah,
So my law school friends.
because honestly,
those for
the
something
whole thing with
nonstop.
Jazz Fest is that you could be with the music that's played other than the Zydeco stage.
Mhm.
You could be at any stage in the world
Yeah.
because they could get bring in all the big,
Yeah.
things. But French Quarter Fest is all local,
Yeah, it's great.
all local music. It's amazing. And if you get tired, just go back to your hotel.
Mhm.
Jazz Fest, you don't go anywhere. You're in the fairgrounds. Take a hat,
Yep.
take sunscreen. And if it rains, take a raft.
Contemplating chair versus towel or blanket. I think
Yeah.
chair might be the move.
A short chair.
Mhm.
Yeah,
Put over my back.
yeah. Oh, yeah, that's the number that we set in April. There, it doesn't match.
Five. That's not right. 508.
Yeah, oh, 80. I think that's it. Craig's doing good. He's back to work.
Oh, good.
Mhm.
Yeah, we do. I almost have to avoid it during the day. Like just push it as far as I can, because the moment I eat lunch, 12 o'clock, 1 o'clock, 2 o'clock, I'm just
Really?
wiped. I don't know what it is. Even just like a bar. I'm like, I'm a little bit more comfortable than I was before. Not today, though. Not.
Blood sugar.
Yeah,
That's what it is.
guess so.
There's a book called, the authors are, last name are Pugh, P-U-G-H. It's called The 5-Day Miracle Diet, and it's not a diet. It's how to balance your blood sugar in 5 days.
Yeah.
And they ask you all these questions about, do you have this? And do you do this? You do this. And they say, if you do these things, you have bad blood
Totally out
sugar
of
by
whack.
midday, you're bad blood sugar.
Yeah.
But they talk you through, and the first thing they say is that within 45 minutes of getting up, you eat protein.
I've heard that.
But most people,
That gets the
you know,
metabolism going.
yeah, it gives the body the right message.
Mhm.
And then once you start doing that, then instead of eating carb or.
Or nothing plus coffee.
Exactly.
Yeah.
Yeah. And then your blood sugar goes, oh, I think I'll be bad now.
Mhm.
And you go, boom, and at 4 o'clock you're out.
Yeah. Makes sense.
Yeah.
I can attest. Okay.
Okay.
Yeah. Just pull the wall. Where Jerry's hurt is. Okay. Yeah.
Question. I'm the same.
Is it an email?
Bless you.
From who to who?
Steel.
Okay.
Can we send it to you?
Or is it a little different?
Same number.
Okay.
That is what we did. This just really shows the late fee because I'm missing. Number was off because of that 206 of the shortage. This should have been probably 206 and I put 500 because that's what they extra. Yeah.
They're not letting me bring it in. Cross it out. It's my second Starbucks. I don't know, they're not letting it through and then 7:30, 8 o'clock, I try to get in with it. It's like, no way. Very strict.
I'm so sorry. It's okay. It's all right.
Oh, wait, we're gonna should take it off. That train.
224.
Just correct that.
You can see perfect.
Sit here.
So focused on feeding.
I understand.
Love it.
I got it.
Thanks.
So. Okay, the Facebook posts that were deemed, just as a reference, all of the ones that were attached to the meeting, I have taken screenshots of since then to have the data where I guess anyway. Okay.
In this unit we're talking about. Store the bathroom out. Turn it, make it ADA compliant.
Push it up here, right? Yeah. He's up there. Yeah, I'm gonna call him in. Oh my God, this was it that was supposed to follow up.
Yes.
Oh, I haven't called.
I called her.
I did.
She said she's gonna stand up the show before the week is out.
Before the week is out.
You might have to fight a little bit.
He said it was bad. 2 years before they moved in, we replaced, can I? More research.
What's the lease say?
Yeah, she said she was.
Yeah, it's.
The discharge showed the person in the shop. And the photos were good. We need to have because we have to introduce the exhibit. That's a lot of stuff. At least we know for next time how the exhibits work on Zoom, but still gotta fix the speed thing.
How'd you feel the first round?
It's not likely I'm gonna be up there today. Is it? Yeah. I don't know if you need to read this, but that's systems. Thank you.
Hold on, water, man, see it.
Ready? Yes, I am talking to you. Okay, are you ready? Excellent. Let's go back on the record. We are starting a little bit late. That is no one's fault but mine, but I'll explain that to the jurors. We were in the midst of cross-examination of Mr. Woodward. Mr. Sterling, was there anything you wanted to bring up before we brought the jurors in?
I just had a question, Judge. Would I be able to do I'll do my redirect before the jurors' question?
Yes, sir.
Oh.
We'll exhaust, redirect, and recross before the jurors ask any questions. Apparently they have some. And then you'll get a chance to ask questions based only on the topics raised by the jurors' questions when those questions have been asked. Okay.
I just want to get understanding, Judge. Thank you.
Sure. Mr. Williams, anything else?
No questions, Your Honor.
All right, jurors, please.
All right, on the jury.
Great, you all may be seated. Welcome back, ladies and gentlemen. So I have learned that the only group of people who talk more than lawyers are judges. So the meeting that I had, it started at 12:30, for which I was 2 minutes late and scolded, ran late. So I apologize that we left you waiting there. You were all back, I assume, real close to 1:30. Everyone here is ready. In case you've already forgotten, we're in the midst of examination of Mr. Woodward. We got partway through the cross-examination from Mr. Williams. He will resume that and we'll keep going. Thank you.
Mr. Woodward, when we were speaking before the lunch break, we were looking at defendant's exhibit number 2. Do you still have those notebooks in front of you?
I closed the book. You gotta tell me what page and everything again.
It's on. Remember, you got to be close and friendly with the microphone.
Pull up a little bit more. Let me just.
All right. So we were on exhibit D2.
Tab number 2, which was the email from your attorney, Mr. Burrow.
Okay.
You testified earlier under questioning from Mr. Sterling that at some point you decided to withhold rent and not pay rent. In looking at that email from your attorney, there's no reference whatsoever to you withholding rent, not paying rent, deducting anything from your rent. Correct?
Correct.
Tab number 3, directly behind that, defendant's exhibit number 3, which we've marked. Have you seen this exhibit before?
No.
And this is an email dated Wednesday, March 30th at 5:45 p.m. from me at my email address to your attorney, Mr. Burrows. Do you recognize that?
You're
No.
at D. Oh, I'm sorry. You're at D3. I went.
D3, Your Honor. I'm sorry.
No, my bad. D3. Here we are. Yes, from you.
Did your attorney ever tell you that he received an email from me?
No.
Did your attorney ever inform you or your partner that I acknowledged receipt of your correspondence and said, this is the first time we're hearing of plumbing, electrical issues being experienced. We need an opportunity to discuss more and understand what's going on and to figure it out and address under the terms of the lease.
No,
Your attorney never told you that?
no,
Tab 5. I'm skipping one, tab 5. Do you recognize this correspondence?
no,
Dated April 11th, 2022.
no,
Letter on my letterhead to your attorney, Mr. Burrows.
no,
But you see where it references notice of default?
yes,
You see where it references your lease?
yes,
I call your attention to paragraph number 2. As referenced in my voicemail messages and email correspondence.
Your Honor, I would object to reading from a document that hasn't been admitted into evidence.
Then I'll move to admit it into evidence. He's attached the later correspondence notice of termination to his complaint, and he's already introduced that document into the evidence. This letter is an earlier referenced letter in that notice. I'm not introducing it for the truth of the matter asserted, but just that the notices went out and that he should have received them from his attorney, Your Honor.
It's proof that a notice of default was delivered to Terrence Burrows on or around April 11th,
Correct.
not whatever in here. Let's say hypothetically it alleges you hadn't paid your rent, not proof of that, but simply that the document was conveyed.
Correct.
Okay. And who's laying the foundation that this is in fact a notice of default?
I mean, I can cover that on my client's own cross or
Okay.
direct. They're copied on this notice. The notice of termination, which references this one, is attached to the plaintiff's complaint. They've already asked him questions about that termination notice.
So what I thought you said was that the notice of termination is attached to the complaint. That would be a harder one for Mr. Sterling to object to. This is not that, correct?
That is correct.
Does the notice of termination include attached to it, the notice of default, or they're separate documents?
I can solve this.
Excellent.
I just got there.
Okay,
Let's flip to tab number 9. Tab number 9. At the top, we see the header for Mr. Sterling's previous law firm. At the very top, it is your email address or Thomas LaVone's management at thomaslavone.com email address, Sunday, May 8th, 2022, to Mr. Sterling's paralegal. And if we look in the middle of that page, do you see an email from my client Shay to both of y'all? Do you see that email?
I see the email, yes,
And the email from Shay to management at thomaslavone.com, April 27th, 2022, John and Thomas, our attorney sent the attached letter to your attorney. There was no response. While we have been instructed by our attorney to change the locks, we would like to give you time to remove all of your things before we do so. Please advise. Do you see that?
yes, I see this.
The notice of default, the notice of termination were attached to this email, correct?
Only thing I see is what's in front of me. I don't know what was attached to it.
Have you ever seen this email before?
No,
So who gets emails at management@thomaslavone.com?
that's what John usually handled.
Yeah, the previous document was a notice of default, which I objected to. This is the notice of termination, which I have not objected to.
I don't know what letter's attached, but this client of yours is saying it really wouldn't matter what the letter was because he says he never saw this email. He doesn't deal with the emails. Apparently, that's a Mr. Wesley thing.
Yes, Your Honor, correct. But I was objecting to the notice of default because I didn't think my client could authenticate that. But the subject line says lease termination, not notice of default. So I don't know what's attached to it, and I'm assuming he wouldn't know either.
Well, he would if he got emails at management@thomaslavone.com. I don't know. Okay.
So it's your testimony that you never saw, never received either through email or through communications from your attorney of a notice of default or notice of termination?
No,
And you never received an email saying, here are the letters that we've sent you. We need to hear from you. Please come get your stuff.
no.
Turn to tab 11. This is another email. This one to the management@thomaslavone.com, which you've said that you didn't get those. Your partner got those. There's a president@thomaslavone.com. Who gets those emails?
Me.
So you get those emails.
President.
So president@thomaslavone, do you recognize this email at tab number 11?
Yes.
Dated April 28th, which is a Thursday, 3 p.m., 3:11 p.m. This is an email from Bobby. No, we don't. You're shaking your head.
I'm just shaking my head as I'm reading them. I'm sorry about that.
You're welcome to shake your head, but you recognize the email.
I recognize the email, which I stated earlier.
Okay.
I'll move to tender defendant's exhibit number 11.
Any objection to D11?
No objection, Judge.
D11 is admitted.
Mr. Brickman, let's see if your skills held through lunch.
Not if you ate at American Deli.
We did not.
Okay.
Good protein
I'm gonna
bar.
get sued sometime. By that. I'm sure they're wonderful. I just like joking about it.
Privileged communications in court, right?
Yeah.
We've put up on screen this email that we've now confirmed went to both management at Thomas LaVone and president at Thomas LaVone, which you are the president, you received this email. This email is from Mr. Flournoy, Bobby, the Flo. If we scroll down to the bottom of this, you see two attachments. Notice of default, termination of lease. Did you receive those attachments?
Yes.
Did you click on and open those attachments?
No, because the time I was at work inside the shop, I didn't see those attachments until I got home that evening.
But you've seen those attachments.
When I got home that evening, correct.
And are those attachments the previous, what we looked at, the notice of default that you said you did not recognize? Which is tab 5.
Which one was it?
Tab 5, Defendant's Exhibit 5.
I don't remember this. I don't remember it.
And was the notice of termination, what Mr. Sterling previously asked you about, the termination that's attached to your complaint, and is also Defendant's Exhibit 7, tab 7?
Tab 7. 1 second. Again, I don't remember. Not to my recollection, I don't remember.
So is it your testimony that from March 22nd, 2022, when your attorney sent an email complaining about a fear of condemnation, plumbing, electrical work, flooding, you have no recollection of receiving a notice of default of unpaid rent,
Again, I don't recall because basically we was actually terminating that attorney to hire Michael Sterling. So I don't know what he told you guys in between, but we had explained to Shay before that we was still looking for another attorney as well. So I don't remember what you're asking me.
So let's look at Defendant's Exhibit 12. This is an email from management at Thomas LaVone. It appears to be responding to the earlier email, the one that we looked at, because this is at 5:53 PM, which was been when you would have gotten off of work. Did you write this email? Do you recognize this email?
No, I did not write this email.
And so you would not have been the one to say, please note, this is a communication between legal counsel and not an eviction notice.
I am president at thomaslavon.com. John is management.
Did y'all not talk about this stuff?
I handles what comes in president and he handles what comes in management. He may talk to me briefly about it, but I'm also dealing with the client. So I'm not going to remember everything till we have a conference meeting when we get together.
But you would not have talked about eviction notices or defaults or terminations?
Yes.
But it's your testimony that you didn't.
I'm saying I don't recall.
You don't recall. Let's look at Defendant's Exhibit number 13, that next document. Again, April 28th, same day, about an hour later. You were here from the attorney regarding the false eviction letter.
No.
Did you ever notify
No.
Shay or Bobby that you had fired Mr. Burrows?
No.
And we established that you're not management, you're president, and so you
That
would
is
not have known
correct.
about this email. Let's look at Defendant's Exhibit 14. Another email from April 28th, 7 minutes later, from Shay. It says Thomas and John again.
What number?
14, I'm sorry.
14. Thank you.
I'm sorry. I'm trying to read these numbers upside down. Email from Shay, Thomas and John. Again, is Mr. Burrows your attorney? When you told us you were represented by him, we must communicate through your attorney. Since Mr. Burrows has failed to communicate, we are asking that you provide an attorney that we may communicate with. Do you remember receiving that from Shay?
One more time. I'm president at Thomas LaVon. John is management.
Not management. And y'all would not have discussed that.
Right.
Defendant's Exhibit 15, that next document. Same day, April 28th. 4 minutes later. Management at thomaslavone.com. To Shay and Bobby, your attorney will be contacted. Again, you're not management, you're president. You don't recall this document, correct?
No.
Were you ever told by management at Thomas LaVone or your attorney, Mr. Burrows, that your landlord had claimed a default of the lease?
Basically, John have actually gave me a briefing on it, but when I'm working with the clients trying to get them service because they paid me money, I focus more on that versus the litigation because I know that he was going to contact an attorney. So each one of us have a role. I don't step in his role and he don't step into my role. That's why I'm the designer.
But in the evening, you mentioned you were a little less focused on clients.
Right, I would look at the emails, but still, he's the one that's actually, when it's no different than, well, I'm gonna say this, he's given the job to handle all of those things. So when those things come about, he handled them, and he come back and talk to me briefly. Am I gonna remember everything? No, 'cause I'm trying to think about my clients and get them service, because they paid me money for this stuff to get service, and they didn't pay cheap for this stuff.
So your testimony is that you have no recollection of management, meaning Mr. Wesley saying, hey, they're terminating the lease. We may have no place.
Right. I'm saying that I do recall him discuss with me briefly about those things, but not really into detail, because he wanted me to focus on the client, because we had such a large amount of clients at that time. So he wanted me to focus on that while he deal with this.
And so to expand on that, you never had any conversations about 7 days to cure the default of the lease?
He mentioned to me about about what Shay is attempting trying to do, and basically that we had got rid of that one attorney and we're going with Mike Sterling.
And in those communications, what was communicated to you as to what Shay was trying to do?
With the attorney trying to get, well, pretty much you representing the attorney trying to actually evict us. So that's what he brought it to me briefly. I'm like, doesn't make no sense. She got our rent. So I just blew it off, because I know the landlord that I deal with. Sometimes she say stuff and whatever, and I learn to blow it off and just keep walking. You know what I'm saying? Because sometimes, we all have our moments. So that's the reason why I didn't take it seriously. I'm like, okay, she said all kinds of things before, so I didn't take it seriously. I'm like, I don't think she really gonna do that, because she got our rent money already. She had everything up to date.
So you blew off, so let's unpack that a little bit. You said y'all knew or had talked about what she was trying to do through me as the attorney. Was it about changing the locks, taking possession, rekeying the space?
John was talking to me what she wanted to get done. That was the point about dealing with the lawyers, let the lawyers handle the situation. That's what John would talk to me about. We really never talked in detail, because like I said, that's what he handles. Pretty much I focus on the design aspect and the clients, because there's no way you could be a designer and trying to worry about the legal litigations. I'm trying to serve as a client. So the times that he did talk to me, it was just briefings. We would come and just have briefings, power meetings at the end of the day. Hey, did you know this is going on? Hey, did you know that? I'm like, I don't think that's going to happen. I don't think this is going to happen. So it was nothing like me blowing her off. I was telling John in particular, I think that you just wait and see what she's going to do. I don't think she's going to do that, because she had already collected all our rents up to date at that point in time.
And there was never any conversations, or you don't have any recollection of letters going back and forth saying that you hadn't paid all of your rent, that you still owed money?
No, because Shay always, again, like I said, we already talked, and Shay knew that we was going to pay rent late. So to my knowledge, I knew that I was thinking the rent, everything was paid. You know what I'm saying? Then we decided to hold back just the rent, not pay it, hold back. And then we said, just go ahead and give it to her. That's the only time I recall saying that, well, let's just hold the rent, see what she's going to do, and decide what she's going to do. But other than that, she was paid in full.
When did you try to pay the whole rent? Was that after the lease was terminated?
No, it was before. We got the letter. To my knowledge, John came to me and said, after now we paid the rent, now she gave us a terminator. I remember him saying that. We paid the rent, so now we got a termination afterwards. So she was already up to date in her rent already. So the letter came after. And that's when he discussed it with me. That's why I didn't take it seriously.
But the letter that we've discussed that you acknowledge finally receiving is the one that was emailed to you after the fact, after it was emailed to your attorneys, after notice was given to your attorney to respond, correct? That's the email that Shay sent on the 28th.
Shay sent that one on the 28th. That much the one before, and Shay sent previous emails before then as well, text messages as well.
After the termination on April 21.
April 21st?
21st. So lease is terminated April 21.
Okay. And repeat your question.
And you attempted to pay after that on the 28th.
No, she was paid before then.
Okay.
She was paid before then.
In any of your power meetings, in any of these conversations, you talked about what you were disregarding what you thought Shay wouldn't do. Any of those conversations about Shay's saying we need to move our stuff out? We've got 3 days, we've got 7 days.
No, because I was at the shop when, like I said, when I finally saw the email, she came in and I pulled it up. She said, I sent it to you. So I went looking through this email and I pulled up. That's when I saw it the day of. That's why I made it clear earlier that I saw it the day of the eviction was taking place.
What day was that?
April, or I mean, that was April the 29th when she came through the door.
April the 29th?
Yes, I believe that was that Friday.
Let's look at Defendant's Exhibit 17, tab 17. It's 2 pages. There's been a lot of reference to things that Bobby promised or didn't promise, or dates and times. This is a May 2nd email from 8:56 a.m. You're shaking your head. Do you recognize this email?
I don't recognize this email, but I remember the date of what took place.
So you remember May 2nd as the
Yes,
date?
I remember precisely May 2nd because that's the Monday we were supposed to go down to the courthouse to see if the paperwork was filed. We agreed to 4 p.m. that day. If we don't come back with no paperwork, the police officer said, you got to let him back in there because it was illegal what you did. The sergeant told Shay this. So he told us we have to the 2nd to come down here to see if any paper was filed in reference to an eviction. We came down, but John was on his way down, and at 8:56 a.m. don't look like 4 o'clock. That's what we agreed on, 4 p.m. And they sent this at 8:56. By 10 o'clock, they was in the shop doing what they were doing.
So 8:56, you see Thomas and John, I am available until noon today to unlock and let you remove the items. Please let me know what time you will arrive and I'll meet you there at Bobby Flournoy. You don't recall?
No,
And you
because
didn't
at this
receive this
point,
email because this went to management at,
and plus we was at this point in time, we was moving, trying to come down to the county of sheriff department to see if any paperwork was filed, which none was filed.
so you've talked about 4 o'clock. Let's look at the second page. This is an email, May 2nd, 9:38 a.m. So less than an hour later, an email from management at thomaslavon.com, which we've established is not you, it's John. Do you recognize this email?
I don't recall.
Do you remember discussion? And let's look at the second paragraph. Please be advised, there will be no removal today. Do you remember any discussion saying we're not moving our stuff from the space?
Well, May the 2nd, we couldn't have a discussion because I was running down to the building trying to get down to see what's going on. So at this point in time, at 9:30 a.m., you know what I'm saying, I was already in motion. So whatever's going on is going on between them two. So I was already in motion to come down to the building. Like I said, just in case we had to take our stuff out of there. So that's the reason why I'm not recollecting this the same day, because this is the day everything took place.
So when you got down there on May 2nd, did you remove your stuff?
No, they did. Before 4 p.m.
But in this email, May 2nd at 9:38 a.m., Thomas LaVone is saying, we're not moving our stuff. Isn't that what the email says?
That's what this letter says.
You take a look at Defendants Exhibit 21, tab 21, please.
Yes.
This is a screenshot from a Facebook post. Do you recognize that?
Yes.
Did you handle the Facebook post for Thomas LaVone?
Not all the time.
Not all the
No.
time. Do you know if you handled this one?
Yes.
Your Honor, I move to enter Defendant's Exhibit 21.
Any objection to 21?
I do have an objection, Your Honor. You had mentioned that, Your Honor had mentioned about it being a completion. It's clear that this screenshot does not contain the complete context. There's a see more, where typically you would click on something and see the full context of the conversation. It's not contained here.
Well, if you've got the whole thing, I'm happy to look at the whole thing to see if what is not included is meaningful enough that we'd have a Rule 106 issue.
I don't have the entirety of the message, Your Honor.
Okay.
But in this exhibit.
All right, but so I'm clear, defendant's exhibit would be a screenshot of one of your clients' Facebook page to which in theory your clients have access.
Yeah, it's the business Facebook page to which my clients have access. And Mr. Wooders has said that he did author this message.
Okay. I think you'll be free to ask him questions about what more might have been in this one, but I'll admit D21. You're welcome.
Mr. Woodward, in looking at this, it says, please take the time out to know what's in your neighborhood. These commercial grifters are targeting so many of our businesses and homes. I can give good advice on signing a lease and the pits to look for before signing from firsthand experience. What is the good advice? What tips do you have for signing a lease?
Don't sign unless you got an attorney present.
And Mr. Sterling pointed out, and I looked to see if I have the rest of this post, I don't, but as you can see, it says, unfortunately, the council, I'm assuming man, do you know what the rest of that post said?
I don't know. You have to read it for me.
But at that time, you had started reaching out to city council members, county commissioners, complaining about the commercial grifters.
I didn't per se, but we did contact the councilwoman.
Let's look at Defendant's Exhibit 28. This is the verified complaint filed in this lawsuit. Do you recognize that pleading?
Yes.
Did you review this pleading before it was filed?
Yes.
We talked a little bit earlier about a claim in your lawsuit for conversion, for stealing. You'll look at count number 1 on page 5. I just want to make sure. We understand what you're suing for. Paragraph 27. Defendants took ownership over plaintiff's assets without any legal authority to do so.
Yes.
In paragraph 31, plaintiffs have been damaged as a result of defendant's conversion of converted property in an amount not less to, and I think there's a typo here because I think we got a couple of extra zeros. because this seems to say $75 million, but that, unless I'm mistaken, is it $750,000? What amount are you suing for conversion?
7,500,000.
7,500,000. Count number 2 is for fraud on page 6. Paragraph 35. Defendants orchestrated a scheme to get Atlanta Police Department to believe that the plaintiffs were illegally evicted and to assist defendants in changing the locks to Thomas LaVone. Right?
Yes.
So you contend. Paragraph 38, $100,000 damages plus interest for fraud.
Yes.
What is the fraud based on?
Based on the simple fact that we paid our rent. She had our rent money. You said they was behind in 3 months of the rent, which is not true. She just recently returned only one portion of the rent. We gave her the last 3 rents all together. She only returned one of the checks, so she cashed the other 2 money orders. So explain to me how we behind in 3 months of rent.
Exhibit number 32. Your Honor, do I need to move to admit the complaint into evidence, or
You might as, just so the record is clear, it's part of the docket, so it's part of the record. I don't know that it's part of, that would be transmitted if a record needs to be transmitted, but I don't know that it's in evidence here.
then I'll move to tender Defendant's Exhibit 28, which is the complaint into evidence.
Any objection to admitting the verified complaint, D28?
No objection, Judge.
Admitted.
Thank you, Your Honor. Defendant's Exhibit 32. Plaintiff's responses to defendant's first request for production of documents. Have you seen this document before?
Yes.
And this is y'all's response to 3 questions that I asked in discovery for documents, correct? Do you see
Yes.
that? Asking for what's the documentation for the $7.5 million for the $100,000 for your damages. And I just want to make sure, because we've got a couple of documents floating out there. If you look at the last 2 pages attached to that, it's a 2-page listing. Of what appears to be an inventory list or with dollar amounts. This is similar to what Mr. Sterling walked through. I just want to make sure they're both the same. These are the amounts of damages and the items that you claim were in the space. And we can refer both of these. The previous one was marked as Plaintiff's Exhibit M, which you should have out loose.
M as in Michael.
M as in Michael. The formatting looks different, but they appear to me, but I'm not the one who created this or have lived with it, but are these the exact same in terms of the itemizations of the artwork and the sketches at $5 million, the custom patterns at $750,000.
It's the same.
These are the same.
Yes, they're the same.
So if we look, 36 custom evening gowns, $126,000.
What number are you on? What number?
On page 2, number 2.
Yes,
And you see above that retail inventory, it's not specified, $200,000.
yes.
Is it your testimony that these were the items that were in the space on May 2nd?
You mean the whole listing or just those two you're talking about that you just
This
mentioned?
whole listing.
This whole listing, these were the items that was inside the location.
And this list was prepared when? Did you prepare it before May 2nd? Is it an accurate?
When I prepared this list immediately once they went in and took everything out. So this list was prepared back in like sometime in like April. I started going through everything because I know if I did not go through it immediately after they took everything out, I would forget. And I had pictures to reference to it as I went through and named every item.
We haven't seen those pictures today. We saw some, but we've not seen photos of all of this stuff.
You see the photos and the listing that I believe that was shown today. There's photos by each name and style number of each garment. There's photos in there.
But there are items on the list like mannequins or fabric
Right.
weights or business cards.
Mm.
Those wouldn't be in that inventory that you shared that had all of the work you had done.
Well, if you look, they look through the pictures, you will see pictures of the mannequins. You will see pictures of certain things, but business cards, you know what I'm saying? I doubt you see that, but you're going to see the mannequins. Those are in there. Those are in the pictures. The matter of fact, the mannequins was in there when it was AC in the window. When we first moved in, the mannequins are sitting right there. They're in the pictures in that whole file that we sent you.
And is all of this stuff in there when we saw the video from the flooding, which
Yes,
was May
yes,
2nd? May
Yes,
22nd.
yes, the stuff was in there. Yes,
So we see all of that stuff in the background,
yes.
in the 690 square foot.
It depends on what angle of the picture. So I can't guarantee you're going to see everything, but the pictures I submitted to you shows all this stuff
In this space.
in this space.
And as Mr. Sterling asked you about on the last page of plaintiff's exhibit M, there's a total amount. And I think we've got an extra 8 in here. 6,884,280,000, not 68 million, right?
I'm sorry. Yes.
So 6 million, 6.8 million. And this is $6.8 million worth of stuff is what you claim was in the space and what you claim the defendants destroyed and damaged and should pay you.
But this is true. I agree with you. But when you're saying that, it's different products. Like I said, there's the patterns and sketches versus garments. So,
Sure.
include all of that. I want them to understand that includes the patterns, include the sketches, and to include me grading all the patterns. What you mean? I grade one pattern, I got to grade it 12 times for different sizes. So that's what's included in all that work of 20 years
That was there,
that was there.
that was in the space. Did you have insurance on it?
Yes, we did have insurance at a certain time and point. We had insurance on that space. Yes, we did.
On your inventory?
On the space.
On the space?
Right.
Were you required to have insurance? I mean, you've got
At the
$7
location?
million worth of stuff.
You mean at the location? Yes, we was required from Shade that we need to have insurance.
And that was in your lease.
I can't remember exactly because it's 30 pages. So I can't remember exactly.
And just one final question. Let's look at plaintiff's exhibit C. This is the online inventory. Online
Okay.
order dashboard appears like that Mr. Sterling asked you about.
Mhm.
And this clothing (36 high-waisted skirts, 24 shirt dresses). Is your testimony that all of this was also in that store?
That is correct.
No further questions, Your Honor, at this time.
Mr. Sterling, any redirect?
Yes, Your Honor, briefly.
Your Honor, let me move to the request for production of documents, responses, plaintiffs, defendants, Exhibit 32.
All right, any objection to the admission of D32?
No objection, Judge.
Thank you, Your Honor.
You're welcome. All right, Mr. Sterling, redirect.
Thank you, Judge. I want to go through briefly, Mr. Woodard, some portions of the lease that you discussed with Mr. Williams. Let's go to let's go to 10.1. Under
page is
default,
What page?
page 15. One of the things that Mr. Williams talked to you about was the default by tenant, which included failure or refusal by tenant to pay rent or additional rent or other payments hereunder when due. You recall that?
Yes, sir.
Now, do you recall there was also another provision within the lease which you talked to Mr. Williams about regarding late payments and interest that accrues on late payments?
Yes.
So within the lease, there were really two remedies. Is that right? One would be if you didn't pay rent on time, that could be considered a default. Is that right?
Yes.
And the other remedy, and the landlord could take the property back or try to terminate your lease. Is that right?
Yes.
And the other remedy that could be exercised by the landlord was to enforce the late payment provision and accrual of interest. Is that right?
Yes.
So a default or failure to pay rent didn't automatically mean, because there are multiple remedies within the lease, didn't automatically mean you were going to get kicked out.
Yes.
Is that right? Now let's go to section, let's go to section 16. I'm sorry, page 16, not section 16, page 16. And you and Mr. Williams had a conversation up top in that first paragraph that said, no such, it's I believe the third sentence, no such alteration of security devices and no removal or other exercise of dominion by landlord over the property of tenant or others shall be deemed unauthorized or constitute a conversion. Is that right?
Yes.
Now, that doesn't speak to the destruction or damage of property. Is that correct?
Yes.
There's another provision that talks about destruction or damages to your property. Is that right?
Yes.
And in section 11.5, let's go to 11.3 first, where you also spoke to Mr. Williams about. It said that I guess it's just one long paragraph, but I'm going to take you down to the middle. But it says, that any issues arising under this lease, including but not limited to matters or claims arising out or caused by the negligence of landlords, its agents, servants, or employees, shall be limited to landlord's interest in the building, and no event shall tenant bring any action or make any claim against, recover any money judgment from, impose any personal liability on principal officer, shareholder, in any action that may be, or for whom landlord may be acting or against any other property in which landlord possesses an interest. Now, this is related specifically to the tenancy and occupancy of the building. Is that right?
Yes,
Not to the destruction and damage of your effects.
exactly.
Now, let's look at 11.5. Now, Mr. Williams talked to you about the portions of them exercising control over the place, the changing of locks, exercising dominion, issues related to the tenancy. But this section is the section that actually addresses the damage to property or to persons. Is that right?
Yes,
And if you look at the very first sentence, it says, except with respect to the gross negligence or the willful and wanting acts of landlords, its agents and employees. Is that right?
yes,
So that means anything coming after that, it is an exception that if the landlord acts willfully with gross negligence or makes wanting acts, then they could be liable for loss or damage of property that you have.
Oh, hold on one second. Are you all right?
Yeah, just try again.
Is that an expensive piece of equipment that crashed to the ground? Is it still working? All right. Yes. That's on the landlord.
So this is the portion that actually talks about the damage to the stuff in the space, right? And it makes a clear provision that if the landlord acts willfully, wantonly, or with gross negligence in terms of removing or damaging your property, then they could in fact be liable for the property. Is that right?
yes,
Which is different from the paragraphs that are in conflict or different from what Mr. Williams discussed when he asked you about the lawsuit for conversion and damages to your property.
yes.
Now, I want to talk a little bit about the notices you received. Let's go to, I think it was, actually, let's go. Let's go to defendant's exhibit number 11. It's in the defendant's booklet. We don't see, now the original message comes from management at thomaslavone.com. Is that right? And you were copied because you're president at Thomas LaVone.
That is correct.
And we don't see the text that was sent to Shay, Embry, and Bobby Flournoy. Is that right?
Yes.
We don't see the actual text of the message,
No, we do not.
but we see the subject line.
Yes.
And what does the subject line say?
John, we received and will be,
Just the
the subject line, I'm sorry. Confirmed receipt of rent.
And was that sent to Shay and Bobby to confirm that they received the rent payments?
That is true.
And that was Thursday, April the 28th at 12:59 when that was sent.
Yes.
And they responded on the same day at 3:11 p.m. Is that right?
Yes.
And that was when you were informed in that email that your lease had been terminated as of April 21st because you hadn't heard from your lawyer.
Yes.
And they talked about their attempted communications with you. Is that right?
Yes.
Now, the 29th is when you were in the space when the locks were being changed.
Yes,
That was Friday, April 20th.
Friday. Yes.
Now, at the time, you were under the belief that you should not be evicted or that the eviction was wrong.
Yes.
But you were told, well, at least on Friday, the 29th, you mentioned earlier that there was a conversation with yourself, Shay, Bobby, the police sergeant, and other members of the community on Friday, April the 29th.
Yes.
This is a day after you first received any notification of eviction.
Yes.
And they communicated with you, you'd have until Monday before at 4 p.m.
Correct.
Now, at the time, you're thinking, I gotta go to the courthouse and demonstrate that they didn't file the proper eviction, not realizing the self-help portion of your lease agreement.
Yes.
But you thought you had until at least 4 o'clock to get your stuff.
That is correct.
But you also received an email, as Mr. Williams pointed out, you received an email from Mr. Flournoy saying you got until 12 o'clock.
That is correct.
That email was sent subsequent to the conversation you had on Friday. That was sent on Monday morning, May 2nd, at approximately 8:30 or so.
That is correct.
And when did you get the ADT alert and realize that stuff was being taken out of your building?
At 10 a.m.
Which would have been before 12.
Before 12.
Now, did you go down to the building at that time when you received I think you mentioned you're a track star.
Yeah, I ran down there.
And at that time, did you and Mr. Wesley and other members of the community try to get them to let you get your stuff?
That is correct. We tried talking to them. We begged them, please, just to let us take our stuff. They would not do it. They just proceeded taking it out into the restaurant next door. Another restaurant next door, they proceeded to take it into and stash the stuff. And we seen them put some stuff in cars.
And even after that, did you try any other methods to get your stuff back?
Yes, we called the chief of police. He even came and talked to her. Chief Jackson came and talked to Shay, and Shay agreed that she would coincide what the chief was saying. And then once again, nothing.
When was the first time you learned that all of your stuff had been destroyed by the defendants?
When we came to court and she said that she destroyed it all, that's when I first learned that she had destroyed 20 years of work.
Now, that was subsequent to hiring me when we had a hearing in front of Judge McBride.
That is correct.
And I filed a protective order trying to get your stuff back.
That is correct.
And ultimately, when you learned the stuff was destroyed, it was moved. So we withdrew our protective order motion.
That is correct.
And that was the first time you learned that
Yes.
all your stuff was gone. Now, Mr. Williams talked a little bit about your damages and stuff that you lost as a result. How much space do the sketches and artwork take up that were your own individual design?
They don't take up much space because what I did, the yellow envelopes, in the fashion industry, we bag everything accordingly. We put, excuse me, if I seen a little, we bag up everything accordingly. And what tends to happen, we'll put the sketches in, excuse me, I'm sorry, with the artwork. We'll put everything together. And we'll bag everything up. So you can get 100 sketches into one of the little white crates with the sketches and pattern, because paper folds up, it bends up, it's really tight. So we had like 5 crates of patterns, and I know there was 100 each, because each one of them fit 100 of them in there. That's how my intern and I, we actually organized it. And just to see all that gone, it's just every time I talk about it, I get a little off. So
you're not contending that you had so many dresses and so much stuff in there that it was worth what you ultimately calculated at, but a lot of your personal artwork that you had built for your portfolio over 20 years,
yes,
what was destroyed?
That's correct.
That's the first judge.
Any recross?
No, Your Honor.
Ladies and gentlemen, now is the time, if you have not already, to jot down any questions you have for Mr. Woodward onto cards. If you've already jotted them down, let's funnel them. It would be to your left towards Deputy Gordon. Don't need to put your names on the cards. Please only write on one side of the cards. Yes.
There are 2 questions.
There can be 10 questions if they're legible on one side of each card. Good luck making 10 questions legible.
Okay, on that little card.
Of course, it's broken. That it? Thank you. Okay, I'm gonna start numbering these. Thank you. All right, council, if you'll join me, you all can be at ease, but stay right there.
That was my sign. That was my sign. That's what I practice. I'm not Christian. That's what I practice. I don't see it. I don't close my eyes with the camera. That was crazy. I just don't know how.
Yeah. Yeah. Yeah, so that's the only one I got, but I haven't. Which is fine, yeah. Everybody else. But
lunch tomorrow. I just wish they would done.
Boyfriend. Email for him. I sent the email. Do you know he's worse than the attorney? I wrote a 3-sentence email. He had 8 revisions. Boy, if you don't make them 3 revisions yourself, look, you could, I'm in the middle of trying. He's like, I think you could add my phone number at the bottom. That should suffice. I think you could get a job. Sometimes you gotta take a break. Look at Michael, like, what are you doing? It's like, this guy, sometimes it gets so intense.
I know where that goes to. I'm not going there because that's not that far, but yeah.
All right, Mr. Woodward, I have a few questions for you. I don't think you'll need to refer to any of those, but you're welcome to refer to any of the exhibits. What's a sloper?
A sloper basically is a block that we use. Again, the sloper is pretty much a block you use for like a standard block for pants, a standard block for tops, a standard block for a sleeve. So it's just like the blueprint to a car, a basic car. You're gonna have the 4 wheels in the body. So pretty much that's what a sloper is. And then when you have celebrity slopers, say for example, anyone you come in, I measure you, fit the garment to your specification. So that garment only fit you, no one else. So we're really more of an atelier than a boutique as well. That's what people get confused at.
So Hugh Jackman and I are the same size. So if you did it for him, it actually would fit me?
No, it doesn't necessarily mean that would fit you because your shoulders may be bigger. You may be able to fit the chest, certain areas the same, but certain things gonna be different. You know what I'm saying?
A sloper though then would be an actual human size, the
Right.
size of whatever. If it was Tattoo from Fantasy Island,
Right,
it's
it would
small.
be right.
If it's Wilt Chamberlain, it's big,
Right.
but it's human size.
Right.
Got it. Okay. Did Thomas LaVone LLC, so the company, did you maintain financial records like accounts receivable, accounts
Yes.
payable, stuff like that?
Yes. we
Okay.
do QuickBooks.
All right. So that was the way, and it may not have been you, it may have been management
Right.
who took care of that. But QuickBooks would be the way that the LLC, the business, kept track of revenues, expenses, et cetera.
Exactly.
Got it. And did the company have a bank account?
Yes, we did.
One or many?
We had 2.
The inventory that you had, was it all on site, meaning in the building there, or was there an offsite location for bulk fabric or anything like that?
Everything we do, what we do, we would go way back to New Jersey, New York, and go buy these fabrics and shit. We would literally drive them down ourselves or either ship them down, because we know you're not gonna find what we find in New York down here in Atlanta. So we would go get the fabric from there and bring everything down and begin the process of doing what needs to be done with all those garments. So that's what we were so anal about, make sure we find fabrics that you can't find in the stores down here. And everybody, their lust, and everybody will have the desire to want them.
So working off of plaintiff's exhibit C, that's the printout of what you said was your inventory. For some of these, color block, animal printed, some kind of garment, it lists 36 in the inventory. Does that mean that in that 693 square feet space, I would have found 36 of those?
That's true, because what we do, again, we take them, once we make them, we take them, we pack them down, and we got to put them in plastic bag and suck all the air out of them. So therefore, when the client purchased them, they're fresh, they're new, no one touched them, and the air is out of them. So therefore, air is not reaching that garment, so it's going to stay more. How can I say it? No moths or anything can get to it, so it will stay fresh. It will stay like it's brand new out of the pack.
Okay.
So yes.
Were any of your intellectual property assets, designs, sketches, et cetera, also digitized? You scanned them so they could be saved in case the building burnt down?
No, because we asked, again, that's why I said we was doing everything manual without the computer. We didn't, some of them you'll see, like I'll scan some of my celebrities, they'll ask me for whatever, then I'll scan it and send it to them, but I'm constantly, it's only me. So I can't do all of it. So I try to do what I think is important, put the sketch in with the garment. I would never think that you wouldn't have your items. So no, I never thought to put them in a computer.
Okay. Did you have insurance on any of your intellectual property, your sketches,
Yes,
your
we did.
designs?
Yes, at the time, if I'm not mistaken, we did have insurance to a certain extent, but it didn't cover it all.
Where would you have recorded the money order receipts? You mentioned that you paid rent through money orders. And so there ought to be a receipt
Yeah, we have
for
receipts
each
from
one.
the stuff from the money orders.
Yeah, where would that have been kept?
I would have kept them in the office, and like right there in that desk you saw, everything was set up there in that desk. That's why when I saw the picture of the desk, everything was pretty much gone from underneath the desk. That we keep everything and we lock all our receipts up at the end of the day once we do whatever. Because right now we live in a smaller place, so we can't bring it home. There's no room for it. So everything had to be at that location. We sold our house from New Jersey to come down here. Now we was in a house, that would be a different thing. We're in a house, but we're not in a house. You know, so.
What was the documented revenue or income for the LLC in each of the couple years leading up to your removal?
In 2000, when we first opened the business in 2009, we was just really, we was more in the negative. We spent our money to get all the equipment, everything we need. For the first 2 years, we spent money just buying things. Now,
But if we fast forward to 2020, 2021.
2021, our business was estimated at 3 million. We've got an offer for 3 million to buy our business out from underneath us, but we still turned it down. So we know exactly what our business was worth as far as the estimate.
Okay, but my question wasn't what would someone estimate your business was worth? Presumably there was a tax return filed for the LLC.
Yes, it is.
In 2021. What would the net income have been listed on that tax return? Ballpark, you don't need down to the pennies.
In 2021, because I know we didn't have a full year, I think in the middle of the year, we were somewhere at 180,000 we had made, somewhere around there. I don't know exactly because I don't have it right in front of me, but
ballpark 200,000.
Right, that we and that was not even a full year. That was like the first 3-4 months that we was making, because we was getting these contracts from the city with the barriers. We got that one contract we was working on.
What about then the last full year tax return that was filed for the LLC?
I don't know.
What would the net income have been?
I don't know exactly right offhand. I don't know exactly right offhand.
Okay.
I don't know.
You estimated the value of each of your exactly 500 sketches at $10,000 each.
Right.
Have you ever been offered money for one or actually sold one that anchors the 10,000 beyond your estimate?
I've actually sold some of my sketches to design companies. What happens when you sell the sketch to design company, they pay you more. So when it been 10,000, probably would have been 60,000 when I sell them the sketch and that. But when I sell them the sketch that includes the design, I can't go back and use it at all.
You've given up the right to use
Right,
it.
exactly. Once I do that, and I've done that several times when I work for companies. And when you work from, you sign that agreement. That's pretty much what you're doing. You know what I'm saying? So I've done that several times working with companies. From Ralph Lauren, okay, we need you just to do this, but I need you to sign this. This is, you can't take any of these sketches back, or you can't say you own any of these. I lose all rights to those once I sign that paper.
Do you know if the lease that we've been talking about required the landlord to maintain the property up to code or get it up to code if the code changed, or if instead that was the tenant's responsibility?
Well, that was the landlord's responsibility because we was paying triple N net, which is she was responsible for the maintenance and the maintaining of the building. That's what all the tenants were paying triple N on top of the rent.
Tell the jurors what you meant by using the term holding back rent. What does that mean?
Meaning that when our intention was to give her the rent once she fixed the situation, because we couldn't get a response from her. Only response we got from her when we seen her face to face was and walked away. So I don't know how do you deal with that besides money's gonna make a person stop what they're doing. So we said, let's just hold the rent and give it to her just to get her attention. That's why she was able to collect the rent before these letters came out. She already had her rent before then. So that's what I meant by just hold the rent. She's gonna respond, and then we can go from there. Because we couldn't get an answer before then. It was no answer at all, none. And one wave off, like, I don't care.
There was a reference made at some point during your testimony about a city council member being contacted. Do you know why you or your business partner were reaching out to a city council member?
The city council women, we reached out to them because, to our knowledge, that she was working with them with those buildings because, to my knowledge, that they was giving so much grant money to fix the buildings. And we was reaching out to her to see if we can get her to respond, because I know she was working with her. And we already tried to reach out to the mayor as well, you know, to their office to get them to respond, which one of them did respond and told them, hey, what's going on with this? So we was able to get some response from that.
Do you know what specifically the landlord deemed to be the default that occurred that triggered your removal from the property? What's your understanding of what the default was?
To my understanding, I don't get it, because like I said, from day one, after we signed the lease, we said, wait a minute, hold up. We may have to pay rent late because we're moving, we got to sell the house and everything else. So she knew that. And we even told her, because the way our pay period fall until we get situated, we're buying stuff to bring in, because we still was working as well and running the business. This is how we have to pay. You said, that's no problem, as long as you pay. She never charged us a late fee, not one time. Not one time.
The property, your property, the business's property that was in the building that got removed, do you know where it is now?
No.
Who physically, if you were there to watch it, was removing the inventory and whatnot from the store when it was being removed?
Okay, it was actually 5 people. It was Shay, Bobby, this girl, her partner chef that was next door, who put the stuff next door in the chef, the restaurant that she part owns. Her name was Whitney, another young lady, and he had her maintenance guy, what's his name? Michael, I believe his name was Michael. Yeah, it was those 5 that was in there removing everything.
Can you tell the jurors what a weep hole is?
I just found out from somebody, a professional had come and looking in the building. A weep hole is, I guess, for water to escape or something like that. And they're in those buildings, and if you don't seal them, the water gonna come in. He's like, they have these all in the building. We had someone professionally come out and look at this and no, these are weep holes. So the water, as you were seeing in the video, running through them, I mean, just running through the weep hole, that had nothing to do with anything we did. Those weep holes was in that wall, behind the wall.
Mr. Sterling, do you have any questions that follow up on the questions I asked?
No, Your Honor.
Mr. Williams?
No, Your Honor.
Mr. Woodward, thank you for your time. You're free to step down. Mr. Sterling, your next witness.
Plans to call John Wesley this time, Your Honor.
All right. Can we leave all the exhibits that are up there? Or the things you want to remove, or we're good?
We're good, Your
All
Honor.
right.
I don't think he's gonna need them, but we're good.
All right. Well, they'll be there in case they're needed. Mr. Wesley, come on up, please.
Here I am. We swear affirm that the testimony you will give from the truth, the whole truth, and nothing but the truth, so help you. Go ahead, have a seat. State and spell your name for the record.
My name is John Wesley, JOHN WESLEY.
John, tell us what it is that you do for a living.
So I work in the fragrance industry. I work as a consultant for an up and coming brand that will be released very soon. And I've been in the fragrance industry for over 20 years now.
Can you tell us the name, or not until it's released?
I can't until it's released.
You're under oath. Good luck with that.
Thank you.
Was there a point in your career where you were involved with Thomas LaVone LLC?
Yes.
Tell us a little bit about the role you played in the company.
Yes, I serve as co-owner. I work in sales and marketing development for the brand. So I essentially translate Thomas's designs into beautiful verbiage for marketing campaigns. I work on the visuals for the brand as it relates to any kind of campaigns and photography. Fashion shows in terms of like the presentation of the garments and in any other way that is possible to keep the brand working. In the capacity of the atelier, I worked mainly with building the sales directly with the clients, engagement, the window displays, that's my work in conjunction with Thomas. And anything on the creative side, visually or marketing wise for the brand.
And can you tell us a little bit about the role you played in moving the company from Northeast down to Atlanta, Georgia?
Absolutely. We had actually toured the Atlanta market for several years because I'm originally from Birmingham, Alabama. I started my career here in Atlanta in the late 90s while I was in college. And we thought that this would be a great opportunity for us to transition the brand from the Northeast to the South. I'm a native Southerner, he's a native Northeasterner, but after visiting and frequenting Atlanta for many times, I finally kind of convinced Thomas that this might be a great space for us to launch with. We would then receive, after a couple of years of a good run of marketing within UKL, UK Harper's Bazaar, GQ, Town and Country, Vogue, and a couple of other magazines, we decided that it was probably time for us to start looking for a brick and mortar space somewhere where we could really expand the voice of the brand and where we would have, I think, a customer base that would be intimately engaged in what we were doing. And we thought that Atlanta made perfect sense. Fortunately, we got an opportunity to launch with Macy's. We were chosen by Macy's to launch in a pilot program called the Market at Macy's, which is a pilot program where they invited up and coming brands to be sold in 12 stores nationally. We could have chosen any market that we wanted. Out of the 12, we chose Atlanta because this is where we had the relationships. And again, where I kind of built my career. So after doing that, we did a couple of pop-up shops all up and down the East Coast from New York, Washington, DC, Philadelphia, Atlanta, and then decided that maybe we should do more lengthy pop-up shops here in Atlanta, and which meant that we would spending more time here in the city away from our home. And during one particular time, we toured the Southwest area. I saw the space on Cascade Road and decided to inquire about it.
And did you, and following your inquiry about the space, did you ultimately participate in negotiating a lease or becoming a part of a lease agreement?
Oh, absolutely. Very definitively, we toured the space with the owner, Shay Embry, who seemed extremely excited to have something like what we offered in the community, and said that this was, a great opportunity for us. It was a great opportunity for her. We were initially interested in a smaller space that was maybe 400 square feet, something that we thought that we could really step out on. She said, absolutely not. You need to be on the front. You need to be on Cascade Road in my premium space. I think this would be great for you. We took the space. I was a little trepidatious in the beginning, only because I kind of budgeted in my mind for one thing versus the other, but she made it worthwhile. After touring the space and getting Thomas's co-sign on it, we decided to be courageous and put our house on the market in November and just go forward. Because at this point now, I had kind of stepped away from the industry. So it was like, go big or go home. So we signed the lease in November, put our house on the market in November, and stayed in contact with Shay Embry about the progress of the sale of the home, because it took a little time. We actually didn't complete the sale until the very first week of March, which is the start of the pandemic. And we moved here directly after the sale, and we were in the midst of the pandemic when we get here. So that's how we arrived.
And so the sale of your home in New Jersey didn't happen until March, but you were already here in December in your new space.
Yeah, we had already signed the lease for the space, and Shay had granted us, since we signed in December, 2 months free so that we could do build out. We weren't able to take advantage of those 2 months of build out because we were still in the negotiating phase of closing on the sale of the home. By the time that we got here in March, of course, the entire world was shut down. So there was really not much we could do in terms of our timeline of expectation in terms of opening. There's quite a bit of work to be done in that space in terms of rehabbing it and resituating it to be ready for the type of business that we do.
And if you look at plaintiff's exhibit A, is that the lease agreement that you entered into? I think you're in the defendant's exhibit.
Yeah.
Okay.
But it's exhibit 1 in there, so we can go either way. A is in evidence, but it looks like it's the same copy. It may be easier to find in the binder.
That's fine. You can look at the Bible.
Okay, I see the lease here, lease summary here at D1.
Is that the lease, and you've been in court, we've been talking about this, is that the lease that was signed by you and Mr. Woodard?
That is correct. This is what I remember.
And you were familiar with the terms of that lease and what was expected in that lease?
I am.
Okay. I want to talk about the as-is clause. What was your expectation in negotiation when you dealt with receiving the property as is?
Thank you for that question. My understanding was that the space had previously been a salon. It had been abandoned for some time. In order for it to be properly converted to an atelier, we understood that there was going to be some cosmetic shifts. Ms. Embry assured us that all of the infrastructure was sound. We were able to check all of the light switches to ensure that they were working. We were able to turn on the water in the bathroom to make sure that that was working. She did share in the very beginning that she would be making a change very shortly. She would be fixing the HVAC. She said that there was no heat nor air in the space and that she couldn't properly rent it without it being heated or having the ability to cool. And so that would be something that she would be working on. And very shortly after we acquired the space, she did exactly that. She went and worked on the HVAC, and we had proper air conditioning and heating while we were able to do our rehabilitation to the space.
And who was the primary point of contact in terms of handling the landlord-tenant relationship between you all and Ms. Embry?
So we both interacted with Ms. Embry for different reasons. She had her preferences of who she would chat with on various things. If it was something creative, of course, she went to Thomas. Over time, she would feel more comfortable in speaking with me on certain things. And we were fine with delegating those conversations.
And who primarily handled the payment transactions in terms of making the regularly scheduled payments?
So the regular scheduled payments were always handled by me, and that would be sent directly to Robert Flournoy, not Shay Embry. Shay Embry never took a payment from us. That was always something that Robert Flournoy took part in. And the way that would happen is because we lived in the same neighborhood, and I had their address, I could walk directly to Robert's address and, to his advisement, placed the rent inside his flower pot. And because he had a Ring cam, he could always see when I'm approaching the property. I would send him a text message to let him know that it is there. He would then reconfirm with a text message or a phone call, or sometimes he would actually come out directly after I placed it and say hello, say hi. But that was always the method, surefire every single time with no deviation.
And did you ever experience any issues, or was there ever any complaints in terms of your relationship with paying Mr. Flournoy and FloShea at the point where there were any issues related to late payments or partial payments?
So no, and I'm glad that you asked this so that we can clarify this. So the one thing that I will admit is the very first time that we sent direct deposit, I sent a check and it did bounce. And this is during the time that we were the sale of the home. So I never paid by check ever again thereafter. It was always by money order, and this was to ensure that they were properly paid. The other thing that I did to ensure that all parties were on the same page and so that we could have a good working relationship is I would always text Mr. Flournoy and Ms. Embry at the very same time. During the month, say, for instance, we're in March now. So if I'm going to make reference to an April payment, they would have already heard from me at the beginning of March about the date that I'm planning to pay in April. And that would always be around the 1st through the 5th. If there was any deviation, of course, in that time I would specify, and they would always text me back, that's fine, that's okay. But that was the way that I operated to make sure that everyone was on the same page. And so there were no surprises. You knew exactly when I was coming to the home to pay. I would always text when I'm walking en route, and I would always text after it was delivered. Even though they could see me on Ring Cam, I wanted to make sure that I had a paper trail and that they were responding to it. And there was never any deviation from that.
And did there come a time in 2022 where you had some issues with the property that you communicated to Ms. Embry or Mr. Flournoy?
Absolutely. So Ms. Embry actually changed the status of the as-is lease twice. So the first time is with the change of the HVAC. The second time is when she installed a new electrical box inside the unit. And she did this in 2021. I know that it was warm, so possibly summer, maybe even late fall. But at the time thereafter, Thomas kept paying attention to this condensation pipe that ran along the electrical box. And he and I discussed internally, how to bring up this discussion. Unbeknownst to me, he was texting her about it, and they were having their own separate conversation. I wanted to let it kind of play out to see how he was working through it with her. But at some point he wasn't getting anywhere. And so he asked me to formally address it. So this is when I put together an email along with photos of what it is that I'm asking to have rectified: the electrical box, the condensation pipe, along with the hot water. What was major about this issue is not just the electrical box with the condensation pipe, which could have caused an electrical fire, and then that would have been our fault, although we didn't install it. We also didn't have hot water and no capacity to have hot water, and we're in the midst of a pandemic. And what we later learned from having a plumber come and do an observation of the water there was that there was something to the effect of the water pressure wasn't strong enough for our unit to receive hot water, and that there needed to be some additional work done to the infrastructure in order for this particular space to receive hot water. So this was a disclosure that broker Ms. Embry never shared with us, that there was never any ability to have hot water, which I found extremely disappointed, because she's the broker and it is a part of their job to disclose the nature of buildings. So we made note of it. I asked in the email, how would you like to address this? Is this something that we should pay for and then it's coming out of the rent? It is something that you are taking care of? Please let us know. That's the essentially the communication. Her response back to me was a portion of the as-is clause. At this point, I realized that this isn't right, because she's altered the space twice on her own initiation, which means that it changes the state of our lease. So I decide, I share with Thomas, we've been paying for prepaid legal. So I decide to reach out and to find out what our options are, to find out what could be done, what's going on. At the time that this is happening, I actually have to travel away for work to Miami, and I'm gone for a few days. Thomas is there at the space. This is late February, and there's a flood. He calls and alerts me about it. I get back to Atlanta, I want to say somewhere around March the 1st. And while I am present in Atlanta, we get heavy rains in Atlanta that week. And at the time, Miss Embry was working on a water line for her upcoming restaurant that she co-owns with Deborah Van Trees called Aretha's at the Point. And she was working very tediously at getting this restaurant prepared to be open. And part of that had to do with a water line that ran along Cascade Road. The water line, access to the water was just 2 spaces away from our space. So there's our space, there's a salon, and then there's a sidewalk space where you would get access to the plumbing unit. So this was completely compromised. It was muddy, it was flooded. The rain was pouring. Our neighbor right next to us, their floor was completely covered in water. It was a salon and she was not open. So we texted her I texted Shay to please let her know that the tenant's space has flooded and that our space has flooded as well. I call Shay, she sends me the voicemail. I know that she's in the restaurant because there are people there working and she's working on the inside. I run around the building in the rain to flag her down and get her attention, like so she doesn't turn back around. So now we have to deal with the flood in real time. So this is where we start to document, to videotape exactly what is happening. And you can see the water literally gushing through the weep holes. So I definitely want to clear some things up as it relates to the construction.
So I'm going to pause you. This is a really long answer and you're going to need to ask some more questions because who knows?
Yeah, sure. I want you to look at the lease agreement, if you can, plaintiff's exhibit A or defendant's exhibit 1, and turn to page 5, if you would.
Exhibit 1 and file, I'm sorry.
Yeah, page 5. At the top, you should see it says tenant's trade name is Thomas LaVone LLC.
Yes.
And it talks about the permitted use of the building. Do you see that?
Yes.
And it was granting you, if you take a look, just read the first section of that, section 1.2, granting of the premises.
Granting of the demised premises, landlord hereby leases to tenant and tenant hereby rents from landlord the demised premises. As long as this lease is in force, tenant shall be entitled to use the common areas in common with landlord and certain other occupants of the building throughout the term of this lease.
And then the second part of that gives the landlord certain rights. And I want you to just read that. Gives the landlord certain rights to do things if they got prior written consent from you. Would you read that portion?
Landlord may increase, reduce, or change the number, dimensions, or location of the improvements comprising the building, excluding the demised premises, or any of them in any manner whatsoever as landlord shall deem proper, provided, however, that landlord may not alter the improvements comprising the building if it materially negatively impacts the access or any other material factor related to the usage of the demised premises as shown on the site plan without the prior written consent of tenant, which consent shall be unreasonably withheld.
Now, prior to putting in the electrical box and doing the water piping under your building, around your building, did you receive a request for your prior written consent?
No.
Now, when you spoke with Ms. Embry in text messages or emails about the issues you were experiencing, did she make any promises in regards to how she would handle those issues, the flooding and the electrical box?
No,
What was her response to you?
she responded back with to the email with an excerpt of the as is clause.
Now, did there come a time where you and Mr. Woodard started to make the improvements to the building yourself after the flooding and the cleanup and all of that?
Absolutely. Well, we were closed for several days after the flooding because merchandise is now damaged. There's water pooling all over throughout the space, also into the office. So we had to assess what had to be discarded, what was damaged, if there was anything that could be fixed, the cosmetic space, if there's any mold. All of those things had to be addressed by us immediately if we were going to reopen.
Was there merchandise on the floor? The videos we saw, while there was a lot of water, it seemed like it was on the floor. You stored garments on the floor?
No, but there are some gowns that touched the floor that actually got wet, which you cannot see from that first section of footage. So all the way over to the right, very close to what I would call my cash wrap, there were gowns on mannequins that actually touched the floor that got.
And the water would go right up in.
Absolutely.
And did you make, I want you to look at page 11 of the lease as well. Section 6.1, Article 6, repairs and maintenance.
You want me to read this aloud?
No, I don't want you to read it. I'm sure the jury's tired of hearing it. Did you make your request for repairs per the lease agreement to Ms. Embry and or her agents in writing?
Absolutely, and I went a step further. I actually included in the email while I'm addressing this issue, we had reached out to a plumber to get an estimate for what it would cost for us to have the ability to have hot water, because we clearly weren't going to touch the electrical box. That was something that she had installed, but the hot water was a pressing issue for us because we're just coming out of a pandemic, and I would have been very much okay with at least getting that up to speed. So we included a copy of the estimate that we received from a plumber to have that rectified.
And was it, and you also, and what other things did you do? You also sought, I guess, legal help and other things to try to.
Absolutely, yes. So we sought legal help. We also reached out to the city councilman in that district. That particular commercial district overlaps between two different city councilmen. We were not sure which councilman was responsible for that section of the commercial district. So this is where we devised an email, and I will definitely take ownership on this, of reaching out to both of them, to their chiefs of staff, to make them aware of what we were experiencing in the building. Ms. Embry had already shared with us who the council members were. We actually were members of the Cascade Business Association, which was a community business association that Ms. Embry led. So this is in addition to being tenants, we are also members of the same business community organization that she leads. So there were plenty of meetings where we would be introduced to the council members of any said district, the police officers of any said district, so that we would know who to reach out to whenever there was an issue.
And I want you to look at page 12, Article 7, additions and alterations. And it's the first section, 7.1, and I'm just going to paraphrase, but it allowed the landlord to build adjoining properties to you so long as it didn't adversely impact your ability to operate. Is that a fair summation of that paragraph?
I would agree.
And at the point it did interfere, you didn't experience any of these issues, the flooding, the electrical box condensation, until after Ms. Embry made these additions at joining your building.
That is correct.
Now, did there come a time where based on the improvements you had made, or rather the repairs that you were making for the flooding and the electrical box, all of these issues, where you believe you had the right to deduct the following month's rent or portion of it, or deduct some portion from the improvements you were making?
Yes, so I was really awaiting to hear from Ms. Embry how she wanted to handle it.
And let me, I'm stopping you. I asked that question inartfully, the repairs you were making. So you were handling the repairs of all of the flooding issues. Did there come a time that based on those repairs, you believed you had the right under Georgia law to deduct a portion of the following month's rent?
I definitely believed so. I definitely believed so.
And did you withhold for a portion rent in trying to get Ms. Embry to make repairs or deduct from the next month?
So what I did was I held on specifically to the March rent, because this is when we were receiving the floods, and this is when we didn't have the ability to be open for several days, and where I'm still kind of awaiting what my legal options are and to see what Ms. Embry is going to do about the situation. So there are several moving parts to this. So we were kind of standing still. But at some point, well before we get a communication from her attorney, I decide to just go ahead and pay the March rent. So we do this well before any acknowledgement of a letter of a notice of default or anything of like that. That was just operating in good faith. Again, please bear in mind, I've communicated each month ahead of time of when rent is to be done. March would have been no exception. The only reason why March is an exception is because of the losses that we are experiencing, and I'm not hearing what the landlord is going to do about this when I know that this is on her. So I'm holding the monies to see what we need to do and what I need to be ready for if I'm going to have to repair, if I'm going to have to give it up. But at some point, I just go ahead and pay it to just make sure that I can maintain the relationship that we built.
And so before you received any notice of termination or removal, notice of default or notice of termination, you had paid the rent for March.
Yes, I paid it on April 10th.
And then subsequent to that, did you receive a notice of termination or notice of default?
No.
Do you know when you first learned that you were in default or that there was a notice of termination?
Okay, so I do remember seeing the letter of the notice of default. Sometime I want to say in mid-April, I want to say one arrived at home, somewhere possibly around like April 15th. But by this point, I've already paid March, which is the only month that is in default, all right? Bear in mind that each month, and I repeat this, I've always communicated with my landlords of which date I'm going to be paying for the month that is approaching, so that all parties are aware. This is part of the reason why I was never charged a late charge, because I'm in constant contact and I've already received it's okay, thanks for reaching out, thanks for letting us know. So that absolved me from receiving any late fees. And it has been that way since the start of our business relationship. If there was any moment where I would have accumulated all of these late charges and defaults, we would have been evicted in 2019 or 2020 or possibly even 2021.
So just based on your pattern of doing business with Ms. Embry over the 2.5 years you were in space, you all had established a pattern of how you agreed to handle the rent payments and all of the payments.
Absolutely.
Now, when did you get the notice of termination?
I approximately remember seeing it about maybe April 15th, possibly.
And what did you do in response?
I shared it with Thomas. We talked about it, but I also remember referencing to him because he remembers the day that I walked to deliver the rent for March. So I'm like, these numbers aren't correct, for one. The amount that they're saying that we're in default isn't right. We're only 1 month behind, which was the month that we were in question about. And now that has been paid. We're now in April. And so I paid the April's rent 10 days after that notice, approximately, I want to say April 25th. And I did the exact same thing that I've done each and every single time. So after delivering the March rent on April 10th, I sent a text message to Mr. Flournoy confirming that I have sent the rent that is there in the flower pot. This is the time that he does not respond. So on April 25th, when I pay the April rent and I send a text message again and he does not respond, this is when I decide to send an email about confirmation of receipts of rent, because no one has responded to me and I need to make sure that I have a paper trail in line. I even went a step further as to take a picture of the rent as I'm placing my hand in the flower pot to have a timestamp on when it was delivered. So this is when Mr. Flournoy responds back in an email.
This was when, so you sent a confirmation of receipt, the email that Mr. Williams referenced earlier. And then that's when he responds back with we're only accepting partial, you're in default and your lease is being terminated.
Yes, and this is the very first time that you hear the words partial being referenced to any rent payment that has been made.
And so this is on April the 28th.
Correct.
And then on April the 29th, was that the day where the locks were actually changed?
Yes, that is correct.
Okay. And were you there when Mr. Woodard was escorted out and the locks were changed?
Absolutely. So
Can you tell me what happened on that day?
yes, so I received a call from Thomas while I'm working from home. Our business is closed that day, that Friday. We had planned to close that day because Thomas was working specifically on a project for a client who had an event that day. Ironically, this event was to be held on Shea Embry's property in the green space, a place where we had done events before. So the client was awaiting this skirt to be completed. Thomas is on the inside working on it. I am at home at work as well. Thomas gives me a call and says, Shea is here with the police officer trying to evict us. And I hightail it down. I get there, I see Shea Embry inside with police officer, Officer Muhammad, and a third unidentified male. I want to use the correct terms, sketchy, a very sketchy individual. And as I'm coming in, he is animating behind Miss Embry, very like aggressively. The best way I can say is like he's an amen corner to anything that is being said.
Now, on April the 29th, was there a conversation about the possibility of you all removing your stuff from the space since they were changing the locks?
No, but I did respond back to the emails that were sent.
But before we get there,
Yeah.
So on Friday, you don't recall a conversation between Ms. Embry, yourself, Mr. Woodard, the sergeant, the police officer, you don't recall a conversation about when you'd be able to get your stuff out after the locks were changed?
Oh, so after the locks are changed, yes, there is a conversation. So it's yes. The senior officer who is there on site, who comes back to admonish the police officer that Ms. Embry used to intimidate us out the space, comes back to create some resolution, so to speak. And he says to us very plainly, if you can go to Fulton County on Monday and get proof that there was no eviction filed against you, we legally have to open these doors back for you. And so Ms. Embry, Mr. Flournoy, Thomas, and myself are all present, and he sets the time. You have until Monday by 4 p.m. to have either provided this documentation or you have to have the space cleared out. Mr. Flournoy agrees. He is the one who unlocks the door for us to go inside to get a few belongings of ours that are present, and then locks the space, confirms with the police officer with us present and says, no one is going to be able to get into the space over the weekend. I have the key. You don't have to worry about it. Contact me on Monday with the time that you plan to arrive.
Were there any limits put on you as to what you could remove from the property when Mr. Flournoy opened it and you went in to get things?
No.
Sketches, anything like that?
No, there were no limitations. What Thomas expressed to the police officer was that he wanted to make sure that he had access to at least 1 or 2 sewing machines that he could get to, because completing this client's work was paramount. So the police officer, yes, allowed him to go in to grab the 1 or 2 sewing machines that he might have needed to complete the project, with the understanding that we were coming back on Monday with proof that there was nothing filed for us to be evicted.
And what about the opposite, right? If you came back Monday, you had until 4 o'clock to remove all of your stuff out of the space.
Absolutely. And Ms. Embry actually turns directly to me in the only way that I can describe as like very assuredly trying to reconfirm, John, 4 p.m. I'll never forget that.
And then what happened on Monday morning? Did you receive an email communication from Mr. Flournoy?
I don't recall seeing a communication Monday morning from Mr. Flournoy, but at that time, Monday morning, around the time that this email would have been sent, I am already at work professionally. So I would not have seen that email.
What does that mean, at work professionally?
So
I'm at work professionally.
My actual occupation at the time was director of sales for a fragrance company. So I was preparing for a conference call on that day with work.
Not Thomas LaVone LLC work.
Correct.
Different work.
Correct.
Okay.
Will you turn to in the binder, look at D17 that Mr. Williams talked about a little bit with Mr. Woodard?
To D17?
Yeah, D17.
It's the tab. Turn to the tab 17.
Sorry.
Okay, sorry.
Okay.
All right, tab 17. Yes.
And your email is themanagement@thomaslavone.com.
Correct.
And you're familiar that that's Bobby Flournoy's email address with Ms. Embry copied on it.
Correct.
And that was Monday, May 2nd at almost 8:56 a.m.
Correct.
And Bobby Flournoy sends you an email saying you have until noon today to and I'll unlock and let you remove the items.
Correct.
Did you, subsequent to that, get an ADT alert regarding individuals being in the building and seeing stuff removed?
Yes, we got 2 alerts.
And what time was those alerts?
It was around 10-ish. There were 2 alerts. One was that there was a possible unlawful entry. The second alert was that the security camera was damaged.
I want you to turn just 1 page over. Did you respond about approximately 40 minutes or so later to Mr. Flournoy and others?
Oh, absolutely.
And Mr. Williams talked about this a little bit, but it said, please be advised, there will be no removal today. And were you referencing removal of yourselves from the space, or were you referencing that you wouldn't voluntarily remove your stuff from the space?
Well, I was speaking to the understanding that there was nothing filed, right? So I was speaking to there would be no removal because I understood that there was nothing filed at the time. We had done some preliminary work before Monday to find out if there in fact was anything filed at Fulton County.
So you wanted the belief that because nothing had been filed to evict you, that you weren't going to be removed from the space?
Correct.
Well, I want to better understand this. There's this email from Mr. Flournoy saying, hey, let me know when you want to come by before noon and you can remove your items. You write back, even though you're at your professional job, your other job, 40 minutes later saying there will be no removal today, as in there'll be no removal of our property.
Correct.
Okay.
Now, are you referencing you removing the property or Mr. Flournoy removing the property?
Speaking in general.
No one's removing the property because there was no eviction filed.
There was nothing filed.
Now, when you get the ADT alert and you learn that stuff is being removed, what do you do?
I call 911. I called and asked to be connected to the sheriff's office because I then knew that it was Shay and her team inside. It was clear. Thomas ran directly to the shop and confirmed that they are inside. So there is 911 tape where me saying, I'm asking to be connected to the sheriff's office. There is an illegal eviction in place, and I list the name of the person who is involved and ask for police presence. And when I arrive to the shop, there may be 4 or 5 police officers there responding to that, one specifically from ADT, responding about the alert.
And when you arrived, what did you see in progress?
I saw Shay Embry, Robert Flournoy, their head chef from Aretha's, one additional restaurant staff, their lead construction manager, and this person who was involved on Friday with the police officer.
The sketchy guy?
The sketchy guy, yes. So there's three men, 3 women. They're all inside. They're bagging up all of our merchandise and things. And as the police go inside, well, first the police address us and we share what is happening. They go inside and then they take our, what I would call our backdrops for our shop. They take the backdrops and they close them together so we can't see what's happening on the inside. We can see hands at the wall reaching down and pulling things, but we can't see or hear the nature of the conversation that Miss Embry is having directly right there with the police. But the police are there from our call.
Did you make any plea with the people removing your stuff to try to get your stuff and allow you to take it?
Absolutely. We bring up the fact that this just happened on Friday, and the exact same document that Miss Embry is showing you, a letter from her attorney, is what she is using as justification for this illegal eviction. And that Fulton County is kind of unequivocal about these things, that if you are going to do self-help, what she has done is essentially the tried and true way of not doing it correctly, changing the locks, of intimidating people out of their space. So yes, we share that directly with them, that there was an incident on Friday.
I'm sorry, I didn't mean to interrupt you. And then even after that, did you make any efforts to Ms. Embry or any of her agents or emissaries to say, we've taken all of our stuff out, can we get it back?
At this point, because the police are involved and they are allowing them to go in and out of this space, take our merchandise in trash bags, all of our belongings, put them into their cars. They put them into her restaurant, into her freezer area. There was nothing that we could do. What we had to do at that time was make sure that each other was safe. We had to make sure that we didn't say or do anything that would put us in jeopardy or possibly have us killed.
And even after that, let's leave that day alone. After that, subsequent to that day, did you do anything to say, hey, can we have our stuff back?
Reaching out to them directly?
Yep, whatever, anything.
There was no more reaching out to them directly. We watched everything be dispersed in different directions at different times throughout the course of the hours of this whole monstrosity of a day. So to be able to know who to contact for what was very difficult, but it was very clear who orchestrated it all.
Did you reach out to any of the agents or emissaries of Ms. Embry to try and get your stuff? Or did anybody reach out to you?
So we reached out to the commissioner, and the commissioner was actually Commissioner Khadija Abdul Rahman. We reached out to her the day prior because we knew that there was something sketchy possibly about to happen on that Monday. And we needed to make sure that someone invested in the city, invested in the community, could be there to witness. There was no way for us to predict that it would be like this. But we're very fortunate that she and several other members were there to witness it in real time. And we witnessed the commissioner plead with Miss Embry. She walked over to her restaurant because by this point, her whole barrage of members have now moved into the restaurant to hide once the commissioner came on site. They went inside the restaurant. And so the commissioner went directly there to speak to them and asked them to come out. And we were able to see that. But at no point during that did we have any more conversation with Ms. Embry or Mr. Flournoy.
And then subsequent to that, you retained counsel to try to get your stuff back.
Absolutely.
And that was me.
Absolutely.
When did you first learn that all of your stuff had been destroyed?
The day that this was happening, that I knew intrinsically that somehow we weren't going to be able to get these things back. There were too many people involved and they were all going in different directions. And it seemed methodical and planned. So there was no way to hold any one specific person. Besides, we had to learn the names of some of these characters.
So the question was, when did you learn that the property was destroyed? Not when you had a hunch. When did you learn?
So when we had, I would say the pre-trial, the previous
But it would have been
conversation.
at the TPO hearing in front of Judge McBride.
That's when we learned, that's when I heard definitively that all of our items were destroyed.
And that was I had filed a restraining order on your behalf to try to get your property back.
Correct.
Nothing further, Judge.
All right, break time. Ladies and gentlemen, afternoon break. I'm going to try to keep it a little under 10 minutes so we can get about an hour of whatever is going to follow. Some of it will be cross-examination of Mr. Wesley. Don't talk about the case during your break. Deputy Gordon will get you in a little bit. Thank you. So you just keep that on a slippery placemat? I thought it was like on a stand. No wonder it falls. Okay. Really? All right. It's pretty dramatic. It's all right. We're going to take a quick break. Mr. Wesley, during the break, you're free to interact with folks. Just don't talk about your testimony because you're still under oath. Thank you. I'll be back in a few. Do I need to be? I gotta get that hair. No, I hear property guys. It's just one of the two property guys. I like that. That's much better than the property guys. Well, and he's got some pretty serious powers. The property guys, yeah, whatever he does, yeah.
Sorry. My favorite words. No, I don't need you, and yes, you're good.
Yeah.
So she could be here at 9.
And then we'll be done. I'll be done. It'll take 10 minutes.
Has Commissioner been waiting out there the whole time?
No, she's
good. Okay. Because I'll apologize on behalf of these guys if it's been like that.
I didn't subpoena.
I understand, but she's gonna connect it with all you.
Lucky we got
Who is that guy? Who is that masked man?
Yes, sir.
She doesn't hold those kind of grudges. You're good.
So who is that man? The commissioner's assistant. Oh, God, got it. With Fulton County. So the response that he got from Oak Street, I see it all over the internet about how we talked to him. Interesting. Not that that matters, but it doesn't, you know.
So. Yeah, so it stays on your knees and then the thing sticks to the top.
do that. I'm just.
Oh, yeah. I don't know what you did. Did you like,
No, I was sitting with my ankles crossed.
Yeah.
The angle, I guess.
It-
was a little steep.
tippy?
You reminded me, okay.
You got really excited.
Yeah. It was some question that you asked.
That was just
Yeah.
asked, right?
Maybe.
On this one, same as ordered.
Definitely a different
Nothing
perspective.
showing that about like repairs and required repairs in their complaint. You know, it's already but diverting attention, but they didn't sue for breach of contract. They didn't sue for tenant's failure to repair. And
Because they're lying.
well, it's been the recurring theme on that. And then I feel like it's 28. Let me confirm that though.
It is.
Okay.
They said, stated that they were told that they said that there was not enough water pressure coming in.
Mhm.
They have a 3/4 inch copper pipe coming in that space.
You can say
And
that
all they're
tomorrow.
running, the only thing they run is a hot water tank, bathroom sink.
You can say that tomorrow.
Oh, well.
Okay, I'm just gonna walk them through the lease.
Yeah.
And walk them through all those communications.
And then what time do we have to be back? Am I crazy?
Like 4:10.
Perfect. I'm right back.
Yeah.
You done, sir?
I'm trying to stretch my legs. Kind of need a little coffee and yeah.
Yeah, my ski knee is acting up. Going to sleep.
You just wait. Next will be gray hair and then your other knee.
Oh my God. No, I know.
What do you think of that?
Oh my God, that's unreal.
Yeah, think of the question.
He's doing what he's supposed to do.
No, I mean theirs.
Or whatever he does.
And it does sound terrible.
It does.
It sounds absolutely.
See, you're allowed to say that. We can't.
Yeah.
So,
So how late do they go? You said 5:30?
that depends on his questions. Then we'll probably end. We're not going past 6.
And then tomorrow.
9 AM.
Trick me. That's too a little too funny.
Yes.
I mean, it's funny now. I was 34 when I had my knee scope. I was playing soccer, but mine was from my English bulldog dragged me down. Chasing the dog, and I reached in and grabbed him by the neck and he threw me down to blow up my knee.
Yeah.
So then I hurt my back, and then it kind of went back into gears about when it started. So this stupid roller coaster at Six Flags The one they tore down.
Like,
No, but I mean, I remember leaving that one customer. Yeah, this guy back's killing me. Yeah. Hey, how are you?
I was in charge of their back, so.
Let's just go see that.
I'll make sure he's got battery. I'll make sure he's got battery.
Yeah. Oh, yeah, he makes that better.
Which I underestimated, listen, Rick, over.
You underestimated how long things would take.
I'll be done by 10:30. The other witnesses are very short. They're 10-minute witnesses, so I'm saying, yeah, I underestimated it by about an hour.
Okay.
But I anticipate being done no later than 10 or 10:30 tomorrow.
Okay. Hey, Mr. Williams, how long do you think your presentation will go?
I'm hopeful that I can finish it up within an hour.
Oh, I'm sorry, I wasn't. Mr. Sterling believes that he'll be done by mid-morning tomorrow, as in he rests. How long do you envision your presentation going?
We have one witness,
Okay.
an hour and a half.
So when you do our charge conference, we may talk a little bit about charges if I can look at some things when we're done today. So keep you a little bit late for that. But it sounds like we still ought to be able to get the case to the jury, just maybe a little later on Wednesday than we thought. And if they need to come back on Thursday for deliberations, they can do that. Okay. All right. Anything for the jury before we bring them? Anything we need to talk about before the jury comes in?
No, Your Honor.
No, Mr. Williams?
No, Your Honor.
All right, let's bring him in, please.
It's just those morning thing, everything in my life.
Fuck, well, that's crazy.
This is topping mine.
All right, so jurors.
It's like this right now.
Yeah.
Thank you, Deputy Gordon. You're doing a pretty good job today. Everyone can be seated. Ladies and gentlemen, Mr. Wesley remains under oath, and we're going to have Mr. Williams or Mr. Brickman start cross-examination of Mr. Wesley.
You're still stuck with me, Your Honor.
All right.
Mr. Wesley, you talked at length and the judge asked you some questions about your email where you went on that nothing would be removed. There would be no removal today. And your justification for that was because nothing was filed. What do you mean by that?
There was nothing filed at Fulton County.
So no, what you would call a lawsuit or an eviction.
Eviction.
dispossessory warrant, that my clients had not filed a legal action against you or Thomas LaVone LLC.
Based upon the examples you just provided, yes, those things were not filed.
And because it's your position that because none of those things were filed here at the courthouse, that it was an illegal eviction. That's what you characterized it as.
According to what the police officer shared with us, yes.
Did you verify what the police officer said with your attorney?
I'm sorry.
When the police officer gave you what sounds like a legal opinion, did you go back to Mr. Burrows and say, is what this police officer telling me true?
The assumption is that Mr. Burrows was our representative, and he was not at that time.
So did you go to any attorney at that time to say, this is what the police officer told me? Is this true?
We didn't have representation.
Did you go back to your lease to say, is what the police officer telling me what my lease says?
The lease at this point is now terminated.
But at the time, you didn't go back to your lease. You didn't see what could happen or didn't happen before it was terminated.
It was scorched earth at that point.
What does that mean?
It was scorched earth at that point. An eviction, illegal eviction had been filed. So at this point now I have to seek legal counsel. I don't have legal counsel, so now I have to find someone.
I'm confused when you said an illegal eviction had been filed. I thought,
illegal eviction had taken place.
okay.
And so when you say scorched earth, what does that mean?
Exactly that. This is now scorched earth. They have taken possession of our things. It was never evicted. Let's put that out. There was nothing of ours actually placed outside like a necessary eviction. This was Miss Embry, Mr. Flournoy, their chef, their lead construction agent, and one of their restaurant staff taking our merchandise, our possessions, our belongings, placing them in their vehicles and their businesses. That had nothing to do with an eviction, those actions.
Did your lease require anything to legally be filed at the courthouse or an eviction?
I can't answer that. I'm not a lawyer.
Let's look at the lease itself. It's D1 in the notebook, previously been admitted as plaintiff's exhibit A. The lease is not in dispute. Page 15, Article 10, default section 10.2. Do you see that section?
You said 10.2?
Yes,
Also
sir.
on the screen, whatever's easier for you to look at.
Okay, I see.
Upon the occurrence of an event of default, landlord may, at landlord's option, without any notice or demand whatsoever, in addition to any other remedy or right given hereunder, or by law or equity, do any of the more following things: terminate the lease, enter upon and take possession, alter locks and other security devices. Do you see anything in there that says that the landlord has to file a lawsuit, has to file an eviction?
I do not.
Do you think that this is wrong?
I don't have an opinion on it.
When you say scorched earth, you filed this lawsuit 22 days after this occurrence. Is that what you meant by scorched earth?
No,
What did you mean?
I mean that these are two businesses in combat with one another, and one has taken very aggressive, mind you, almost ridiculous steps to alleviate themselves of a business relationship.
And
That's what I
steps
mean by
that,
scorched
I'm
earth.
sorry, and steps that you've already testified that you didn't go back to see if it was allowed under the lease.
I didn't need to.
Why?
Again, law enforcement is now involved. Law enforcement has made a decision on what the next step should be. So that's what we pursued.
When you say that, I want to make sure I'm following you because you've described two different law enforcement scenarios. One is, I think you described him as a sergeant giving you this legal opinion that, hey, if there's no paperwork filed, they have to let you back in. So that's law enforcement being involved. You also described law enforcement being involved when they basically blocked your view of what was happening in the unit while things were leaving, and you had decided that you and Mr. Woodward better just step back and not be involved anymore for reasons that you described. Which of the two scenarios are you referring to as law enforcement was involved, so I didn't need to worry about what was in the lease?
The first scenario that you described, where the police officer shared with us that if we had provided proof that there was nothing filed with Fulton County, that there was no actual legal eviction. That's what I'm referring to.
Okay, thank you.
But law enforcement hasn't put you back in that space, correct?
We are not in the space, correct?
And if we look at Defendant's Exhibit 28, which has previously been admitted, which is the complaint. A complaint that was filed May 24th, 22 days after everything that we're talking about. I see claims for conversion. I see claims for fraud, theft by deception, theft by taking, breach of fiduciary duty, tortious interference, but I don't see a claim for breach of lease, correct?
It's not there.
I don't see a claim for breach of any duty to make repairs,
It's not there.
and I don't see a claim to put you back in the space that the police officer said the law required. Correct?
Agreed.
Okay. Let's look at Defendant's Exhibit 9. And we've established that of the two emails, the two email addresses, management at and president at, you're the workhorse, you're the management. You're management at Thomas LaVone LLC. That's your email address. Correct? Do you recognize Defendant Exhibit 9, which is behind tab 9?
I'm looking at tab 9. Yes, I see.
Look in the middle of the page. The top of the page is an email from you, management at, to your attorney. And that's dated May 2nd, 2002. This is what was submitted as an official document for eviction. The middle of the page, do you recognize that email from Ms. Embry, April 27th?
I do.
What does it say?
You would like for me to read this. I'm understanding.
Yes.
Okay. John and Thomas, our attorney sent the attached letter to your attorney. There was no response. While we have been instructed by our attorney to change the locks, we would like to give you time to remove all your things before we do so. Please advise. If you do not have everything removed by 4 p.m. April 28th, we will change the locks at that time. Shay and Bobby.
And the header of this email is lease termination.
I'm sorry, I didn't do that.
Number 9. I'm sorry.
Okay, all right.
Your Honor, I move to admit into evidence Defendant's Exhibit 9.
No objection.
D9 is admitted.
So that email is April 27th, 2:48 p.m. Let's flip to D10, the next page. Email from you, management at, to Shay and Bobby, with a copy to the president at April 28th, 12:59. This is an email I think Mr. Sterling was asking you about, and we'll go ahead and get it into the evidence. This is the one that says confirm receipt of rent. You recognize this email?
Absolutely.
What is, we'll move to omit Exhibit D9.
So 9
D10.
is just admitted? This is
D10.
10. Any objection to defense 10?
No objection, Your Honor.
Also admitted.
April 28th, and you testified, I believe, that your March payment of rent was paid April 10th. April payment of rent was paid April 25th or tendered. Is that correct? About those
Approximately
dates?
April 25th, that's correct.
And under the lease, when were your rent payments due?
They're due on the first according to the lease.
Let's look at D11, the next tab. This purports to be an email responding to that previous email from Bobby, April 28th, 3:11 p.m. Do you recognize that email?
Yes.
Your Honor, I move to admit into evidence D11.
No objection.
11's admitted. It was already admitted through Mr. Woodward.
I think
It's
you're right.
doubly admitted.
Mr. Brickman is not
We'll
keeping
send two
good,
copies out to
Mr.
the
Brickman
jury.
is not keeping good notes.
Okay,
It's my fault. Your Honor, I apologize for that.
okay.
In this email from Bobby, he's saying we have received and will be returning the partial payments of rent because the lease was terminated April 21st. Did you know your lease had been terminated April 21st?
At the time that I received this and read this, I did not.
Attached to, if you look at the bottom of this email, there are two attachments, notice of default, termination of lease. Had you seen those documents before this?
No. Well, let me take that back. The notice of default is, that's the letter that is addressed from your firm. That is the letter that I saw that I said that I received by mail as well as by email, that I recognize seeing it about the 15th or so.
So let's look at that. Exhibit D5. This is the letter dated April 11th, titled Notice of Default from me to Mr. Burrows, your attorney at the time.
I do not confirm Mr. Burrows was my attorney at the time.
Did you ever notify anyone that Mr. Burrows was not your attorney?
I notified the law firm that we have ceased a business relationship. They are no longer representing us, which is who I needed to notify.
Let's look at this notice. It's your testimony that you did receive this?
Yes.
Do you know when you received this?
As I shared earlier, I remember seeing this approximately April 15th, which is 5 days after I've already paid the March payment.
But you hadn't paid April payment by then.
Confirmed.
Let's look at the third paragraph in this letter. But first, let's talk about that second paragraph. Second paragraph says landlord is in receipt and acknowledges your email correspondence dated March 22nd, 2002. That's the email from Mr. Burrows. It's saying, we understand our obligations under the lease. We invite you to elaborate specifically on plumbing and electrical issues and to provide additional documentation. And you see that last sentence, landlord will abide by the terms of the lease and its obligations, including any such repair, replacement, and maintenance owed. You see that?
I see it.
And you read that then when you received this on April 15th, 4 days after it was emailed and mailed?
I read it.
The next paragraph says, regardless of any of that stuff, you still got to pay your rent. First day of each and every calendar month throughout the term. And that you had failed to pay March and April, and you were deficient January and February, and that you owed a total of $5,080.24. Did you see that?
I saw it. It's incorrect.
And your testimony is it's incorrect because you had paid March by this
I paid
point.
January, February, and March.
All of rent, CAM, late charges, everything that was owed.
Thank you for that question. So CAM, as you referred to, for the tenants of the Point at Cascade could be paid either semi-annually, which would mean it was due in June, or it could be paid annually, which you could pay the full year by the year in December. You had more than one option. with Miss Embry and Mr. Flournoy, in which CAM could be paid. Rent was totally different. That had to be paid every single month. But Mr. Embry and Mr. Flournoy gave every business that was a tenant within Cascade at the Point leniency on the triple net charges.
And those leniencies on the triple net charges started during COVID, didn't it?
I can't confirm that.
Because the leniency that your landlord extended to all the tenants was to excuse part of the CAM during that COVID period of the closures.
I cannot confirm when that started from her part.
Let's look at the second page of this letter. The second full paragraph. It's been your testimony, and we don't dispute. You had paid late occasionally. That had been an understanding. They had accepted late payments or partial payments. But let's look at this second full paragraph. The landlord does not waive strict compliance with the lease. So basically, what we've excused to date, we're not going to excuse going forward. You saw that in this letter.
I see it's printed.
Your Honor, I don't believe Defendant's Exhibit 5 was previously entered, and we tendered that into evidence.
Any objection to defendants 5?
I don't have the objection, Judge.
Pardon me? You don't have?
No objection.
Okay, admitted.
Thank you, Your Honor. And that last paragraph in Defendant's Exhibit 5, in the event that tenant does not cure this event of default within 7 days, landlord may, at its sole option, without any notice or demand whatsoever, in addition to any other remedy or right granted by the lease or law or equity, and we see once again repeated what's in your lease, terminate the lease, enter and take possession of the premises, alter the locks, change the locks. That's in this letter, right?
I see it printed.
Let's flip to Defendant's Exhibit 7. This was the second attachment to the email back and forth between you and Bobby. The notice of termination of the lease dated April 21st, 2022. Directed to who everybody assumed was your attorney at the time, Mr. Burrows. Did you receive this letter?
No.
When was the first time you saw this letter? Is it April 28th when you and Mr. Flournoy were emailing back and forth?
I can't recall as it relates to this specific letter. I take that back. If this is notice of termination of lease, this must have been the document that was attached to Mr. Flournoy's response to my request about confirmation of receipts of rents in question.
And that email was the email that says, we're returning these we're returning these rent payments because the lease has already been terminated.
It says that it was returning a partial payment.
And those emails, the email from you is Defendant's Exhibit 10. The email from Bobby is Defendant's Exhibit 11. That same day on April 28th, a couple of hours later, if you look at Defendant's Exhibit 12, do you recognize this email?
Let me read this.
Of course.
Sure.
Of course.
Which exhibit?
12.
Oh, yes, absolutely.
This is an email from you
Oh, yes, absolutely.
directly to Shay and Bobby.
Yes.
Your Honor, I move to admit into evidence Exhibit 12, defendants.
No objection.
Submitted.
Why'd you write this letter, this email? What does it say?
So I'll read the email first, as you requested, and then the first part of your question, you'll have to repeat so that I can make sure that I answer that.
Of course.
So the email says, "Hi Shay and Bobby, please note this is a communication between legal counsel, not an eviction notice. I'm referring to the letter that is attached that says notice of default. Thank you for sending this over. We will be sure to share this with the city. Please also note, we have proof of the submissions of rent and text messages confirming. Your response to this email is proof of receipt also. Thanks again."
And we've gone through ad nauseum, it seems like eviction notice and filings and all of that. What did you mean by we will share this with the city?
Exactly what I said.
Which is what? Who were you sharing it with?
Council members, mayors, key players who live within the southwest area of the city, people who had visited our shop, who witnessed the trajectory of the brand, who were very important to the city, those people.
And what was the point of sharing it with those
To
people?
share our experience, what was happening.
And what were you saying in those sharings?
We were apparently in a building where an owner had received funds, possibly from the city, to improve that building. Those rehabilitations, those advancements had not been made. And now all of the tenants of this said commercial district are in very predatory leases, 30-page leases, I might add, that have numerous different facets of them that limit the power of the actual tenant, but all the while creating avenues where the landowner could take additional funds from those tenants and pad their pockets without ever being responsible for the health and wellness of the buildings that these tenants are now renting. I hope that clarifies it.
So to unpack that, you were talking to the city, talking to city council members, talking to leaders in your community, MPU, neighborhood planning unit chair, that your landlord, your property owners were taking advantage of you?
There were multiple aspects to this conversation. I wouldn't use the words taking advantage. Those are your terms. What I will say is that I was leveraging this opportunity to bring attention to what was happening to us as tenants and other tenants of Shea Embry.
And what you're bringing attention to is that you signed and agreed to a 30-page lease that had self-help remedies in it that you didn't know about, that your landlords executed on.
That's not my answer. That's your answer.
Okay.
My answer is I was working to ensure that there was a platform which tenants could share their experiences about the nature of the spaces that they're in, the condition of those spaces, the lack of hot water, the lack of it being addressed, these electrical boxes that were being put into spaces without being inspected by the city. The questions about how much funding was actually going into this project called the Cascade at the point, and what was supposed to be the final outcome. Because you have to understand there's several articles written about this project, right, over a course of years, and where numbers are specifically listed about how much money is supposed to go into the development of that project. So if that's the case, then the tenant should know how that money was going to be used to benefit their businesses or the buildings that house their businesses. I hope that clarifies it.
Yes, thank you. Were you reaching out to accuse my clients of misappropriation of funds or misuse of funds?
I reached out to get clarity
What does that
on
mean?
what funds have been allocated for this said project and how were they being watched and or accounted for. As a member of the community, not only as a resident, but also as a business owner in that community, it's my right, it's my duty to look for that information.
And this is part of the scorched earth.
No, her actions made the scorched earth.
Your Honor, I move to tender exhibit number 12.
No objection.
12 is admitted.
Defendant exhibit 13. The next page.
12 had already been, I mean, you had just so the record doesn't make us all sound confused, during the course of your discussion with Mr. Wesley about 12, you admitted it. So,
If there's anything confused, it's not the record, it's me.
okay.
13. Defendants Exhibit 13. Do you recognize this email?
You said D13, am I correct?
Yes.
Yes, absolutely.
And this email is from you that same day, same thread, August 28th. This is at 6:08 PM. So just 15 minutes or so after your last one. This is your email to Bobby and Shay again, correct?
Absolutely. Would you like for me to read it?
Let's get it into the evidence first. Your Honor, I move to tender this into
Sure.
evidence
I
D13.
think it's April 28th and not August, but I want to make sure I'm reading it correctly.
You're correct. I'm trying to
Okay.
rush.
April 28th. No objection. It's admitted.
I'm writing down admitted now. Mr. Wesley, you offered to read this. It's very short. We can put it up on the screen. Go ahead.
You will hear from the attorney regarding this false eviction letter.
Who is the attorney?
Not stated at the time.
Was it Mr. Burrows at the time?
As I said and stated earlier, Mr. Burrows did not have a relationship with us at this time.
But this email doesn't say Mr. Burrows is no longer representing us. You will hear from a different attorney.
No, it says exactly what it says. You will hear from the attorney regarding this false eviction letter.
Defendants Exhibit 14. Another email, same day, 10 minutes later or so, April 28th, from Shay Embry to you. Do you recognize that email?
Absolutely.
Your Honor, I move to admit into evidence Defendant Exhibit 14.
Objection.
Admitted.
Email, we can put it up on the screen. Thomas and John again, is Mr. Burrows your attorney? When you told us you were represented by him, we must communicate through your attorney. Since Mr. Burrows has failed to communicate, we are asking that you provide an attorney that we may communicate with. You see that?
Absolutely.
Defendants Exhibit 15. Thursday, April 28th. 4 minutes later, 6:22 PM. Email from you to back to Shay and Bobby responding to that previous one. Do you recognize this email?
Yes, I do.
Your Honor, I move to admit into evidence Defendants Exhibit 15.
No objection.
It's admitted. If you were getting in a series, what you could do, if there are a few more, is say, hey, Mr. Wesley, why don't you look at 17 through 19? Do you recognize all these? Are these all emails? And then we can get them in at once. If you want to do that.
That would have been smarter and a better use of time, Your Honor. Again, in this email in Defendants Exhibit 15, your attorney will be contacted. Correct?
Correct.
No statement that Mr. Burrows is not your attorney.
It says your attorney will be contacted.
So I kind of interrupted you with the whole introducing things. Did you want to tender 15?
I think we did, Your Honor.
Okay, just in case you didn't, it's admitted.
I'll tender.
Okay, I may have, instead of writing down as I was, that may have been when I tried to hand you the little light bulb. Just admit them all at once.
I got two more.
Okay.
So we'll cover these last two together. Let's look at Defendants Exhibit 16 and Defendants Exhibit 17. These are different dates. Do you recognize Defendants Exhibit 16 and Defendants Exhibit 17?
Absolutely. Both?
The 16, I can confirm. Yes, I can confirm.
And 17 is 2 pages, and I believe 17 is already admitted, and you. Is that right?
I think 17 is.
I don't have that. It may have been admitted as one of yours, but I don't see it.
I don't have it as admitted.
Okay.
No objection, Judge, to both of them.
Okay. Without an objection, 16 and 17 are admitted.
Defendant's Exhibit 16. The top of that is you forwarding this email to your attorney. But the meat of it is another April 28th email, this time earlier in the day, 1:04 p.m. This is from you to Adrian Bond and MPUR.EXC. Who are those folks?
The MPUR chair, Andrea Boone, is the city councilman who's responsible for that district.
And so this is you reaching out to this. This is one of the times that you reached out to the city that you said that you were going to do in an earlier email.
Confirm.
Why did you send this email?
To bring attention to what was happening.
And what was happening?
We had floods. We had a landlord who refused to correct the electrical box that she installed with the condensation pipe that ran over it that could cause an electrical fire. We had multiple floods where days we could not open. And now we're being threatened to be evicted as we're asking for help with that. And as we're learning that this possible landowner would have received funds from the city to improve those buildings, and it's not done. So yes, we're asking questions, we're asking for help, and we're doing our due diligence by utilizing the resources that the city has provided, i.e. the Excella website, to double check to see what has been done.
And the last paragraph here, you're talking about the success of the grant would have been spearheaded by Councilmember Overstreet and Corliss Clare. Did you ever reach out to Councilmember Overstreet?
Oh, absolutely.
And she told you that your landlord was within their rights, right?
No,
No?
that's not what she said.
In this email, it says she refused to meet with you.
Yes, that's different from what you just said.
Okay, just making sure. Defendant's Exhibit 17. First page, May 2nd. Email from Bobby to you. May 2nd, I'm available until noon today to unlock and let you remove your items. Now, we saw in all these notices, all these emails, offers for you to come get your stuff, dates for you to come get your stuff, opportunities for you to come get your stuff. Had y'all moved out anything in any of this process?
As shared earlier, when the police arrived to admonish the other police officer that Miss Embry hired to help intimidate us, the sergeant who recognized that police officer that Miss Embry hired to intimidate us, then shared with us, Mr. Woodard, myself, Mr. Flournoy, and Miss Embry, again, the conversation of if you go to Fulton County on Monday and can get proof that there was no eviction filed, we legally have to open these doors, right? So this is how this conversation started.
And you've testified that you went down and there was no eviction filed, there was no paperwork filed, correct?
Correct.
And the doors haven't been opened.
So thank you for that question. The doors were already closed and locked before we could actually get to Fulton County. So the day that that the police has advised us to go to Fulton County to get the documentation that no eviction is filed, this is the day that we get the alert on ADT that someone has made an unlawful entry. About 10 or 15 minutes later, we get a second buzz where our camera is now damaged. All right. So during the time frame by which we would have arrived at Fulton County, gotten our documentation to bring back to present to the police, as well as to Miss Embry and Mr. Flournoy, that nothing was filed. The attack was already in motion. So I'm not sure if I can't speculate. I don't know if Mr. Flournoy sent this while he's actually in the space. I don't know if he did it in the car. I don't know when or where he was. What I do know is that 1 hour later, they are already inside and bagging up our merchandise. So what was this email about?
And the question I asked you was, you said the police said that they would reopen the doors if nothing was filed. The doors have not been reopened for you.
We had the option to have those doors reopened in the previous hearing that we sat at. And the judge asked us, well, I can grant you entry back into the space.
Your Honor,
He did say
entered an
that.
order.
Stop. Yes.
You've entered an order on that previous motion and that TRO. That should be what the evidence is.
Okay. Just thinking through, I don't remember everything that's in the order, and I understand where Mr. Wesley's going based on some things that were discussed there.
Your Honor, we withdrew, and then your court made an order because when we learned that stuff had been destroyed, we withdrew the injunction, and your Honor entered an order declaring it as moot since we withdrew the request.
Right. So I'll just clear all this up because I don't want this lingering because it's not germane to what you all need to work out. I may well have said at some point during the TRO hearing, I could provide the relief of letting the plaintiffs back into the space, but isn't that moot because we've received information that the space is empty now? So yes, the doors would have been unlocked. To what point you could have confirmed that the space was empty, i.e. the property was gone. I think that's all that
I'm fine with
came
that,
out of
Your Honor.
that. So that's where we'll leave that.
I'm fine with that.
Okay.
No further questions, Your Honor.
All right. Do you have any redirect?
I do, just, it won't be long, Your Honor.
Okay.
I want to go to section 10.1. I'm sorry, 10.2. In the lease, it's page 15. Let me know when you're there, Mr. Wesley.
You said section 10
Yeah.
of the lease?
Yeah, Article 10, Section 10.2 of the lease, under default. The 10.2
Yes.
landlord's rights on default.
I'm here.
Mr. Williams walked you through on cross-examination about what would happen on the occurrence of default and talked about the fact that they could take possession of the premises, they could change the locks. Is there anything in there that gives them the right to take your property and destroy it as a result of a default?
I do not see that.
Is there anything that gives them the right to take your personal effects, property, intellectual property, tangible items, put it in their own personal vehicles and drive away with it?
I do not see that.
Now, they could take possession of the premises and expel you from the premises based on that default, is that right?
That is correct.
And they could terminate the lease, and you'd have to surrender possession of the property, is that right? Of the space, is that right?
That is correct.
But there's nothing in the landlord's rights on default that allows them to take all of your items and destroy them.
That is correct.
Now, I want to take you to look in the binder defendants exhibit 28, which was the complaint. Now, you're not a lawyer, is that right?
That's correct.
I drafted this complaint, is that right?
That is correct.
And Mr. Williams asked you several questions. He asked you about whether or not you tried to get back into space, whether or not you tried to get the items back. Is that right?
That's correct.
He asked you questions about whether or not you were suing for a violation of the lease. I want to turn your attention to page 9 of that document.
Okay.
And paragraph 68. So when he asked you about the relief that you were requesting when this was filed on May 22nd, now you didn't file this on May 24th. You didn't file that on May 24th. I did, right?
Correct.
You don't have any control over my schedule on when I can file things. Is that fair to say?
That is correct.
Okay. All right. Would you have liked me to file it sooner?
Would have loved it.
Okay. Now, on paragraph 68, you requested, we requested in this thing, it's called injunctive relief and temporary restraining order, is that right?
That's correct.
And among the relief we requested is, if you look at 68 B, requiring defendants to return all of plaintiff assets to 2291 Cascade storefront. Is that right?
That's correct.
And if you look at D, granting, D as in dog, granting plaintiff's request to move back into their 2291 Cascade storefront as per their lease agreement, and requiring defendant to make necessary repairs to ensure the business is in a safe condition for customers and the business owner. Was that also filed?
Correct.
So there was a request to get your assets back and to allow you back in the building to fulfill the obligations of the lease in your initial filing.
Correct.
Now, I want to take you to Defendant's Exhibit 9 that Mr. Williams talked with you about. Now, in here, there was an email from Ms. Embry on Wednesday, April 27th. Said, our attorney sent the attached letter to your attorney. There was no response. While we've been instructed by our attorney to change the locks, we would like to give you time to remove all of your things before we do so. Please advise, if you have not removed everything by Friday, April 28th, we will change the locks at that time. Is there anything in that communication besides changing the locks?
No.
Anything in that communication that led you to believe that they were going to go into that store, take all of your stuff and destroy it?
No indication.
Exhibit 10. At the bottom, you're asking for confirmation of receipt of rent. In that email, do you inform both Shay and Ms. Flournoy that you submitted rent as usual, and it was the second time you had not received confirmation of the receipt of rent?
That's correct.
Meaning you had previously paid and didn't receive the confirmation, and you had paid again and did not receive confirmation.
Correct.
And you were trying to make sure they got what they needed in order to confirm that you paid the rent,
Correct.
so that you wouldn't be in default.
Correct.
Now, Mr. Williams talked to you about a letter he sent to the attorney that you had once used through prepaid legal, Mr. Burroughs. I believe it's Exhibit 11. Is that right?
The default is 5, if that's what you're looking for.
Thank you, Judge.
You're welcome.
I'm not as good, but my assistant is up here with me. Now, I want to talk specifically about, now, this letter comes from Mr. Williams, is that right? From Kyle Williams?
Which tab? I'm sorry. I thought we said D11 or
D5, I'm sorry, go to
D5.
D5.
Okay. Okay, yes.
Now, and go to the second page. Mr. Williams talked to you about this language here. It says, landlord does not waive strict compliance with the lease. No failure or delay of landlord to exercise any right or power granted under the terms of the lease or to insist upon strict compliance or obligations thereunder. No custom or practice of the parties at therein shall constitute a modification of the lease or a waiver of any right of landlord to demand strict compliance with the terms of the lease. Right?
Correct.
Now, he doesn't cite any statute in that, like a Georgia statute or code, right?
No.
He doesn't cite any particular case that supports his position on that. Is that right?
That's correct.
And he's sending this to an attorney who no longer represents you.
Correct.
Right? And I respect Mr. Williams, but his opinion, and often lawyers disagree, does not necessarily mean that is the fact of the matter. It's not
Correct.
fair.
Correct.
So a letter from Mr. Williams would not necessarily, is not the same as receiving a ruling from Judge McBurney.
Absolutely.
His letter is not legally binding.
Absolutely.
No further questions, Your Honor.
It's more of a recross than a redirect, but okay. Mr. Williams, any questions?
Maybe I'll redirect. Very quickly, Mr. Sterling walked you through the lease, and as you've already testified to, you think this is a 30-page long lease that you missed some stuff on, right?
I didn't say that.
But you said,
I said it's a 30-page lease. I didn't say I missed some stuff.
okay. So section 10.2, page 16, and the lease is not in dispute. And I can say what I think the lease says, but y'all going to see what this lease says, and y'all going to be able to read what this lease says. Mr. Sterling tried to make a big production about some kind of obligation of us to keep your stuff or store your stuff or not remove it from the premise. Let's look at what the lease says. Top of page 16, about midway through that top paragraph. Tenant hereby consents after any event of default, and an event of default is not paying rent on time, to the exercise of dominion over tenant's property within the demised premises. So if you default, you consent to the exercise of dominion, which is control over your property in the premises. You see that sentence in this, and I'm sure you're going to disagree with it, but you see that sentence in this lease. Section 11.7. Page 19, section 11.17, surrender of the premises. That second paragraph, prior to the expiration or sooner termination of this lease. At its option, tenant may remove any and all trade fixtures, equipment, other unattached items which tenants may have installed in the demised premises, including but not limited to counters, shelving, chairs, unattached machinery, and we've heard a lot about sewing machines, purchased or provided by the tenant, so long as they don't damage the building. That last sentence in that same paragraph, if tenant shall fail to remove its trade fixtures or other property, such trade fixtures and other property not removed by tenant shall be deemed abandoned by tenant, and at the option of landlord shall become the property of landlord, or at landlord's option may be removed by landlord at tenant's expense or sold or otherwise disposed of. And I know you're going to disagree with that, but that sentence is in this lease.
I don't disagree with that.
Section 11.8, second paragraph. If tenant fails to surrender the demised premises upon the termination of the lease, in addition to any other liabilities to landlord accruing therefrom. That meant if they still wanted to come after you for rent. Tenant, not landlord, shall indemnify landlord and hold landlord harmless from loss or liabilities resulting from such failure, including without limitation any claims by any succeeding tenant founded on such failure. That's also in this lease, right?
I see that.
No further questions, Your Honor.
All right. What I'd love to do with your permission is field your questions so that we end the day by closing with this witness. But that'll mean staying a few minutes past 5. Is there anyone who can't do that? Seeing no hands. If you'll write your questions down, Deputy Gordon will collect them and we will expeditiously go through your questions. But take the time you need to write them down. Handwriting was good. Probably 5 questions on one card is pushing it. It was really small print. Just FYI to Mr. or Ms. 5. Sir. Lawyers, please.
How's it feeling? You saw.
Yeah, I'll see how hungry he is.
What?
Cheers.
Oh, yeah. No. Not silly. I got 5 this morning. It's like,
Mr. Wesley, have you retained any evidence of making the rent payments when you did? Either text messages saying, I sent this, or ring cam footage, or the bottom half of the money orders?
So yes, we kept the bottom half of the money orders. In terms of ring cam film footage, you probably have to get that from Mr. Flournoy.
Because it was his ring cam, not yours.
Ring cam that would have seen each time that I arrived on the property and dropped the rent off, followed by the text messages. So if there's a need to subpoena the text messages, that's definitely, available.
Okay, it's nothing you have with you.
Not on me today, no.
Okay, and the money order receipts, where would those be?
Oh, so we kept all of the actual stems of all of the money orders that we paid over the course of time.
Kept them where?
We would keep them in our file, our accounting file. Sometimes I took pictures of them. If there's a specific month that needs to be referenced, that might help me better find that record.
You don't need to, if it's not in your pocket, there's nothing you need to produce right now. I guess what I'll ask is, those paper receipts that you have, or the digital versions, those weren't lost when property was removed. Those are things you still have, you just don't have them with you right here.
Correct. So yeah, we either took photos of them, particularly during that time, the March and April. The last one for sure, I know I photographed where I'm putting it directly in the flower pot. And the one prior March, I may still have the stems for.
Okay. Was the rent ever paid on time, by which I mean the date that was established in the lease, so the first of the month?
I never paid rent on the first.
The flooding that was documented in the videos we saw, was that coming from rain? I understand it was coming through weep holes under the door, but was that because of rainy day events or because of plumbing issues, a pipe burst or something like that?
Both issues. So the rain impacted the work that they were doing on the water line. They were working on a water line for the restaurant that sits in the back of our space. Right adjacent to our space was a salon. And because it sits on a decline, the water would flow from that water unit into the adjacent salon. When that filled, then it would decline into our space, because we were at the lowest point of the block.
But when water would come in, it was because of rain. It may have been exacerbated because of the plumbing, but it wasn't because of a burst pipe, if I'm understanding correctly.
I can assess that from a plumbing perspective as to what came in. All I can tell you is what I visually saw.
Well, was there ever flooding in there when it wasn't raining?
No.
Okay. You, in defense 16, so tab 16, if you'll turn to that, you sent, it is an email that you sent to Council Member Bond, copying Council Member Boone and NPUR. And in it, you are sharing floodings that occurred on April 5th and 6th. The question is, wait, was the flooding in April or was it in March?
That's a typo. That was March 5th and 6th.
Okay. So there weren't two different sets. It was the March incidents that we saw on video and that you've been describing.
Absolutely.
All right. We have some very attentive jurors. On May 2nd, who went down to county offices, you or Mr. Woodward?
Thank you for that question. So we couldn't make it to the county offices until the 3rd. Once we got the alert on ADT, Thomas went initially first. I had a conference call that I had to take for work. Immediately after I got off the conference call, I ran to the space. The next day, after all of the melee, I then went to Fulton County to see if I could get a physical copy of what we were looking to have on Monday before they started their attack.
So May 2nd is the day that your belongings were removed, the property was removed?
Correct.
And on that day, neither you nor Mr. Woodward actually went down to Fulton County offices, whether it's magistrate court, superior court, whatever. Neither one went down.
No, not that day, because it already started that morning.
Okay. Had you done any research between April 28th to May 2nd to see if there had been anything filed by any of the defendants that would constitute documentation that would support a dispossessory or an eviction.
At the time between the 28th and the 2nd, no, on the 28th is when we had the encounter with the police officer where he tells us to get the documentation for the 2nd.
And between the 28th and the 2nd, it sounds like then, if I'm understanding your answer, neither you nor Mr. Woodard actually did anything to confirm that there was no documentation.
There's no way to, it was a weekend.
Well, 28, 29, 30, May 1, my birthday, May 2. So 5 days. That some of that must not be a weekend.
So the attack happened on the Friday, where the first attack happened on the Friday. The following.
So I'm confused by the word attack.
I'm sorry. Okay.
We've got the 2nd when property was removed.
Sure.
You can put any label you want on it.
Yep.
What was the other event to which you're referring?
The first where Miss Embry comes in with the police officer to intimidate us out the.
And sketchy guy.
Yes.
Okay, and that's the 28th?
That's the whichever Friday is. And so I do not say the wrong thing.
Okay.
It's either the 28th or the 29th, whichever day is a Friday. So that is the reason why we couldn't go to Fulton Counties, because we have a Saturday and Sunday. The earliest we can get there is Monday, if I'm not mistaken.
Okay. Got it. Friday, I'm taking judicial notice of the fact that April 29th was a Friday and May 2nd was a Monday. So the 29th, it was the Friday, was the encounter with Officer Muhammad and others. And then you've got Saturday, Sunday, county office is not open.
Correct.
And then you've got Monday the 2nd.
Correct.
When neither you nor Mr. Woodard went down to, because things started happening in the morning.
Correct.
All right. Thank you for explaining that. If you'll turn to tab 13. A one-sentence email from you to Councilmember Boone, Ms. Embry, Mayor Dickens, I think Ms. Hickson was at the time the county attorney, Mr. Flournoy, and Attorney Williams. You write, you will hear from the attorney regarding this false eviction letter. Who is the attorney?
So at the time, we didn't have one, but I just said specifically without naming an attorney because I knew that we would have one eventually. You'll hear from the attorney. Because at this time, we've already ceased the relationship with Attorney Burroughs, and we're looking for good counsel. So without naming anyone specifically, I cite that you will hear from the attorney. So I don't name anyone specifically because we haven't.
You did not. And so the question was, who is the attorney? And you're saying right now it's no one.
Right now, there was no one.
Okay. And so I'm understanding at this point, you had not communicated to Ms. Embry, Mr. Flournoy, or Attorney Williams that the previous attorney was no longer the attorney. What you've done is told the previous attorney, you're not my lawyer anymore, but you have not told Attorney Williams or Ms. Embry or Mr. Flournoy, he's not my lawyer anymore.
That is correct.
Okay. Excellent. Thank you. Mr. Sterling, any follow-up for Mr. Wesley?
Just briefly, Mr. Wesley, were there rain events that occurred in the space in 2020 and 2021? Were there rain events that occurred outside the space?
Rain event?
Yeah, were there?
Absolutely. There's rain throughout the course of 2021, rain throughout the course of 2020.
And at that time, was there ever any flooding in the building when it would rain?
No.
When did the flooding first begin, and why did you notice that flooding beginning?
When Miss Embry started working on her water line, and at the time that it started raining in late February to early March, we would get the moisture back into the space. At first, it wasn't a huge deal. It was noticeable, but it wasn't a huge deal. It got progressively worse in the beginning of March when there was consecutive heavy rainfall. Incessant, and they were still digging each day. So they're still working on the water line each day. But as it's raining, it's getting progressively worse in both spaces.
Nothing further, Judge.
Mr. Williams, any questions for Mr. Wesley based on the questions I asked?
No, Your
All
Honor.
right. Ladies and gentlemen, we're going to break for the day. Thank you for the extra 12 minutes. We actually didn't start right away because a couple of you got stuck somewhere. Mr. Sterling believes that he'll be wrapping up mid-morning. That's his best estimate. And he'll go as promptly as he should. Mr. Williams thinks that if he presents evidence, it'll only add a couple hours to that. So we're still pretty much on schedule. I'm going to review the law that I'll be giving you tonight, and I'll talk about it with the lawyers. I was going to say during their lunch break, but I have some criminal matters during their lunch break. But that's the one piece we still need to work through. So I need to wrestle with that some. But we still will be getting the case to you tomorrow. It'll just be in the afternoon. It won't be before lunch. Tonight, have a wonderful evening. Don't talk about this case. Don't go home and say, I got to tell you what's going on. Be boring about the case. Be exciting about everything else in your life, but just don't engage folks. Just say, I'm having a good time, but I can't talk about it yet. No outside research. You've done a great job with the 18 submissions, many more than 18 questions. That's how you get your questions answered, if they are questions that ought to be answered. If you wrote a question and it didn't get posed, don't go look it up. It just meant that for whatever reason, it wasn't a legally permissible question. I appreciate your time and attention, as do the lawyers. Any logistical questions? Yes, ma'am. Yes, please take your pads into the jury room. It'll be locked. No one's going to go in there and look at that. And then you'll just collect them in the morning. And again, we can't start until everyone is here. So everyone try to be here as close to 9 as you can. If you're running late for whatever reason, call that number I gave you yesterday. You can write it down again or just memorize it. 404-612-6907. That's my chambers. And they'll say, Juror X is doing her best to get here. There was a wreck on I-20. And then we'll all breathe a sigh of relief that you're okay and you're doing your best to get here. It's if when we don't hear from you that he gets to call his friends with the squad cars and the battering rams and they wake you up and it's awkward. You show up in your pajamas. You don't want to have to do that. And
Part of the problem this morning is like the line was wrapped around side of the building.
that's on actually it's on him because of that, the only one magnetometer. So don't, that's why all I did is say, if you can get here earlier, super. If you get here in plenty of time to have gotten in the building, if that machine wasn't broken, we eat that. Marta broke. So you got a long list of excuses. This is one of those jurors. Here we go. Yeah, and then my shoe blew out. Okay. We'll do what we can, but do call. If you get stuck somewhere, we can arrange extraction. Okay? Good. All right, prayers that Marta follows through. Anything else? Thank you, folks, for staying a little bit late.
You're happier today, that's a good thing. Yeah.
You get sleepy.
You all can be seated. I want to talk real briefly and I'll let you go as well, just so I'm going to work on the jury charge tonight. Do you want this taken down? If we take, okay, then stick with us, please. Are there any, you're about to rest. You're gonna have one more witness, and he or she's gonna add whatever to the mix. Are there any of your counts based on what the evidence has shown so far that you intend to withdraw? So I don't need to worry about how does conversion fit in the mix or negligence per se, theft by taking. Those may be perfect charges. I just don't want to spin my wheels on coming up with the right legal language. If you already know, hey, I filed this complaint, I wanted to cover the waterfront, but look, this is what I want the jury to wrestle with.
Yeah, Joe, I do anticipate that, Your Honor. Does the court need to know now?
Well, what I'm going to be doing tonight is working on the jury charge. Ms. Niles, if you want to get an email to me and Mr. Williams, not right now, but before 8 o'clock, saying, you know what, we're going to not go forward on those kinds of counts. I will wait until 8 o'clock.
I'll do that here.
Okay. And Mr. Williams, same for you. I know you're not going forward with punitive damages.
Yes, Your Honor, jury charges that we submitted, that's the last one, number 9.
I don't worry where they are.
I think that's the only one that we submitted that we can strike.
Okay, well, I'm gonna need to, maybe still include language about punitive damages because that's something that Mr. Sterling prayed for in, prayer J, not J, I. That your concession
He can use mine.
may not streamline anything. But it will help me, Mr. Sterling, if you are able to right size it a little bit. And I'm not saying you have to. You may say, Judge, every one of these is sticking. But as Ms. Niles and I were reviewing it, it was very thorough and it went at things from different angles that I thought, hey, you may strategically withdraw some of those so that the jury's, you know what, just none of these works because we can't figure them out.
You know, I anticipate doing that. Your Honor, I want to have an opportunity to look at it and talk to my client.
All right. Do you have my email address?
I believe so, Judge. If not, I'll take it down now.
It's not, it's just like Monica.Niles, but it would be Robert.McBurney. And then you know how it ends on the back end. So Robert.McBurney and then the rest of the stuff. I will look for that. That will help me focus and hopefully then I can have a draft jury charge to you all that you'll have in your back pocket and that will streamline our charge conference.
I may have, Judge, I may submit with that as well, a few additional potential jury instructions. I don't know if you want me to formally amend my requested charges or just submit it to the court and copy Mr. Williams.
The latter is fine. That's very informal. I just need to get them. Copy Ms. Niles on anything you send me. But you have her email address because she's the one who's been emailing all of you. So copy her on it, but I will look at your additional proposals and weave them in as I see fit. Anything else from plaintiffs?
No, Your Honor.
Okay, Mr. Williams?
Your Honor, very briefly, I think one of the things that you've probably seen throughout this trial and that you will wrestle with, or that we ask you to wrestle with this afternoon and this evening, is the difference between a residential lease and a commercial lease. We submitted non-pattern jury instructions based on commercial leases, pulled from the law, pulled from Georgia jurisprudence. There are some pattern suggested by Mr. Sterling, number 36, those that we think are not applicable because those are residential leases and residential situations. We think the commercial law is different.
Okay, that is something that Ms. Niles flagged and I know we'll need to wrestle with. I certainly don't want to under-instruct the jury, but I don't want to over-instruct them either. And it is plain to me, just to manage expectations, that the world is different for commercial leases than residential leases. And that will inform the way I instruct the jury. If there are principles of law that apply only to residential leases, I'm not going to talk to the jury about that. In fact, I may need to say, that's not how it works if there's confusion about it, but really that's not my role. My role is to say, here's how it works. And then you all ought not to argue contrary to that in your closings. So I will look for that email no later than 8 p.m. because by then my kids will be where they need to be doing what they need to do. And I can focus on an exciting evening of reviewing a jury charge. All right. Thank you, everyone.
Thank you, Your Honor. And we can still leave some notebooks.
Please, yeah, you're good. At noon tomorrow, some criminal attorneys will come in. And so you'll just need to consolidate a little bit, but not totally relocate.
Thank you, Your Honor.
You bet.
Thank you. Need anything from me? Have a great evening.
I don't think so. We're gonna, we got Bobby, we got the checks. You've got copies of the checks, so we'll probably get copies of that, copies of.
So are you coming back tomorrow?
That'll help.
I have no idea. Some of these places like, hey, it's a different person, but it's just you. It's your company. Look at that. Okay, then you don't have a choice. Yeah, better for you.
At least we'll get an offer.
With these, did you see?
I did.
Why don't you just keep those?
Okay.
Hope it's
Yeah.
full.
With the ledger.
It's like penny